What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God!
Before the
Don't get brazen with me.
Hey, good morning, good afternoon, good evening. How is everybody doing? It's me, Legal Vices, still shutting myself down from the stream that I just finished on my regular Maritime Monday. How are we all doing? Welcome, welcome, welcome. Trial today. It looks like we may have final arguments today, the closing arguments, jury instructions, and the jury may get this case. So we may be in business for a jury today. Andrew Branca will not be joining us today because he is on the road doing some personal things. But Nicholas Starov, union rep labor law guy, has said that he would be happy to join me. So I am preparing to send him a tweet to invite him on over. But how are you guys doing? That's the question. How's everybody doing today? Hope you had a great weekend. The parts of the weekend I can remember were really good, except for Sunday because of everything I did on Saturday. It made Sunday not so great. Then I had a really crappy day at work today. I mean, it was a crap fest from before I woke up this morning until I started my Maritime Monday stream an hour ago. The Vice Squad chat, you guys made it perfect. You guys always lift my spirits and you raise me up. And so that you guys lifted my spirits and I'm here and I'm ready for murder trial. While we get things squared away here, bear with me. There is still nothing going on here with the court cam. Court cam is still here. Where are you at, court cam? Oh, I guess I should bring it up so you guys can make sure that I'm paying attention. Share screen. Sex worker shooting retrial. There we go. That's what we're looking at, but we'll in small. Oh, well, that helps. That's new. Hey, how about some proportion over here, guys? Hello. And that's the exact opposite of what I wanted to do. Let's try this. There we go. You are the wind beneath my wings. Thank you, Kitty. All right, so I'm trying to send a tweet here. Just wanted to let you see what I'm seeing, so you know that I'm just not stalling for time. I'm just stalling for Twitter time right now. Nicholas Starov, union rep labor law, please stand by. Here you go with the link. I hope that's the right link because that's the link I'm sending you. Just in case, I'll send it again. All right. Nicholas should be joining us here in a minute, keeping me company for a little while. Oh. Silent PS says, I understand crap week. I've got a new coworker who can't seem to keep her ass out of jail. Well, that's a problem. John Gordon, we don't want to see your face. Well, I'm sorry. You got to see it anyway. All right. Thankfully, you introduced it to Nicholas because he introduced it to MLS show, LawTube Expand. MLS does some cool stuff. Funny, Nicholas. Get in here. Nick says, why am I looking at an adult diaper site? Get in here. All right. Make sure, yeah. Okay, the video is still playing. I just want to make sure I didn't pause it because that's kind of how I roll. There, I like this. I like this setup. This is the way we're going to keep it. This is the way God meant it to be. You small person, Nicholas. Now, hey, Nicholas, what's up?
Yeah, it's Monday. I'm doing good, and yeah, I spent from 2 a.m. to 7 a.m. talking to Steve Gosney. First 3.5 hours on his stream, and then an additional hour and a half, something like that, after stream, just talking away. That was, he's an amazing guy.
Yeah, I wanted to join, but that's always like right when I start work. And like I said, it was just a shit day today. It was a really, really bad day. So that would have just made it worse. Legal Vice's new show idea in the vein of Judge Judy, but on bumper boats. Okay. That was an OG Maritime Monday. Yeah, we showed some ship collisions. Well, that's kind of fun. Said nothing like carnage to get the spirits up and the blood flowing. I think it must be part of our shared common ancestry. That's why you look at ski jumping and drag racing, because sometimes things go wrong. Yeah, that's the only reason you go to hockey games, to watch fights. You watch NASCAR for crashes. You watch F1 for like the first 2 turns, and then you go, all right, there's going to be no more accidents. Unless you watch the F1 Australian Grand Prix. That was a wild race a couple of weeks ago. Anyway, here we are. We are on. Have you followed any of this? Have you been surreptitiously watching me?
Any of this trial? Yeah, I tuned in once in a while to watch it, and in the beginning I thought, screw this cop, he's guilty as sin, send him to prison for the rest of his life. And then the prosecution got their case up, and since then they changed my mind, which was interesting. I don't think that was the goal.
Well, now wait, do you think he's innocent? Because innocent and not guilty are much different animals. Yeah. I'm thinking my gut is still telling me he's probably guilty, but the prosecution hasn't proven it, and those are the cases that make me more angry than anything. When you know and I don't know the guy did it, but in the cases which is clear the guy did it, but the prosecution just can't prove it. I hate that.
Yeah, and I'm leaning towards not guilty. Innocent, not so much, because I still stand by with what I saw in the beginning. If you have to fire 6 shots, first is self-defense, second is a maybe. If you need an additional 4 shots, but then, as you said in the stream, which one of these were the 3 that hit?
Yeah, it could have been the last 3. We just don't know, and that's where I fault the prosecution. The prosecution put nobody on, no ballistic experts, and they stipulated to some stuff the medical examiner was going to say, but they didn't show which of these shots were likely fired first, which bullet, which of these rounds hit her likely first, which one of the ones that hit her were the ones that maybe they couldn't do it. I don't know, but that's a huge part of the case, showing, at what point did that threat end?
Yeah, because the defense brought up that she had her leg against the back of the car seat, and that's how the shot got through her calf and into her thigh. While the prosecution could at least have argued that that was when she was curled up.
Yeah, I mean, there was none of that, and it's a failure of the prosecution. Because my gut's telling me that he did it out of, I don't know, murder, I don't know, but voluntary manslaughter, I could probably see that. But the prosecution didn't prove that he acted unreasonably. I thought he met the burden of proof for proving self-defense, but the state did nothing to overcome that.
Yeah, but then again, now you have the jury, and if this was the same case they brought up the first time and they were hung, what's going to happen now?
Well, see, that's the thing about these retrials. They've had a year to make better arguments and to find more evidence and to do more things. And if this is a year extra preparation, I don't want to know how bad it was the first time around, and it was still so bad that it was a hung jury.
Yeah. Yeah, this will be interesting to hear closing arguments, because if the prosecution doesn't make a killer closing, yeah, because I remember from the Zachariah Anderson so to speak. I remember from the Zachariah Anderson case, although I hate the prosecution's closing, it was effective.
Mm-hmm. Right.
Yeah. Oh,
I mean, it was terrible, but effective.
Yeah. DUI guy is having an interview with Solomon on Wednesday.
That is correct.
Yeah. And so the story continues. And to the prosecution's big disappointment, we won't shut up about it.
Carla, whatever.
Well, let's see if we got the microphones figured out today.
19 CR 1662. State of Ohio versus Andrew Mitchell. Do we need to put anything on the record prior to bringing in the jury?
I got you. I don't think anything substantive procedurally, Your Honor. Once the jury's seated, we were going to do a...
Wow, they're in both ears today. The last day of trial, they figured it out.
Yay.
All right, bring in the Jew roars. Nicola Maxwell, are you here? I haven't seen you for ages. Live.
So good weekend, Carla. Hope your husband's birthday. Good. What's that? I know. Now it's terrible. My wife got home, so.
Oh, we can hear about his wife and his day, how his day's going.
No longer a bachelor.
How is this stream already limited monetization? All right, it's time to. We'll do a live appeal of this.
They read my mug.
Probably. It's probably your fault.
Yeah. Sorry.
Marv White, thank you so much for your super thanks the other day. We mentioned, did Legal Vice's dream of being a radio disc jockey when he was a kid? His delivery seems to mimic the pros of the late 70s and 80s. Fun fact, I was a radio DJ from 1986 to 1991 at a top 40, a heavy metal, and an oldies station in northern Utah. That's my history. 94.5 KVFM, 61 KVNU, and Z104 FM were the stations I worked at in northern Utah. So, you guessed it. That's why you got to do the crazy old radio voice sometimes. We just call them pukers because it sounds like they're puking all the time. News and weather on the 9s.
Oh, please say you didn't do the weather.
I used to have to do the farm report every morning. That was great.
Friday, I left without even telling you guys what time to come back, and here you're up all on time. Everyone have a good weekend?
We would have got along back then when I was telling you what the price of a bushel of wheat is this morning as opposed to yesterday.
Yes, Your Honor. First, logistically, Your Honor.
Yeah, I missed those radio shows.
To the ladies on the jury, as well as a playing of an audio tape.
Thank you, Mason.
This is stipulation of the parties. State of Ohio versus Andrew Mitchell, 19 CR 1662. Joint exhibit number 7. The parties stipulate as follows. If called to testify, Laura Thomas would testify that on August 23rd, 2018, she worked for the Columbus Police Department in the dispatch department. She would testify that she collected the 911 call that had arisen out of this incident and provided it to Detective Shepard. If called, she would testify that this is a fair and accurate copy of the 911 call as it occurred on August 23, 2018. The 911 call is marked as a joint exhibit number 7.
Ooh, do we get to hear the 911 call? That'd be pretty cool.
Okay.
I need a police officer in an ambulance at 355 South Hill. You have a police officer down bleeding in the back. You said a police? Yeah, you have a police officer down in the back bleeding. He's being nice. She's on Bella Hill. Do you want me to get a shirt so I can wrap your hand up? Give him up for over there. Hey, go get me another shirt. What happened, Bobby? I don't know, but I'm taking my shirt off and I'm wrapping this evening, so the picture is, Here's the picture, Donna, and, get you over to our paramedics so they can tell you what to do, okay? He's cut pretty bad, man. His hand is wide open. Okay, we're gonna get you over to our paramedics so they can tell you what to do to stop the bleeding. Hold on. Yeah.
Thank you, Your Honor. And with that, our next witness.
His
we will
hand
call
is
Kevin
open.
Davis to the stand.
Okay.
That was a really bad audio. During the break, we'll have to see if we can find some clearer audio of what that 911 call. Robin says closed captions. The closed captions are on. They're just not on. They're on for me. They're all on and underlined. They're just not showing up for whatever reason. They might show up later.
No.
And Marv White says, bah, ha, 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 ha. I think he's calling to Valhalla's sheep.
Watch for the wires. So
You were right about the radio. And Bella Stella, let's start the doggo cam. This is about $50. Wow, thank you so much for that. That is seriously generous of you. And in fact, that's closer to $60.
Your testimony in this case would be the truth, the whole truth, nothing but the truth. I do.
Who's that?
Have a seat. Pull yourself up close to the microphone. And you may inquire.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please state your name and spell your last for the record?
Kevin R. Davis, Davis.
Could you please tell the ladies and gentlemen of the jury a little bit about yourself?
No.
I'm a retired law enforcement officer. In April of 2021, I retired from the Akron Police Department after 31 years. Prior to my service with Akron PD, I worked for
This guy's voice sounds really familiar to me. I'm trying to think of who he sounds like.
A total of over 39 years of law enforcement experience.
I can't think of who it is.
I worked a variety of different assignments from patrol through the training division and ended my career in the body-worn camera unit of the Akron Police Department as a detective.
You said you're retired?
I did.
How are you enjoying retirement?
I'm busier now than I was when I was working.
Are you married, sir?
I am.
How long?
24 years.
Any children?
Yes, 3.
How many? Oh, any grandchildren?
I have, let's see, 4.
Congratulations. I want to talk to you about when you mentioned that you were an Akron police officer. Can you give the jury a synopsis of the positions that you held while you were a law enforcement officer with Akron PD?
Certainly. I started out as all new hires do in the patrol division. I worked platoon 4, which is 7:30 at night until 3:30 in the morning. I worked that assignment in some of the busiest districts in Akron for a number of years. And then in approximately 1993, a new unit was formed within the Akron Police Department called the Street Narcotics Uniform Detail, or SNUD unit. I worked that unit for about 6.5 years, a variety of different assignments, both in uniform, responding to mostly street level narcotics trafficking and street crimes in Akron, and also as a plainclothes detective, where I, among other things, did surveillance and made hand-to-hand buys of rock crack cocaine primarily. After that assignment, but at the same time with my work with the SNUD unit, I began working for the Akron.
That's really the best you can come up with. SNUD.
I was an operator and eventually became a team leader.
I worked for SNUD.
And I also began working collateral duties in the Akron
Street
Police
Narcotics Unit Donut Division.
After the SNUD unit, after I left that unit, I went into the training bureau full time for about 19 years. I was the lead defensive tactics instructor, a firearms instructor, as well as the lead use of force instructor.
You've provided us a copy with your curriculum vitae to detail your experiences and qualifications. Is that
curriculum
correct?
vitae? You mean resume?
May I approach the witness, Your Honor?
Shut the fuck up, Donnie.
Mr. Davis, I'm handing you what has been marked for identification purposes as Defendant's Exhibit 24. Can you take a look at that document?
Yes.
What is that document, sir?
This is appears to be an accurate copy of my curriculum vitae or CV, also a resume based on my law enforcement experience and my work as a trial consultant and expert witness.
I kind of want to just work through some of those topics listed in your CV, Mr. Davis. When you mentioned that you were with Akron PD, you mentioned that you were involved in the training bureau, correct?
That is correct.
And in what capacity were you involved in the training bureau?
I was a full-time instructor. My job was to teach basic academy cadets, the new hires within the city of Akron, and also in-service officers, officers that had been working already, veteran officers that came in, rotated through with either firearms training or in-class, in-service training.
Would you do that both in an individual setting as well as a group setting?
I would mostly do individual training on the firearms for remedial shooters, and when we would remediate or bring back officers on the firearms range, primarily it was classroom and hands-on training.
Did you ever train at the Basic Academy?
Yes, I've trained at not only the City of Akron Basic Academy, but the University of Akron Basic Academy and Kent State Basic Academy.
Describe for the ladies and gentlemen.
You know what that was? That's a boomer moment right there.
We noticed.
It's set forth by the Ohio Peace Officers Training Commission, or OPOTC. The curriculum dictates a variety of different, they call it unit topics, everything from constitutional law through first aid, suspect control, baton, firearms training, room clearing, a variety of different topics. All of that curriculum is set forth by the state. However, at the City of Akron, we always exceeded that, gave more hours than the state minimums.
Can you tell the ladies and gentlemen of the jury what's the importance of training? Why is there so much?
Why is there so much? I know the answer to that question.
Well, I would argue that we need more. And in that regard,
is there a
it is
time
course?
Because you missed
when I went
that
through,
one.
it was only 320 some hours, and now it's over 600 hours. And we're striving to have more training, always striving to have more training. But the reality is that officers do on the street or do in actual incidents what they have been trained to do. And so training is so vitally important, not only to learn the constitutional limits of their use of force, for instance, but also the practical application of use of force.
When you talk about that practical application, how are the trainees trained on the practical application? What types of things do they do in order to be trained practically while they're out in the field?
Well,
practically nothing.
We start out with the basics, for instance, of suspect control, how to frisk somebody, how to put handcuffs on somebody, how to control someone when they resist. Everything from that through dealing with people that have weapons, be it knives or guns, what have you. Then we advance through the static training into practical applications or dynamic.
What's static training? Is that where you shuffle around the house in socks and touch doorknobs?
Fist suits, and the subjects, the students have to work with a role player in the padded suit to try to control them, etc.
So do you walk through scenarios? Do you give the trainees scenarios and then they have to play out that scenario during that role play type incident?
That's correct. This part of this is what we call inoculation training. So much of law enforcement is dealing with the physiological, psychological, and physical aspects of dealing in a violent confrontation. And they have to work through that, get used to it. In other words, become inoculated to it.
Have you trained supervisors before, Mr. Davis?
Yes, in both hands-on training as well as use of force instructions.
Hands-on training is what got this officer in trouble in the first
place. Why is
place.
it important, tell the ladies and gentlemen, to train supervisors?
Well, those are your frontline management that respond to the scene, be it an officer calling for assistance in terms of information or knowledge about what they should do a certain call, everything to that through a use of force investigation after an officer has pepper sprayed somebody, for instance, or there's been some type of resisting. The frontline supervisor comes out, conducts an interviews, oftentimes takes photographs, et cetera, and then comes to a conclusion on whether the use of force was within policy and within the law.
You mentioned you trained with firearms as well. Did you also train trainers with respect to, did you also train supervisors with respect to firearms?
Yes, they were
supervisors.
Sometimes were
had
their own class or their own training program, but most of the time they were within the group of officers that were at the range at the same time. So yes.
Have you presented at conferences regarding the topics of use and force with regards to whether a decision to use force was reasonable?
Yes, I have done quite a few conferences for the American Society of Law Enforcement Trainers, or ASLET. That organization is no longer in existence. I have trained at the conferences for ILETA, the International Law Enforcement Educators and Trainers Association Conference. CIPHER, which is a defunct organization, which was the Society for the Investigation of Force and Reporting, and as well as Ohio Tactical Officers Association and others.
Have you presented here in the state of Ohio with regards to use of force?
Oh yes, I was an adjunct instructor for OPATA, which is the Ohio Peace Officers Training Academy in Ridgefield, Ohio, in the northern part of the state. That type of training, I did everything from pistol work, submachine gun training, shotgun training, all the way through use of force investigations.
What about other parts of the country?
Yes, I have trained throughout the country at conferences and for agencies.
You mentioned you were more busy now than you were back when you were a police officer during your law enforcement tenure. Is that because you own a consulting firm now?
Yes.
And when did you start consulting?
I actually have been working as a trainer and a consultant for probably 20 or more years. Previously, I had done more tactical training, i.e. firearms training, SWAT team training, use of force practical application. But as you get older, you start looking at more consulting and doing other things than physical stuff. So I had, and now I focus on use of force consulting as well as expert witness work.
You mentioned you were training, you've trained people on defensive tactics. Have you also trained people, officers, supervisors on non-defensive tactics?
Oh yes, everything from firearms to the legal application of use of force.
Have you authored any articles regarding use of force?
Oh yes, I was quite busy writing for all of the law enforcement periodicals, Law and Order magazine, Tactical Response magazine,
Doggo Cam. Also hit the like button,
magazine,
y'all.
Law Officer
Thanks so
magazine.
much.
Unfortunately, a lot
Appreciate
of those periodicals are now out of business, but I did write extensively for those venues for a number of years.
Are you associated with any professional affiliations or organizations with respect to law enforcement officers and or use of force?
Yes, I'm still a member of ILETA, the International Law Enforcement Educators and Trainers Association, as well as the Association of Force Investigators.
Have you testified before Mr. Davis as an expert on the use of force here in the state of Ohio?
Yes.
Municipal court?
Correct.
Common pleas court?
Yes.
How about federal court?
Yes.
And when you testified in each of those places, have you been declared an expert before?
I have.
Have you testified in other states, whether it be federally or locally?
Yes.
What are some other jurisdictions that you have testified in?
I've testified in the 10th Circuit federal court in Denver, Colorado, and I've been involved in other cases from Pennsylvania, Florida, Lincoln, Nebraska. I was in Spotsylvania, Virginia, Bristol, Virginia last year, so throughout the country.
Quite a few. I want to talk to you, Mr. Davis, about your work case process. How is it that you determine whether or not to take a case during your consulting business?
Well, I don't solicit work. All of my work
that
comes
your
from
dog
word of
snoring?
mouth. So
Yeah.
I usually get an email.
You're snoring.
Primarily emails from attorneys asking if I'm interested in working on a case. that is usually followed up by a phone call in which I ask for all of the discovery material that is available to them. Now that is a trickle effect. In other words, I get what I can to begin with, but then I go through the evidence as it develops or is presented to me, and first of all, give an oral opinion to the attorney whether I believe the case is something that I could help with, or is that I believe is part of my expertise, and then that's followed up with a retainer, etc.
Have you reviewed use of force cases and decided not to take them depending on what side the perspective is from?
Yes.
Why so?
Usually because I don't find that the facts are conducive when we're talking about law enforcement use of force, that the law enforcement use of force was not within the law.
Have you examined use of force cases and found use of forces to be unreasonable before?
Yes.
So just because you work on a case, Mr. Davis, doesn't necessarily mean you've formulated an opinion or at that point in time, right?
No, it's when I start working on a case, you go through it, try to formulate the opinion as best you can in the original stages, but then as the situation develops, that may change. But that opinion is based on the facts and evidence and not on any preformed conclusion or any desire by the attorneys to have their client vindicated.
You mentioned you charge a retainer fee. What is that retainer fee, sir?
$3,500.
Is that industry standard?
I don't know. I think it's cheap from what I understand.
Does that retainer fee come with an opinion attached?
Absolutely not.
Have you worked cases and testified in cases on behalf of law enforcement officers?
Yes.
Have you worked on cases, whether that be administratively, civilly, or criminally, with regards to actions when you were testifying against the officers on a use of force situation?
Yes.
And in our process, when did Mr. Collins and I first reach out to you?
I believe that was in May of 2019 now.
You didn't have the material at first, did you?
No, very little material.
You followed that same exact process whereby we retained you as you had done in normal cases. Am I correct?
That's correct.
When we asked you about the situation first, did you eventually ask us to provide you those materials?
Yes, what frequently happens is that as the case develops, more material is available in discovery, and it's forwarded to me. It can be on jump drives, on Dropbox, or just through emails.
And did you eventually receive all of that relevant information that you requested of us?
I don't know if I got everything in the case, but I got a lot of material, so I went through everything that I was presented with.
And did you eventually make us aware of your potential position?
I did, yes.
Did we ask you to prepare a report?
You did.
You charge a fee to testify here, sir.
I do, yes.
What is that fee?
$2,500.
Okay, so 6,000 total, if I read that correct.
Can I approach the witness, Your Honor?
You may. So basically, this guy is saying he follows rules because we need rules.
Am I the only one around here who gives a shit about the rules?
Purposes, as defendants
Rules, because we need rules.
Am
I'm the only one around here who gives a shit about the rules.
I should be an expert witness. I just need to be expert in something.
I'm an expert in not being an expert.
Ah,
does that count?
Can you testify to that, Mr.
Pretty much.
Devices? Can you, to a reasonable degree of scientific certainty, testify that you are not an expert?
So the thing is, he's an expert. I mean, he's been doing this for a long time, and he's making some good money as an expert. But at the end of the day, it just boils down to one thing.
Yeah, well, that's just like.
This is an accurate copy of my report.
I want to walk through your report, Mr. Davis. Before we get to your opinions, I want to talk about the authority behind your opinions. what is the authority that you used to make a decision with respect to a use of force case?
Well, first of all, this authority talks about the officer's authority. In this case, Detective Mitchell was a certified law enforcement officer in the state of Ohio and a commissioned member of the Columbus Division of Police. So he had authority within the city of Columbus to enforce all ordinances, state laws, etc.
Redirecting your attention to the lawful objective part of your report. Describe for the ladies and gentlemen of the jury what type of lawful objectives
Hang on
you're
just one
speaking
second.
about for taking action in that section.
This goes back to the fundamentals or the foundations for the use of force. In order for an officer to legally use force, they have to have lawful authority. That means that, or a lawful authority jurisdiction, and they have to have a lawful objective for taking action, meaning they have to be doing something based on the law. In this case, that was the investigation of prostitution and the probable cause that developed to arrest Miss Castleberry for soliciting. So that was the legal foundation or the lawful objective for Detective Mitchell taking action.
I want to talk about the Supreme Court cases you discuss in your report. What are the opinions on which you can derive an opinion, or I apologize, what are the cases that allow you to derive an opinion with respect to whether or not a use of force was reasonable with respect to the Supreme Court of the United States?
Well, there's a variety of different cases. There's Terry v. Ohio, which is about reasonable suspicion and detaining somebody based on reasonable suspicion to believe that a crime has been, is being, or about to be committed, and that person did it. From Terry, we also have what's called a Terry pat-down, or the frisk of outer garments for weapons based on reasonable suspicion. Terry v. Ohio. In terms of use of deadly force, we have Tennessee versus Garner, which is a 1984 case about the shooting of a fleeing subject, and the Supreme Court ruled on that. Prior to Garner, they had applied the 14th Amendment to use of force cases, but with the Garner decision, they said that use of force was a seizure. And because of that, the objective reasonableness test of the Fourth Amendment applied. From Garner, we then had Graham v. Connor, which was the first time that the Supreme Court applied the Fourth Amendment to the use of non-deadly force. And once again, they said that use of force was a seizure. Now, Graham v. Connor was a civil case. In many states, even to this day, there's conflict about whether Graham v. Connor applies. Well, in Ohio, we now have the White case. That's a 2009 case that was adjudicated in 2015. And what the White case did, State v. White, was apply Graham v. Connor, the standards of objective reasonableness, Garner, Graham v. Connor, to criminal cases in the state of Ohio. So that's State v. White.
So is State v. White the seminal case here in Ohio that experts used to determine whether uses of force were reasonable?
Yes.
I want to move on in your report and talk about the information that you received. You mentioned that you received discovery from us. What kind of information did you review in that discovery?
Everything from the investigative reports, photos of the scene, body-worn camera of the scene.
He's an expert witness.
BCI 3D laser scanning and ballistics reports, morgue photographs, the coroner's reports, and videotape analysis done by Agent Loomis from BCI, where he connected the audio and video, a variety of other reports, including Detective Mitchell's written report, his audio tape by the investigative detectives, and that's about it.
Have you gone to the impound lot to examine the car involved in this situation?
I did, yes.
Tell the ladies and gentlemen of the jury why it's important to go and examine that car.
Well, photographs only tell you so much, and you can only glean so much. Excuse me.
There is no excuse for you.
you can only glean so much from a photograph. So going to the impound lot and actually looking at the car, opening up the doors, I was struck by the fact of how tight it was in that passenger compartment. In other words, it's not a very large four-door sedan. So
4 doors more horse.
Better information. Excuse me, sinuses. About the movement patterns and the amount of room available in the car for the detective to operate, as well as Ms. Castleberry to move.
When you opened the car door and saw it, what was your initial opinion of seeing it compared to what it had looked like in the photos that you examined?
Yeah, I'm over 6 foot tall. There's no way that I would be able to sit in the back seat of that car as it was left in the impound lot. There was just no room.
Have you visited the scene of this incident?
I did, yes.
Tell the ladies and gentlemen of the jury why that's important.
Well, as part of my report, and I duplicate photos from Google Maps, they can only tell you some. Excuse me.
Do you need a break, sir?
No, it's
The
sorry.
prosecution's poisoned the water. He had tea with Putin this morning.
Those the locations on Google Maps. I mean, you can turn the view around and try to get a 3D idea, but it really was quite open. I was struck by how open that area was and how the neighbors and passersby could see where the car was at and subjects in the parking lot of the apartment building, etc.
Now, based on everything that you reviewed, going to see the scene, going to see the car, your training, your experience, your expertise, did you formulate, Mr. Davis, an opinion as to whether or not the use of force was reasonable as it relates to my client, Mr. Mitchell?
I did, yes.
And what is that opinion, sir?
That at the moment that Detective Mitchell used force, that it was within the clearly established law, within policy and procedure of the Columbus Division of Police, and within the standards of use of force in this country by law enforcement.
That's a very strong statement by an expert witness. It's better than the prosecution
I want
did
to
in
go
their
back in your
entire case.
report, Mr. Davis, to the authority and jurisdiction. You mentioned that you had a discussion in your report about the authority or lawful objective of a police officer in being allowed to use force. Is that correct?
That's correct.
And when you say lawful objection for taking action, do you mean physically touching someone, apprehending them, arresting them? Tell ladies and gentlemen of the jury what you mean by that.
Well, it could be everything from, for instance, law enforcement officers oftentimes have consensual contacts with citizens. They're working an area, they want to know what's going on. They see someone they don't know on their beat, be on a sidewalk, excuse me, etc. And they can approach that person and say, "Excuse me, can I talk to you?" And the person can agree and have a consensual contact with the officer, or the citizen can say no and keep walking. At that time, absent reasonable suspicion or probable cause, the officer can't detain the person. If they believe that a crime has been, is being, or about to be committed, that's reasonable suspicion. And they can approach the person and detain the person based on reasonable suspicion. Depending on the circumstances, as I said, that can evolve into what's called a Terry stop or Terry frisk, where they may, for their safety, pat down the person for their outer garments for weapons. If they have probable cause that a crime has been committed, that's based on the elements of crimes in the Ohio Revised Code, then they can detain the person and use force,
like
both reasonable suspicion and probable cause, to detain the person. In other words, the person is no longer free to go. In reasonable suspicion, they're not under arrest, but with probable cause, the person is placed under arrest. They're no longer free to go, and the officer may use force to detain that person, handcuff, search, etc.
What did you find in this situation as it relates to lawful objective for taking action?
That Detective Mitchell was on a vice detail, that he had observed Donna Castleberry. I believe he had reasonable suspicion based on her contact with the driver of a truck that he saw pull away. It was a high crime area known for prostitution. He could have, if had he been a uniformed officer, he could have approached and talked to her at that point, and she would have been detained. But working undercover as a vice detective, He then talked to her and developed probable cause based on the elements of the crime, which is soliciting, sex for hire. Once the elements of the crime were met, then he had probable cause to make an arrest.
So was he allowed to charge Donna Castleberry at that point that he had the elements for the offense of solicitation?
Oh, yes.
And at that point, Mr. Davis, once a citizen is under arrest, are they supposed to allow that arrest to happen?
Well, there's no lawful right for a citizen who's placed under arrest to resist arrest. There is no lawful right. And once Detective Mitchell had placed Ms. Castleberry under arrest, she did not have the right to resist.
And when you say once Detective Mitchell placed Donna Castleberry under arrest, what do you mean by that? That doesn't necessarily mean putting her in handcuffs, right?
No, in law enforcement, it's the magic words. You are under arrest. I'm a police officer. He identified himself, showed his police ID, and informed her that she was under arrest.
Is she allowed to say, "I don't believe you're a police officer, so you're not putting me under arrest"?
I don't know whether she's allowed to say. They say a lot of different things, but she's not allowed to resist arrest.
She's allowed to say it.
So is she allowed to be non-compliant?
No, she's not allowed to. In other words, resist being handcuffed, etc. She's not allowed to do that.
And at that point, Mr. Davis, what are Mr. Mitchell's obligations? Is he allowed to reach over and take her into custody by handcuffing her?
Yes, he is at that point in time. That would be his decision on whether he wanted to handcuff or not based on the circumstances. For officer safety, it's always advisable to handcuff people. In these situations, it's difficult because trying to handcuff somebody primarily behind their back in the passenger seat of a vehicle is not an easy thing to do, especially if they're resisting. But he is allowed.
But this was not an unlawful or illegal arrest.
Subject to control that person to reduce the threat against him and also to improve the safety of Ms. Castleberry.
Is there anything else, Mr. Davis, with regards to the lawful objective for taking action in this situation?
No, that everything is clear that he had the probable cause to make a lawful arrest for the crime of soliciting.
I want to direct your attention to police-involved tactics. Can you tell the ladies and gentlemen of the jury what kind of tactics, if any, are allowed in the analysis of use of force with respect to either Graham or Garner or Terry v. Ohio?
Well, tactics refer to what an officer does. Tactic can be, for instance, things like using cover, creating distance, de-escalation is a tactic. The problem with these things is they're subjective in nature and have nothing to do with the core transaction of the use of force. We don't judge, and the prosecution's expert, Uri Patrick, has said in his book that the actions of an officer prior to the use of deadly force are irrelevant. And the reason for that is because they're so subjective. Could he handcuff? Yes. Could he not handcuff? Yes. Could he get cover? Yes. Did it make the use of force bad if he didn't use cover? No. Could he have gotten or created distance? Possibly. Did it make the use of force bad because he didn't? The answer is no. So tactics are very subjective, but have nothing to do with the examination of the use of deadly force at that moment.
Are you aware, Mr. Davis, of any policies back in 2018 regarding whether an officer had to take a person to jail if they had warrants?
It's my understanding in Franklin County that it was policy or division, Columbus Division of Police, to take a person into custody if they had a warrant.
I'd like to move on to the next part of your report. I think you detail it circumstances. You claim that the circumstances are tense, uncertain, rapidly evolving. Why do you include this type of analysis in your report?
This comes directly from Graham. So what I try to do in my report is deal with many of the issues as outlined in the Graham decision and work from there. Not all of the circumstances were tense, uncertain, and rapidly evolving. We can hear on the audio tape that there was a conversation.
Legal Vices
Detective Mitchell. He was trying to He provided his ID, provided other paperwork to Ms. Castleberry to assuage her fears at that point. But at some point, when he makes the decision to handcuff her because of her behavior, then the circumstances change. And certainly the circumstances are tense, uncertain, and rapidly evolving once she cuts Detective Mitchell.
Who changed those circumstances, Mr. Davis?
Ms. Castleberry changed those.
You mentioned he went through various steps in order to try to calm Ms. Castleberry down. What would you classify that in terms of Mr. Mitchell's police action?
The big buzzword today is de-escalation. Although ultimately the use of deadly force is based on his reasonable perceptions at the moment that he fired, we look at totality of the circumstances and we find that he attempted over a period of time through calming dialogue, the showing of his police ID, the showing of other paperwork, to once again assuage her fears and to de-escalate the situation. Matter of fact, he said, hey, listen, I'm not going to handcuff you at some point, and that once again, an attempt to to de-escalate the situation in terms of use of force.
Is answering her questions a type of de-escalation?
Certainly, a dialogue is an important part of de-escalation.
When he tells her, I will not take you in as long as you don't have any warrants, is that a type of de-escalation?
Yeah, to once again reduce her fears. Ms. Castleberry was not new to law enforcement contact, and she knew that if she cooperated, and she knew the process.
Speaking of the process, Mr. Davis, when he tells her, I'm going to cuff you for both your safety and my safety, is that a normal process in terms of arrest that you have seen based on your training and experience?
Yeah, those words to that effect are used thousands of times and every day in law enforcement. Once again, telling the person, this is what I'm going to do, and this is why I'm going to do it.
What about resistance? Is resistance common?
I'd say vast majority of arrests have no resistance. There is a gradation in terms of resistance that we see. We see verbal noncompliance or verbal assaults. That's part of resistance. We also see resistance during the handcuffing procedure. That's pretty common in terms of resistance that occurs. In law enforcement, we try to train officers to be ready for resistance once the first handcuff is applied, because for whatever reason, the suspect realizes that, hey, I'm going to jail or I'm being arrested at that point, and they tend to pull away or resist the handcuffing procedure. So we have majority of incidents, even in this type of prostitutes arrested for soliciting, are completed without any type of resistance or without any type of use of force.
Who does the resisting, Mr. Davis, the officer or the suspect?
Well, the officer reacts and has to respond to the resistance displayed by the subject. So officers respond to what the suspect does. Suspect cooperates, then they're handcuffed, transported, paperwork is done, and they're either booked into the jail or released on a summons. If they resist arrest, it can escalate up to including deadly force.
Once there is resistance, Mr. Davis, who is the aggressor at that point?
Well, the officer isn't the aggressor. The officer's job is to control. And the suspect resists arrest and is the aggressor. And certainly in this case, Ms. Castleberry was the aggressor. She cut and seriously wounded the detective at the beginning stages of the encounter with a knife that he didn't even know she had in her hand.
Once she brings that knife into the equation, Mr. Davis, how did you view that with respect to your analysis?
That's a deadly force situation. Certainly, even standing on the street is a dangerous situation. And once again, the prosecution's expert, Mr. Patrick, talks about in his book and previous testimony the lethality of a knife. So standing out in the open is a dangerous situation when you're confronted with somebody that's cutting or attempting to cut you with a knife in the close confines of a vehicle where you can't maneuver as you normally would. You can't get a base, for instance, stand up and be able to develop power, etc. A very, very dangerous situation.
Who created that deadly situation?
Miss Castleberry.
Why so?
Because she chose to resist a lawful arrest. That's number one. She had no lawful right to do that. Number two, she chose to access, open, and cut Detective Mitchell with an edged weapon. She chose to place her back up against the dashboard and shove her foot against his throat to the point where he was almost rendered unconscious. And then she chose to continue to resist and to not comply with his with the instructions or with the situation, to submit to lawful arrest.
When someone decides to use a weapon against a police officer here in the state of Ohio, is that a crime?
It is.
Yes.
Tell the ladies and gentlemen of the jury what kind of crime that is.
One that gets you shot.
Normally in this situation would be felonious assault.
Now, after you're on the receiving end of a felonious assault, what does training dictate to do in this type of situation?
First of all, survive, to be able to keep from being seriously wounded or killed during the encounter. That's number one. And number two is to try to control the subject, to stop the person from continuing to assault you.
When you're close to that knife and somebody has already cut you, what did training dictate that Officer Mitchell do in that situation?
Well, this situation is an anomaly in that when we train law enforcement officers in firearms, for instance, we do so at the range. It's a flat range. Most of the time, it's well lit. The target's in front of us at a known distance. It may turn, or a tone may go off to indicate when to fire. But there's not any training that's required in the state of Ohio on how a detective should confront a female offender who has a knife, who is seriously wounded, and be able to maneuver, be able to shoot, be able to stop the threat in a vehicle. There's just no training like that.
Was Mr. Mitchell's actions of trying to grab the knife, was that reasonable in this situation?
Grab the knife or grab the hands, yes, to attempt to keep from being cut, yes.
I want to talk to you about using a knife, Mr. Davis. What type of skill does it take a person to use a knife against a police officer?
It's a weird
Unfortunately,
question.
in my career on the street and SWAT, I've seen countless numbers of stabbings, slashings. And
I mean, if you're going to get like in a Steven Seagal 1980s knife fight, maybe
no
different.
skill whatsoever. It's one of our basic tools as human beings that we develop, but also one of the basic weapons that we've been facing or have been used against us. It takes no power, no technique, no training, whatever. All you have to do is take the sharpened point of whatever edge weapon it is, shove it into your victim, or take the edge of the blade and slice or cut the victim, or to chop or hack or whatever. So it takes no skill, takes no power. I've seen small juveniles commit felonious assault, serious wounds with edge weapons. Somebody that was smaller in stature than Miss Castleberry.
And so I think you mentioned Miss Castleberry's size in your report, that she was 5'4" and 115 pounds thereabouts. Why did you mention that in regards to her use of the knife?
Well, once again, that's how tall she was and how much she weighed. So if it does need to be considered, but when you're talking about a deadly weapon, for instance, a gun or a knife, that's the great equalizer. I mean, the old notion about guns is that God made men, but Sam Colt made them equal, meaning that guns are an equalizer. With edge weapons also, it doesn't regard. I've seen very, very small people totally eviscerate victims with edge weapons. In other words, basically fillet their abdomen open. So it takes no power, no strength, no skill, and her size and weight did not factor in at that point.
What does the law say, Mr. Davis, about perspective in this situation? Whose perspective are you supposed to be viewing this from?
From the perspective of Detective Mitchell. The
Mhm.
question is at the moment he used force, would a reasonably prudent and well-trained officer in those exact same circumstances have used that amount of force?
I want to switch gears and talk about the shots that are discussed as part of your report.
Oh,
You discuss a
please.
concept called ambulation. Tell the jury what being ambulatory means in reference to the shots here that you analyzed.
Well, I specifically used the term ambulation after death or ambulation after a serious wound, pardon me. Mr. Patrick, the prosecution's expert, uses this extensively in his book and talks about the same concept. The reality is that a subject can receive a mortal wound, a non-survivable wound, and still stay in a fight or still stay the aggressor attacking 10 to 15 seconds. And Mr. Patrick even says up to 5 minutes. There's very many variables there, but that concept is that you can shoot somebody, literally take the heart out with a gunshot wound or stab into the heart, etc., and that person can still stay up, mobile, and a deadly threat until they finally drop from loss of blood pressure, etc.
Do we know what shot here, Mr. Davis, was the mortal wound?
Well, the torso shot, which hit Miss Castleberry's heart, was the mortal wound.
Do we know if that shot occurred in shot number 1 through number 6?
No, that has never been determined.
That is the prosecution's
Typically,
problem.
when officers are trained to fire a weapon, are they trained to fire at the weapon or the hand that's holding the weapon?
We're lucky if they hit the center torso of a subject. Surprisingly, and contrary to what you see in TV and movies, gunfire by officers is not that accurate.
That's not a good thing to say. That's not a ringing endorsement.
Hit their intended target. And that's even at close range. Majority of
Listen, people, police are crap at aiming, even from inside the car.
Is many,
they're just fucking Star Wars stormtroopers.
The officer may be moving.
They are lucky they don't shoot themselves.
Leading to what we call sympathetic nervous system reaction or fight or flight, which degrades performance under stress. All these things can factor in. But even in the most highly trained agencies, 50% of rounds that hit their intended target are pretty good.
What are they trained to aim for, Mr. Davis?
That would be center of mass, or the largest area of the target, the subject that is presented to them. So if they're frontally aligned to the person, it would be the center torso, primarily where the heart is and where the major organs lie. But if they're at their side or have a side target, it would be that area. It could be, depending on what the circumstances are.
That's why they shouldn't eat donuts. They should reduce their center mass.
They're trained to shoot the center of the mass of the target that they have available to them.
The rest of your report talks about a factor discussion. Are these the factors that we were talking about earlier, Graham and White?
I'm sorry, factors?
Yes.
The Graham factors are elucidated or mentioned by the Supreme Court Graham decision. That's usually severity of the crime at issue, whether the suspect poses an immediate threat to the officer or others, and whether the suspect is actively resisting arrest or attempting to evade arrest by flight. However, those are not, it's not what's called an exhaustive list. In other words, there's other variables that factor in under totality of the circumstances, excuse me. In the White decision, they talk about even more factors that can be considered, but once again, not an exhaustive list.
And did you base the rest of your report on the totality of circumstances as well as your decision here?
Yes.
And when you're examining the totality of circumstances, whose perspective are you to use in order to examine the totality of the circumstances?
Detective Mitchell's the actual officer that was involved.
So if I'm correct, you're supposed to put yourself in the shoes of Officer Mitchell and experience those things as they were occurring to him at that time?
That's correct.
And Mr. Davis, what did you find in regards to the totality of circumstances as you're standing in an officer's shoes, specifically Andrew Mitchell's shoes, at the time that he was experiencing the knife, the choking? What did you find with respect to the use of reasonableness?
I found that it was a chaotic, extremely violent, dynamic encounter within the close confines of a vehicle. It was a deadly situation. Had Detective Mitchell, for instance, his hand slipped from the arm holding Ms. Castleberry's wrist or arm that contained the knife, that he could have sustained a mortal wound. That at the time he made the decision, after he was almost rendered unconscious by her shoving her foot in the side of the neck, that when he made the decision to let go and move for his firearm, that was a serious circumstance that had it gone the other way, Detective Mitchell had possibly been killed or seriously wounded. And that the time that she moved into the back, that Detective Mitchell makes a statement or in his report talks about he was afraid that she was going to slit his throat from behind. He had to divert his attention to grab and access his duty pistol, and during that period of time, very susceptible to an attack by Miss Castleberry. When he comes back, once again, she's now moved past him or moving past him into the back seat. Very hard to accurately deliver gunfire to stop her. And she's moving chaotically in the back seat, making a very difficult target. So all these circumstances exist, and in that, I find that his actions were once again within clearly established law or reasonable based on the totality of the circumstances.
I want to break that statement down, Mr. Davis. Did you rely on the Graham factors and other factors in State v. White in order to come to that decision?
Yes, I considered them, used some, but not all of the White factors, for instance, apply.
I want to talk about the Graham factors. What is the first factor that you analyzed?
Severity of the crime at issue.
Tell ladies and gentlemen of the jury what you found with respect to the severity of the crime at issue from the incident on August 23rd, 2018.
Well, what we're talking about is the severity of the crime at issue, reference the seizure, reference the use of force. And at that point is when Detective Mitchell is cut. Up until that point, he's trying to handcuff Ms. Castleberry, is verbally defiant and apparently pulling away, takes the handcuffs, puts them outside the window, etc. All that is resistance, but we have a deadly threat. We have a deadly circumstances once she accesses her knife from wherever, opens it up and cuts him. Then that is a felonious assault. That's a deadly assault on a police officer. She's, first of all, not allowed to resist by pulling away. That's against the law. And it certainly escalates by her actions into felonious assault.
So what is the crime at issue here that you're to analyze, Mr. Davis?
Felonious assault, or the use of the knife and the assault of the detective. That's the circumstances that we're talking about in terms of the use of deadly force.
It's not soliciting?
No. I mean, a situation,
Oh, no.
And oftentimes this happens where law enforcement officers try to arrest misdemeanor subjects. Unbeknownst to them, that person is a wanted felon and armed with a gun. It could be something simple like jaywalking. You try to arrest a person or cite a person for jaywalking. Next thing the officer knows, the subject is pulling a gun and shooting at the officer. He's not dealing with a jaywalker. That's not the severity of the crime. The severity of the crime is the attempted murder or the felonious assault.
I'd like to discuss the second factor. What is the second factor that you based your conclusion on?
Bye, Nicholas.
Whether Ms. Castleberry was an immediate threat to Detective Mitchell of death or serious.
Hello again, Nicholas.
What is your opinion on that, sir?
Hi.
Oh, that's not only, there's not it rises above his perceptions that she was an immediate threat. There's no doubt that she was an immediate threat. She seriously wounded him by cutting his hand open with an edged weapon. And there's no doubt that that was an action taken, so that it was an immediate threat. Had he, once again, not controlled her arms, we don't know what the outcome would have been.
Did you find this threat to be ongoing?
Yes, throughout the encounter, until Miss Castleberry is finally wounded to the point, or her body, based on blood pressure, loss of blood, etc. They call it exsanguination or blood loss, where she finally succumbs to her wounds or stops resisting.
What facts did you review that would lead a reasonable officer to believe that the threat was in fact ongoing?
Well, primarily we have the videotape, although unfortunately the videotape is very hard to see. We know there's movement. We know, based on the facts and evidence, that Ms. Castleberry did have a knife, did cut the detective. Those are facts and evidence. We know that the situation started in the front seat, ended up in the rear seat, and that's where the shooting took place. And we have Detective Mitchell's statements about what he saw, what he perceived, what he felt.
Boomer,
what
boomer.
happened to your knowledge after the after the knifing incident?
Well, that happened early in the encounter when he didn't know that she had a knife. Apparently it was palmed or something he describes to a detective, so he didn't know he'd been cut until afterwards. Then when he tries to grab her arms and control her arms is when she maneuvers, somehow gets her back up against the dash and shoves her foot into his neck. Once again, he's seatbelted in, and this is extremely dangerous because from ultimate fighting competitions or martial arts or whatever, that rendering somebody unconscious through a choking or through a neck restraint or what have you leads that person can become unconscious and even more susceptible to attack.
Why is that relevant here, Mr. Davis?
Because Detective Mitchell could not allow himself to be rendered unconscious. As a matter of fact, in his statements, he talks about feeling that he was going to black out. Once again, because of that, making the decision to let go. When he let go, Miss Castleberry still had the knife in her hand. That's his statements. And also, as she's moving from the front seat to the rear seat, he says that she still had the knife. He was aware of that. At that time, she was right next to him. She'd already cut him. It was reasonable for him to believe that she was a threat of death or serious bodily harm.
And at that point, was it reasonable for him to shoot?
Oh, yes.
Why, or does it matter if Detective Mitchell ever suffered another serious slash or wound?
No.
Why not?
Well, in the use of force, and once again, excuse me, the prosecution's expert, Mr. Patrick, talks about, in one of the cases, the White case, was Mr. Patrick was used as an expert to testify in that case about Officer White's behavior. Officer White shot a subject by the name of McCloskey who didn't have a gun. And Officer White's statement was that McCloskey was making the motion towards his waistband to what he believed to access a gun, and Officer White fired. And Mr. Patrick testified in that case that he didn't need to have a gun, that his perception of the threat of death or serious bodily harm was enough based on the law. And now we know that the White case is law in the state of Ohio.
So an officer only has to perceive that a person is a deadly threat. Is that correct?
Oh, yes. He just has to perceive, and it's reasonable under this situation. We have no evidence that Detective Mitchell knew when she let go of the knife. We know that the knife was found somewhere around the driver's seat, but there's no evidence to suggest that she could have dropped it after the final shot. We just don't know.
Now, at the point he feels as if he's going to lose consciousness, he releases his hand. What, in your experience, then, would an officer be trying to do with respect to deadly force? What's he focused on at that point?
Well, he's focused on accessing his handgun. The problem with that is handguns are usually concealed or carried on the strong side of an officer at belt level. Here we have a situation where the vice detective has decided to put his handgun at the side of the driver's seat. This is not something that you train for. And all of the studies, all of the times that we look at in terms of response time are an officer coming from the holster with the handgun already out. In this case, the detective had to turn, unbuckle the seatbelt, we know he opened the door, access his handgun, and then turn. And his statement is that he fired first with his left hand, pivoted, then his right hand, and then both hands, I believe, on the final shot. But this all takes time. This is not something we train for, unfortunately, and not something you can understand the time frame involved because of the movements of the detective to access his gun and deliver an accurate fire on target.
Was that action taken by Detective Mitchell reasonable?
Oh, yes.
Was it reasonable for him to fire across his chest, kind of turning his head?
Certainly. I mean, there's no, once again, we talked about tactics being subjective. There's not any training in the basic academy or in service that I'm aware of that teaches officers how to shoot at a deadly threat behind them in the seat of a vehicle. There's no training. So the object is to get the muzzle, the barrel pointed towards the threat. And it was my understanding that the first shot or a couple shots were to get Miss Castleberry off him because he felt that she might slice his throat.
In your opinion, Mr. Davis, was there any type of reassessment going on here?
Well, it's continual reassessment, but you know, this term reassessment is an interesting notion. Mr. Patrick in his book talks about, you know, in the book only uses the term reassessing or reassess one time. And he talks about that in a derogatory fashion. For instance, there is a group called PERF, or Police Executive Research Forum. And part of their recommendations is that officers continually, you know, think and reassessing, et cetera. There are a variety of different components there. But the problem is, and Mr. Patrick says this is beyond the standard of Graham v. Connor objective reasonableness. In other words, reassessment is not a part of Graham nor a part of White.
Now, with respect to this second factor, whether the person posed an immediate threat, does an officer have to be certain that the suspect has a weapon?
No, Mr. Patrick, as I stated before in the White case, said that, you know, his perception that he was facing
Chandler in the house. What's up, girl?
Is enough to allow him, if it's a reasonable perception, to use deadly force.
What if the officer doesn't see the weapon?
Well, once again, you know, there are a variety of different circumstances, especially with subjects that are moving in this manner, very hard to see. But he knows that she had a knife. He knows that he had been cut. So he had more than just his perceptions. He had probable cause based on actually being cut that she was a deadly threat.
And was that reasonable for him to perceive at that time?
Oh, yes.
The next part of your report talks about the third Graham factor. What is the third Graham factor?
Let's see, whether the person was active.
That's what we decided during the opening statement. She sounds like Lisa Simpson.
Walk the jury through that
We've been saying that
factor
from
and
the
how it
beginning.
applies to the facts in this case.
Once Miss Castleberry began resisting at the handcuffing procedure, she continued to resist and turned into assaultive behavior in short order by once again accessing, opening and cutting the detective with the knife. That's felonious assault. That is a fact and evidence. At that point, the movement in the front seat, you know, she maneuvered after he grabbed her arms to place her foot against his neck. And this is extremely dangerous, as I said, because you have a detective who's already been cut. And if you've ever
She grabbed her arms.
even in the kitchen, you recoil and you know, the pain factors, etc. Blood is flowing, making gripping slippery. on her hands and arms, etc. Blood pressure begins to drop a little bit. Heart rate increases because you're in fight or flight, all of these things. And then when he's almost rendered unconscious, he makes the decision to save his own life and let go of her arms and turn and access his firearm, knowing that she still had the knife and knowing that as she moved next to him that she was still armed with the knife. This continued throughout the encounter until she was finally stopped.
You said she moved next to him. Are you aware of where Donna Castleberry was found in the vehicle?
Yes, based on the body-worn camera video.
I'm highlighting some points
Is
here.
that a change in circumstance, Mr. Davis, that you took into
We'll be
account
talking
for
about them on the
purposes of
break.
your opinion?
It's not a substantive, what I call a substantive change, because it was within touching distance. There is no time during this encounter when Donald Castleberry was beyond arm's reach of the detective. All she had to do with the knife was to extend her arm and shove the knife into him or slice him, or et cetera. So during that entire encounter, she was within touching distance.
I want to switch gears and talk about human factors. I believe they're listed in your report. How do human factors impact an officer's perception with respect to what is occurring in the car?
When we talk about human factors, and once again, Mr. Patrick deals with these in his book as well, we're talking about the impact, physical, psychological, physiological impact of stress on the human being in times of peril. And
I think this guy's a fascinating witness. He's the best witness so far in the trial, but he's boring as
you may have experienced these things. Say you were in a traffic accident, or not even in an accident. You're driving in downtown Columbus and a car pulls out in front of you and you slam on the brakes. And that's probably an occurrence here, like most cities. You may find yourself that you were narrowed into the car in front of you. You may be shaking afterwards. You may have jammed on the brakes, which is why ABS brake systems improve performance, because we don't pump brakes in those times. We're incapable of those types of actions. So these human factors,
clearly never driven in
whether
snow.
psychological, physical, or physiological, impact our performance. Also in that we have what's called action response, which is how time and distance impacts performance.
Are you familiar with the term perceptional unnarrowing?
Perceptual narrowing, yes.
Tell ladies and gentlemen of the jury what perceptional narrowing means.
Was this study advanced? We used to call it tunnel vision, where you tunnel in on something. Tunnel hearing as well, or auditory exclusion, where we're not hearing as well. Those types of things have changed to perceptual narrowing.
Are we no longer
Science
balanced?
now says that
Damn it.
when something happens, when a threat presents itself in front of me, it's not that I don't see the things out to the side. It's just that my brain filters them out as unimportant. In other words, if I have a deadly threat in front of me, what's to the side or to the rear is not important to my brain for survival. Same thing with hearing. And once again, Mr. Patrick talks about this in his book, where officers repeat verbal warnings. We have these tape loops that officers get in sometimes where they say, get down on the ground, and they repeat the thing over and over again. Or
hey, the 70s were a great time. Why change your habits and why change your dress?
And when I say don't hear, they're hearing it. It's just their brain says this is not important. So perceptual narrowing has to do with not only a sense of vision, but also the sense of hearing.
Tell ladies and gentlemen of the jury how you took tunnel hearing, perceptional narrowing into the account here when analyzing this case.
Well, there's other factors involved in what went on auditorially inside the vehicle, but certainly there's nothing to say that that the detective heard what Ms. Castleberry said, especially when he's focused in on his response. He's focused in on shooting.
If the video is blurry, that's your fault. Turn up the resolution.
Gunfire inside a
crystal clear here.
Confines of a vehicle. That is an overwhelming sense. microphones, for instance, oftentimes blank those sounds out. We may later on suffer ringing in the ears afterwards, but not even realize that shots were fired. For instance, in a shooting that I was involved with, the shots from the suspect at us were very loud, but our shots toward the suspect were muffled. So there's a lot of interesting things that take place that you may or may not hear shouts of warning, shouts of suspect, and you may not even recall what you said.
So what is your opinion with respect to if Andy Mitchell perceived the words uttered by Donna Castleberry in this situation based on your training, experience, and expertise?
It would be up to his testimony as to what he recalled, hearing, but it would be understandable that he didn't hear it under those circumstances.
Would it be reasonable?
It would be reasonable, certainly based on, once again, that perceptual narrowing, especially once the gunfire started and his focus on shooting. Once you're focused in on your action, you're trying to be effective or trying to stop the deadly threat in this circumstance, then other things are filtered out by the brain as unimportant.
Another human factor you mentioned, Mr. Davis, is close proximity. Tell the jury what you mean by close proximity.
Once again, this has to do with.
Was he sworn in as a sound expert?
Everything at close range is perceived by us as a deadly threat. In other words, when we're confronted by a subject
testifying about the sound stuff, I don't think he was sworn in.
Or as a gun, everything is an emergency because our brain does not perceive that we have enough time to react and respond. We're rushed, we're panicked because of these circumstances. Even a police officer.
I don't know what you're thanking me for. I don't know what helped 100%. I haven't done a fucking thing. I'm just watching the trial, making fun of Nicholas. I haven't done a thing.
Their attention be diverted, or them not be paying attention. They could be. Having a bad day. It could be thinking about other things. All of these things factor into leg time and mental leg time. And oftentimes in close, unfortunately, we see officers say to suspects with their hands in their pocket, take your hand out, take your hand out. And when the suspect has a gun and takes their hand out, they're shot. The officer is shot before they realize the suspect has drawn a firearm and shot them. That's how fast action is versus response and mental leg time.
I want to focus on that for a moment, Mr. Davis, specifically the shot cadence here. What did you find in regards to the shot cadence here of Mr. Mitchell?
Well, it is what it is. I mean, those are the shots fired and the amount of time that he's taken. What we can say is that when we examine cadence of fire, we have to examine circumstances. And
it was weird. The cadence of the shots matched Bon Jovi's shot to the heart.
Involve a lot of different things.
You're to blame.
We talked about the
weird
difference between drawing from the holster and reaching next to the driver's seat, getting the gun, removing it from the holster, shooting with the left hand change into the right change, or to the right hand, shooting with the right hand, and turning in the seat to be more effective. All of those things are going to add time. When we're dealing with somebody at 12 feet in front of us that's a deadly threat and we're drawing from a holster, those types of situations don't translate to this type of situation. This is completely different based on the circumstances.
What's your opinion based on the circumstances with respect to the reasonableness of the shot cadence?
That it is what it is. He perceived a deadly threat until the last round was fired. And that decision to fire was reasonable based on the circumstances.
Do you know are you familiar with the term soot and stippling?
Yes, I've gotten advanced training in shooting incident reconstruction, and I know the terms.
Tell the jury what soot and stippling means and how it relates
to like a sex act
proximity in this situation.
Well,
$25 gets you soot and
what we have in stippling is normally about will occur, and what it is the unburnt powder and particulate that comes out after the bullet goes out in a cone-shaped pattern, and usually it's out to about 18 inches. So from 0 to 18 inches, you're going to see various degrees of stippling. the closer the barrel is.
Shut up, Nicholas.
to
Don't say
the
it.
Skin, it could be clothing, what have you. You're going to see a ballistic mark, a pattern, a cone-shaped pattern.
Did you say that distance was 0 to 18
I got your
inches?
18-inch
Normally,
cone-shaped
yes.
pattern right here, baby. Sorry, I
I
couldn't
want to
help
switch
it.
gears and talk about another human factor that you take into account in your analysis, specifically memory.
Oh, shit.
Based on your training, Mr. Davis, is it reasonable for an officer to recall every single thing that has happened or not happened?
No, this is common knowledge in law enforcement. Mr. Patrick, once again, the prosecution's expert, deals with this in his book about memory.
It's very common
a
amongst
friend of
cops
mine,
to
Dr. Alexis
misremember
Archibald, has done
and
extensive
forget things.
studies
Gotcha.
in terms of
I'm well
what
on my way to
officers remember
remembering a
after
lot of
shooting
shit.
incidents. And the memory does not work like a VCR. It's very fragmented. It depends on experience, on training, on the circumstances. There's a huge component with human memory, and oftentimes memory may improve after an encounter. For instance, we recommend that officers are not interviewed directly after the incident, that there's a delay for a couple of sleep cycles. They tend to remember more once the stress chemicals wear off, the adrenaline, noradrenaline, et cetera. They tend to remember more. However, over time, that memory can deteriorate. This has been a number of years since the shooting took place. It wouldn't surprise me that Detective Mitchell's memory is worse now than it was, several days or weeks right after the incident.
Objection,
In your experience, Mr. Davis,
anyone?
is it reasonable for an officer, or in this case, Officer Mitchell, to not remember a door being open?
No, there is a variety. I worked a case for the Akron Police Department, in which several officers fired, and it was compelling because none of the officers had an accurate recollection of the events of the shooting. All of them had distorted memories.
So in that
Distorted
distorted
memories the same
memories,
as
is it
perverted
reasonable for
memories?
Officer Mitchell to be able to
Asking for a
recall every
friend.
single thing that may or may not have happened on the video?
No, it depends on what we're focused in on as well. For instance, the door being open was at the time that he was accessing his firearm. Does he have a recollection of that, or getting the gun, drawing the gun, and shooting? One would say that, based on the way the brain works, the door being open was a trivial thing, to consider based on shooting to save his life.
You just mentioned about the door being open. Does Officer Mitchell have an obligation to retreat if the door was open?
No, there is no lawful requirement for an officer to retreat, or what's called a tactical retreat. This may or may not happen based on a decision by the officer, but there's no lawful mandate for them to retreat.
Does that diminish the threat if the door was open?
Not with Miss Castleberry armed with a knife to his rear. No, not based on his perception that she was a deadly threat.
Does Officer Mitchell have to wait before force is used on him again before employing deadly force?
No, matter of fact, he doesn't even have to be sure that Miss Castleberry has the knife. His perceptions just have to be reasonable.
Tell the ladies and gentlemen of the jury what preemptive force means.
This is based on an article from Tom Piotrowski, who is I believe he's now retired from the FBI, a special agent with the FBI, and this was published in the FBI Bulletin. And once again, Mr. Patrick, I believe, quotes Mr. Piotrowski in his book. Preemptive force means that we don't use force, or an officer doesn't use force, or in this case, Detective Mitchell didn't use force because of what Donna Castleberry did. He used force to stop her from feloniously assaulting, cutting him, stabbing him, etc.
Based on your review, Mr. Mitchell, is that the type of preemptive force that was used here before each and every shot?
Yes.
Based on your review here, Mr. Davis, is it based on your experience and review, did Andy Mitchell continue to keep firing?
No, once Miss Castleberry stopped, he stopped shooting.
What did you determine as to whether Donna Castleberry
Fair enough.
presented a threat?
I'm sorry, can you
I apologize. That was a terrible question. With respect to the threat, what did you determine with respect to the threat, if it was ongoing or not ongoing?
Once again, Detective Mitchell's statements were that at the point where, well, he certainly knows that Donna Castleberry has a knife. He just got cut. He knows that she's resisting by shoving her foot in the side of her neck. He made the decision to save his life and let go of her hands or arms and access his firearm. And he knows at that point that she still had the knife in hand as she's moving past him. But his statement is he was in fear that she was going to slice his or slit his throat from the rear seat, and that was a reasonable fear based on the perceptions. She was moving chaotically, very hard to see, very tense, as we say, tense, uncertain, and rapidly evolving situation that was a deadly threat.
Thank you, Mr. Davis. I want to switch gears and talk about Uri Patrick for a moment. You've already discussed some of what Uri Patrick in his book had authored, and I think some prior testimony as well. Have you read Uri Patrick's report in this
Is Uri
case?
Patrick dead?
I have, yes.
Have you read his book?
Several different editions. I believe.
No,
I own two
we've
editions.
seen Uri Patrick.
It's called In Defense of Self and Others, right?
That is correct.
And what did you find with respect to Uri Patrick's report in this case in comparison to other works that he has authored and or prior testimony?
Uri Patrick is the guy that looked like Hal Holbrook, was eating his eyeglasses the other day because
Patrick
he didn't
said
give
in
the
his
greatest
report,
testimony ever.
For instance, he uses the term necessary or reasonably necessary no less than 9 times in his report. And that is not a Graham factor, and that's not a White factor. And that's not in keeping with his testimony in White. In White, he specifically said that later on we may find that force was not necessary, but if deadly force is based on the officer's reasonable perceptions that the subject had a deadly weapon, then it's reasonable, then it's within the law. He in his book and the Laquan McDonald case talk about the lethality of a knife. And he says he compares
I was talking about
edge weapons and guns, and how the public may not believe that a person with a gun is a deadly threat, and that it's even worse when we're talking about a person with a knife. But clearly, within touching distance, as Mr. Patrick says, that Donna Castleberry was a deadly threat, armed with the knife. And there are other areas that I disagree with his report. As I said before, the reassessment. It's a quandary to me where he talks about reassessing prior to shooting, but in the book he is very derogatory in that when he refers to the perf standards about that, he says that that's not in keeping with the legal standards of objective reasonableness.
Mr. Davis, in your report and analysis, did you consider suspect intent?
Well, I consider what I call manifested intent. In other words, we're not mind readers. We don't know what Donna Castleberry was thinking. We only know manifested intent, which is what she was doing. And what she did was feloniously assault the detective, resist arrest, feloniously assault him with a knife, and presented a deadly threat. That is a fact and evidence.
Based on your training, experience, expertise, what did you find with respect to my client's decision to use force on August 23rd, 2018?
That it was a reasonable use of force based on his perceived threat of death or serious bodily injury based on the totality of the circumstances.
May I have a moment, Your Honor?
All right, sounds like you're going to wrap
Thank
it up.
you, Mr. Davis. I have nothing further at this time.
Ladies and gentlemen, at this time we're going to take a break. Carla will want one. Hold on. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. About 15 minutes.
All right.
15 minutes. It usually takes like 30, 45 minutes. Hopefully you'll stick to it this time. Ooh, someone's got a really bad coat there that's reflecting in the window. Holy jeez. I'm Neon Tiger. Wow. Now let's uncuck ourselves.
Mr. Davis, you can sit down.
Thank you.
So the question that I have, are we, if you guys need to argue on the
what? Come
Why
on.
did they cut this sound? I want to know.
Well, I guess that's it. They're not going to come back out and go, oops, sorry. Mr. Enzo asking the important question that we all want to know the answer to. What's in the box?
Put the gun down.
I saw you in the box. What was in the box?
Because I envy your normal life.
Put the gun down, David.
It seems that envy is my sin.
Oh, what's in the box?
Not till you give me the
What's
gun.
in the fucking box?
Give me the gun.
Can't resist that. All right. Let's bring this up, and we've got a few minutes to kill here, it sounds like. How you doing, Nicholas?
I'm doing okay. It's past 4 o'clock. They can't call me. So cheers.
Cheers. I'm torn. I'm torn between two lovers and feeling like a fool, as the old song goes. I can either continue to go the super heavy, ultra peated Bruichladdich Octomore Scotch route and never taste anything again. Or I can go the never mind. I can't go the Balvenie route. That's gone too. Never mind, my 2 bottles are empty. I guess I got to go the hardcore Octomore route. Man, for those of you that don't know, this Bruichladdich Octomore is the most peated Scotch that's produced. It smells just like an old folks hospital. Just band-aids, gauze, and age. For those of you that are like fans of peaty Scotch, or even though not peaty Scotch that have had like Lafroig or Ardbeg or Bowmore, they measure the peatiness in the phenols per million. Ordinarily, like a Bowmore, a Lafroig, or an Ardbeg will be around 35 to 55 ppms. They call them. This Octomore Edition 7.2 is 208 ppms. So you're looking at almost 10 times, like about 8 times more peaty than an Ardbeg or a Bowmore or something like that. So it's once this goes in, I'm not going to taste anything until breakfast. But this is so good.
If you ever want to know why somebody licks car tires.
Exactly. Well, burning car tires. Burning car tires covered with pig grease and old people. I should be on their marketing team, shouldn't I? Yeah, unfortunately, this is not something in the $10 range. I drank all the $10 range stuff. And then I'm gotten increasingly, that is so good. Holy crap. All right, that's the end of Whiskey Chat for now. We've got a bunch of chats to get through here. Because what I did is I went through and people were making comments that I wanted to comment on during the breaks and you give our little opinions. Me as the rational, right-thinking American and you as the foreigner. Give our thoughts on these things here. Let's get the super chats out of the way first. Kingslayer Damocles. This guy is on. Oh wait, we've got some movement in the courtroom. No, they're just moving the camera around. Never mind. Just the cameraman is trying to make us dizzy. This guy is untrustworthy. He just claimed your First and Fifth Amendment rights are resistance when it comes to use of force. Well, he's saying that, words and verbal assault is resistance. Yeah, if the cop says, I'm putting you under arrest, and you say, fuck you, that's a sign to the police officer that you're just not going to willingly comply. I don't recall him saying the Fifth Amendment rights are resistant, but yeah, back-talking a cop, telling him to go intercourse himself, can be seen as resistance and an indication that you're not going to comply with his lawful orders. Any insight or comment?
No, I'm just having a hard time understanding the scene of events. Why, if he is placing this woman under arrest, why is he still wearing the seatbelt?
We'll talk about that in just a little bit here.
Yeah.
Bella Stella, thank you so much. 610 watching and only 265 likes. Smash that like button. Well, we've gone up a little bit since then, but people are asking who has the worst the worst shooting records, cops or stormtroopers. Well, I just hate to say that apparently it's people here that are watching the stream. You guys are the worst of all. There's 609 of you and only 364 of you have found the like button. So come on, stormtroopers, step your game up. Get a little more accurate. Reach down there, smash that like and subscribe button. That's what we've got to do to get the YouTube algorithm to lock in on us. The more likes we have, the more they go, oh, hey, people like this video. Weird, huh? And they say, oh, more people like this video, so let's recommend it. And that gets more viewers, which gets more subscribers, which makes the Lorax happy. So do me that favor. And again, don't take this for granted because it's a thing. Once you get to a certain point, if you advance too rapidly for YouTube's liking, they just start deleting subscribers for no reason whatsoever. Wait till that happens to you, Nicholas. You'll be like, what the you'll get stuck at this level. I've been stuck literally ranging between 36,025 and 35,993, almost on a daily fluctuation basis for the last 3.5 weeks. Let's break that cycle. Make sure you're subscribed. And if you have already subscribed, please just do me the favor and go down there and double checking. And while you're at it, go over to Nicholas Starov's channel. Let me get this off here so we can see his details. Union Rep Labor Law, that's his channel name. Newly monetized, newly minted, and able to grift from y'all.
Yeah, that was fun. And thank you so much for aiding in that. I think the past two,
I gave Nicholas 8.
Yeah. Yeah, you gave me the 8.
Something like that. Wait, what?
But I think I gained close to 500 subscribers just by being on your F It Friday.
Well, there you go. That means half of what you ever earn goes straight to me.
Sure.
The check's in the mail.
I can swear it's in the mail. No. See? Doggo just, no, not gonna happen.
No, Shlomo, the jury's not deliberating. It's just a little bit of a break here. Settle down. Yeah, so please do me a favor. We're now up to 400 likes, so that still means at least 200 of you haven't done your job. Probably closer to 300 because people come and go. And how is our poll going so far? All of you people that are pole dancing over here, hit the like and subscribe and take the poll. This is the first time ever that there's been like fewer votes than there have been likes. Usually there's like a lot more votes than there are likes. All right. Here is the poll for today. 11% of you are so far saying guilty of murder. That's a surprisingly low number. It was 25% on Friday. 17% of you say probably guilty of voluntary manslaughter. 29% of you say I enjoy fence sitting. And 44% of you say not guilty, but not necessarily innocent. That's kind of, I'm in the not guilty, but not necessarily innocent category. We'll talk a bit more about that. Let's go, Brandon. I know this guy's testimony is absolutely riveting, but you should read this so you don't get put in the copyright cut cage or the Cage. Nice spelling there, Brandon. Almost as if you were like the president of the United States.
Have a cigar.
Yeah, and honestly, I thought this guy is the best witness in the entire trial. I think he's saying all the right. He's being the most effective witness in this whole trial, but he's boring as fuck. And that's the problem with a lot of people that have bass voices or like lower register voices. They tend to be really monotone. And that doesn't lead to a good storyteller.
So you should talk like this on the witness stand then.
Yeah. Insert eye shifting monkey meme here. And let's go. Brandon also says, imagine how much of an ass clown you'd have to be to show up to a murder trial dressed like that. As I said, you know, that look has served him well since 1976, so why change? And also, thank you again, Nicholas. You need to sorry. Thank you again. I'm not drunk. Thank you again. Let's go, Brandon, for talking to Nicholas here. Nicholas, you need to round a few of your relatives up and pop over to this guy's house and say hi to his wife.
She's over here. No.
Debbie Drelion says, sorry, but 52 late, so loud compared to the court. Love you. Apparently, you are literally the only person having that problem. I even checked it myself, and I sounded really awesome to myself. Well, that takes care of ye oldie super chats, except for the one that just came in from Matthew Self. I'm so sorry to have missed you this morning. That's probably like Steve's streams. He starts like right when I start work, and today was an absolute shit day, and it would have been extra shit if I would have popped in. So, morning, gents. Not sure what's going on in this trial. Give me the 60 second. Can you give me the 60-second synopsis?
Lousy
Okay.
Cop tries to take in hooker.
Yep.
Yeah.
Cop goes. He's a vice cop. He picks up a hooker, parks up against a wall so she can't escape. She doesn't believe he's a cop. He doesn't care if she believes he's a cop. He's an undercover cop, so he really is a cop. He tries to arrest her. She resists. He continues to try to arrest her. She stabs him in the hand. He shoots 6 shots, hits her with 3 of them, and now he's charged with murder. This is a retrial. He was tried last year, and after 18 hours of deliberation, the jury was a hung jury from 0 to 18 centimeters, apparently, according to this last witness. They were a hung jury, and now they're retrying it, and this is the end of the proceedings. This should be one of the last witnesses called. Hope that made sense. All right, on that note, let's kind of hit a few of these things here. But first, before we hit a few of these things, I just want to do a quick and simple little grift here. First of all, what I should have been doing, rather than drinking a large quantity of Lafroig 10, I should have fired up the teapot here and had an amazing pot of the Dragon's Treasure tea, because the Dragon's Treasure tea is awesome. If you want some amazing tea, make sure you get yourself over to thedragonstreasure.com. Thedragonstreasure.com. Every month, he offers up 60 different teas, either loose leaf or tea bags, and he'll take care of you. They come in all sorts of sizes from 20 grams to 100 grams. Amazing teas. I have a huge selection of teas here that I bought, and they're all absolutely amazing, and I should be drinking them now instead of Octomore, but now I've started with the PD Scotch, and I couldn't taste tea right now if I had to. So anyway, if you want to get tea bagged by the Tea Man, go over to the Tea Man shop at thedragonstreasure.com and use code VICES to get 10% off your tea order. You win, you get 10% off. He wins, he gets a sale, and I get a 5% kickback that I can apply towards more tea. So it's a win-win-win situation. It's like a happy threesome. Unhung hero, dog cam is currently a lie. Where be the dogs? Okay, shifting the dog cam. There's Cthulhu. Hi, doggos. What's up? There we go.
Aw. Look, how can you not love that face?
There's the dogs. Dog cam is no longer a lie. Right. Well, see, Chimney the Witch, normally I never make my coffee with an electric kettle. I'm a straight pour over guy. But with the tea, when I'm doing my streams, I use the electric kettle for my tea streams. Otherwise, I use a good old fashioned gas range stove with a pot of water on it. All righty, let's see. Let's hit a couple of more of these things here. Now, these are some of the comments that I've just tagged as we've gone through that I wanted to play devil's advocate for. Camera shifting again. Why are we shifting? Never mind. We're just showing the wall. Stupid. Oh, are we back? Can you hear the audio there, Nicholas?
Yep.
Okay. And I will mute it because they're still just showing the state seal. All right, here we go. It's Trenton says, unreasonable force is not legal. You have to establish the force was reasonable. And I think the cop has done a great job, a very good job, especially this witness, in arguing and establishing that the use of force was reasonable for the situation. I don't think the state has overcome that argument.
No. As he said it, but he is going solely on the cop's testimony. This is what happened. And by that standard, yeah, he's doing a great job. Now you have to conclude, is that cop the defendant? How credible is he in his statements? But you can't say anything against him because the other party is no longer here.
Yeah, they're calling the jury in. Bifron says no evidence to prove he stabbed him. She stabbed him. He stabbed himself. Well, the prosecution has stated that's part of their case, that she stabbed him, so he became really super angry and sought revenge by blasting her and making Swiss cheese out of her. Momo Shark says overkill for sure. I don't know. Put yourself in a situation where someone is attacking you with a knife in the confined space of your car, and then ask if firing 6 rounds and hitting them with 3 is really overkill. When someone is attacking you with a knife, you've got 2 cuts, one requiring 34 stitches and a blood transfusion, and as well as someone that continues to assault you and attack you. Because we haven't, the prosecution has not given us any evidence to prove that did not happen. What about stabbing your attacker? Again, Kitty, I will ask the devil's advocate question. What evidence has the prosecution put on that he was attacking her unlawfully? None, really, that I can see, that I saw or found credible. But it is possible that she could be defending herself. She could reasonably believe he was trying to attack her. And he can also, at the same time, reasonably believe that her self-defensive actions are an attack on him. It is possible that both she and him, is that the, or whatever whatever your proper pronouns are, it's possible that she and he both acted reasonably in defending themselves from each other. That is something to consider. Just because one person is acting in self-defense doesn't mean the other person is not also.
Good morning, I guess.
All right. Cross-examination time.
I've looked over your CV. Obviously, we've discussed this at a prior hearing, and you list a lot of cases in your CV, including things that happened while you were still working at Akron PD, right?
That's correct.
So cases you were involved in while you were there, and then you have some cases where you submitted reports, things didn't go to trial, right?
Correct.
Cases where you may have submitted a report and it was settled or was a civil case.
Maybe ongoing as well, yes.
Okay. And with respect to criminal cases where an officer used deadly force, how many times have you testified as an expert at that trial in that specific field? Let's not include what we're doing in this case here.
I would have to refer to my CV.
You can't tell us how many cases you've testified in, that you've been in court, declared an expert talking about matters like this?
Well, I want to be accurate, Counselor. I don't want to guess. I don't have
That question from
accurate
the
recollection
state.
as to the number of times, ma'am.
Mr. Davis, we talked about this very topic last year, did we not?
Last year.
We did,
I
yes.
asked you that very question then, didn't I?
Last year.
I can't recall, but okay.
And you still can't tell me. One or two, maybe?
This
Oh,
is
it's more
bad.
than that, I would think, but a number of them, yes.
That you have testified whether or not an officer's use of deadly force was reasonable or not in a criminal trial.
Or testified in a.
No, I asked that specific question. How many times?
I would refer to my CV. Would you like me to?
Sure,
Let him do
wait
it.
a moment.
Okay. Seriously, like I'm trying to get him to remember what he said a year ago. I can't remember what the hell I ate for breakfast yesterday. Well, I
have to
can
look
because
down
I
to
eat the
see
same thing every
the
day.
color of my socks. I mean, what did
Not
you
only
say
are
in the
pants
stream
prison,
last week?
socks are prison too.
Yeah.
Aw, she's getting a little grumpy wumpy. And God, I hate this prosecutor. Upper KB.
Well,
Yeah,
unless the number is 0, that's a
I
bad
believe
question.
4 times, including prior testimony here.
Which cases are those, if you would?
Well, obviously, the prior case here, that would be State of Ohio v. Jacob Baker. That would, another one would be,
Well,
I'm sorry?
are you looking at your report to get these? You're looking in the air.
Well, I just looked, and
Okay.
I'm telling you.
He's doing the
Jacob
proper
Baker.
thing. He's supposed to refer
in
to
the
it to
10th
refresh
Circuit,
his
that would
memory,
be,
not read from it. He was doing the right thing here. Fuck you,
The State of
prosecutor.
Dion Damon versus City of Denver.
Sorry, dogs. Didn't mean to scare you.
You're saying you testified in a criminal,
Oh, I'm sorry, that was a civil case.
okay?
The Jacob Baker, this case,
See, he was doing that right. They're supposed to refer to their reports and their notes to refresh their memory, not read from them. So he looked at it and then he tried to
Excluding the,
remember what he just read.
the civil case, that would be, what, 2 cases, 3 cases?
Besides this case, that would be one case then, right?
What?
Jacob Baker, correct, actual
Jacob
trial
Okay.
at,
Okay.
yes.
Exactly, thank you. And
So
in these cases, the majority of the cases in which you have acted as an expert and given some opinion, civil, criminal, whatever these may be, they were almost entirely in favor of the officer, claiming the officer acted reasonably, right?
Those were the clients that hired me. I can only give
Uh-oh.
opinions in cases where attorneys retain me.
So you haven't been retained by the prosecution, correct?
No, that's incorrect. I've worked prosecution cases in Portage County, Colga County, Summit County, so several different
You haven't
counties in
testified
Ohio.
in a criminal trial on behalf of a prosecutor to say an officer acted unreasonably.
Not officer cases, but I have testified as an expert for prosecution in cases in Ohio.
In use of force, general use of force matters, right?
In murder cases, a variety of different cases.
And you know who Yuri Patrick is, right?
I
Well,
do.
obviously.
You know who John Hall is?
I've actually met John Hall and corresponded with him. That's the co-author of the book In Defense of Self and Others.
And both very experienced, very well respected in the field, right?
Yes,
And you wrote a book called Use of Force Investigations, right? This is your book.
it is, yes.
And even in your dedication, you note to my legal educators on use of force, John Hall, a couple others, Yuri Patrick, and many, many more. I stand on the shoulders of giants. I thank you for your training.
I absolutely do, especially John Hall. I've attended firsthand training programs with John Hall, who's an attorney, former supervisory specialist.
What about Andrew Branca?
And you urge readers over and over throughout your writings on your blog and here to read this book, And the book by Gary
Is
Patrick.
Logan here?
And John Hall,
No.
yes, I still do. It's a good book.
And you
What's
rely
going on?
on much of what Mr. Hall and Mr. Patrick say in the field of use of force, right?
In this case, I quoted them in my report, but I wouldn't say I rely on the law first and foremost. As I stated, Mr. Hall was one of my first legal instructors on Graham v. Connor a number of years ago. So I defer to Mr. Hall, who is an attorney. Yes.
Who is Mr. Patrick's co-author.
Yes.
Now, let's get back to this case. You said you interviewed a bunch of information. Did you interview the defendant before giving your opinion?
No, I was never given access to the defendant. I did listen to the audio tape of his interview by investigators, as well as read his report.
You reviewed prior statements that he made, correct? You reviewed a statement, you said a written
To the
statement?
investigators?
Yes.
Yes.
And did you
Investigators
review
and
any statements
alligators.
he made at any other hearings?
Oh, grand jury testimony, yes.
And did you meet with Ms. Stevens and Mr. Collins to discuss the case,
A number of times, yes.
including this past weekend?
Yesterday or last evening.
And you would recognize, as you've said in your book, that citizens can be a victim at any time in virtually any place, right? Yes or no?
Ooh, well,
I'm sorry, which book, man?
That was a weirdly
All right, let's talk
aggressive
about
yes or
citizens'
no.
Armed defense. This is talking about citizens' right to defend themselves, right?
Can we approach? Why is she being a douche? That was like a weirdly aggressive yes or no. I'm curious what law. He's trying to take over, Nicholas. No, I'm curious what God damn it, what Nicholas says about this. What Law and Crime says about this. What's their poll telling us these days? Oh, sorry, that was the that weird stepmom murder case. We don't want that one. This is the one we want. Right now, legal. Why do I keep calling them legal? Law and Crime. Oh, they don't have a poll up right now. They're just saying Ken Davis, retired police officer, Akron PD, deadly use of force expert, is on the stand. They're not asking anything.
If they are uncertain of the result, they don't put up a poll.
That's probably true. I hadn't noticed, but that's probably it. Let's see here. This is a lengthy one. So, all right, let's try to read some of these. God damn it. I mean, shoot, I couldn't tell the story.
You wrote this book, Citizen's Guide to Armed Defense, correct?
I did, yes.
Okay. Talking about a citizen using self-defense, being aware of their surroundings, things like that, correct?
There's a variety of different topics. I have been a firearms instructor and a concealed carry permit instructor in the state of Ohio for a number of years. I'd also lectured at conferences
Your Honor,
about the.
I hate to cut the witness off, but it's being non-responsive. I simply asked one question.
What was the question, Carlo?
Even the judge is like, what the fuck are you asking? When even the judge is asking, what the fuck are you talking about? That's not a good question.
Continue answering. You know where, or do you want to ask another question?
Thank you. And in this book, do you also discuss Graham versus Connor and kind of relate the factors and totality of the circumstances to this situation?
My background is as a law enforcement officer, and Graham v. Connor is about the use of deadly force or use of force for law enforcement officers. Graham v. Connor against Tennessee versus Garner, State v. White do not apply to private citizens in the state of Ohio or throughout the country.
But in your book, and at page 65, you talk about Graham versus Connor factors, the totality of the circumstances, right?
I talk about how these totality of the circumstances and other factors need to be considered by the private citizen using self-defense, et cetera. But once again, Graham v. Connor does not apply to private citizens in this state or any state.
And that's not what I'm saying. You talk about the factors, you explain them to the average citizen, correct?
Could you bring the book?
Certainly. Size, strength, those are the factors I'm talking about.
Oh yeah, size and strength. Those are the only factors a woman cares about.
In this book.
Just kidding. Just kidding. A girth too. Yeah. All right. Never mind.
I say in law enforcement, these components, severity of the crime, et cetera, totality of the circumstances, they need to be considered in law enforcement. However, they also can apply certainly to private citizens, things like distance, time, lighting, et cetera.
Right. So you're just talking about factors that we look at in analyzing the totality of the circumstances, right?
That I use or can be used in those types of private citizen cases. Yeah. But once again, Graham, the legal standards for law enforcement don't apply to private citizens.
That's not what I'm talking about. I'm just talking about how you are listing and telling your reader about Graham versus Connor factors.
What you talking about, Willis? Factors to be considered in the use of deadly force in the private citizens. Yes.
Very good. And you mentioned size, gender, strength, right?
Certainly, these factors can be considered in private sector as well as law enforcement. Yes.
Okay. You don't mention those things in your report, right?
I document
skill. I'll give you skill.
I do document Ms. Castleberry's size and weight, but I do talk about the use of an edged weapon or the knife. Once again, and the fact that even the smallest or diminutive person can be a deadly threat with a knife.
And you mentioned when discussing gender that in general, women are easier to victimize, correct?
I don't know if I use the term easier to victimize. There is a strength and size difference, obviously, between men and women. Yes.
Women were rated as easier to victimize than men.
Rated by whom? I'm sorry.
I'm reading your book, page 11.
The context. I'm sorry.
Page 11, chapter on Don't Be a Victim. Women are rated as easier to victimize than men. Older persons were rated as easier to victimize than younger ones.
I believe.
Does that sound familiar?
I believe when I talk about rated, this was looking at offenders who were interviewed in prisons and jails about who they would assault. And they said that women were rated easier, as were older people rated easier to assault.
You mention things like environment as a factor that's totality of the circumstances, right?
Yes.
Things like night or day matter, right?
Can matter, yes.
Okay. And you mention time. The ability to create distance is a factor, isn't it?
The fact or the distance between a subject, an assailant, and the defender is certainly a factor. As I've stated, things that touching distance, especially when we're talking about dealing with the person armed with a knife, are a deadly threat. 50 feet away, that same person may not be a deadly threat. However, we've learned that closer, depending on the suspect running at an officer with a knife, and Mr. Patrick says this in his book, may be a deadly threat out to 30 or 35 feet.
But the ability to create distance is a factor we look at in the totality of the circumstances, right?
Well, in this book, those factors it depends on the circumstances. If it's a surprise assault, you, the defender, you as a member of the jury are out, you're walking down the street, round a corner, and confronted with a sudden deadly threat. The distance is what the distance is. what you do, you maybe offered the opportunity to create distance, maybe not, but that doesn't change your use of deadly force. In other words, just because you could move or create distance doesn't mean that if you don't, it's a bad shooting.
But you can objectively look at the ability to create distance, to have time, to create some space, right?
Once again, it's both ways. It's the assailant, the distance that they are from the victim, their intended victim, and it's also the tactic of, if possible, if time permits, the ability to create distance. But that is oftentimes based on circumstances. What's behind you? If you turn and run, will you be assaulted? In this case, a person with a knife, will you be stabbed in the back if you turn and attempt to run? Same thing with private citizens, which is what this book is about.
I'm simply asking, it is a factor that you can look at in the totality of the circumstances, right? And assign what weight the reviewer wants to, right?
That's correct.
Very good.
Objection.
And
He's not giving the
Can we
answers
agree
I
that when
want.
we're looking at the moment force is used, we're looking at the moment the trigger is pulled, the moment of the decision to use force?
Well, that
Yeah, right? I mean,
I'm answering your question, Counselor.
Overruled. He can answer the question.
Your Honor, the relevance in terms of, is this a question about a private citizen or a police officer?
Okay.
Mhm.
To that extent, you can
Okay,
clarify.
very good. I'll clarify. With respect to police officers,
Okay, could you ask the question again? I'm
when
sorry.
we talk about the moment force is used, I think you said at the moment force is used, we're talking about at the moment you start to pull the trigger, right? When
Well,
we're reviewing the decision to use deadly force, the moment of the decision.
The decision is made before the action. That's the way our brains work. We make a decision based on the circumstances. We fire, an electrical signal that makes the trigger finger work. So there is going to be a delay between the decision and the moment the trigger is pulled, but we look at the moment that use of force is applied. Yes.
The moment the trigger is pulled.
The
moment
moment
use
the
of force.
decision, yes, based on the decision, right.
All right, let's go to your report. And I believe page 5, I think you already noted, Ms. Castleberry was involved in a previous arrest with no resistance offered by her, correct?
Yeah, very similar circumstances. The police officer.
Excuse me, Your Honor, I just like responsive answers and not narration.
Oh, shut up.
I think your question allows him to respond.
Right.
Continue.
Thank you.
Learn to ask better
Very
questions.
similar circumstances.
you
The police
cowbag.
officer identified himself as a police officer, and Ms. Castleberry offered no resistance, did not assault the detective. She was taken into custody, etc.
Were you aware she was taken to the library around other officers in that situation?
I believe that was the case, yes.
So it was not exactly like these circumstances, was it?
Very rarely, or do we have the exact same circumstances?
But yet you said it was almost identical. That's what your report says, almost identical, but it was not, was it?
Well, it was a vice detective announcing he was a member of the Columbus Division of Police and placing her under arrest. So to that extent, it was pretty identical.
She offered no resistance when she was taken to the library in that instance around other officers, right?
She chose not to assault the detective or resist arrest. That's correct.
And she didn't get shot the first
Then we have
time.
page 6, 7. You have a bunch of photographs of the scene, correct? Or taken from body camera.
Still images taken from Officer McDaniel's body-worn camera, correct?
Right. Then we go to page 10. You mentioned that the prior photo shows the close proximity of Castleberry to the front seat, correct? Do you have your
Yeah,
report in front of you?
Yeah, that's addresses the previous photograph. Yes.
And you would agree with me that Donna Castleberry couldn't get further away from the front than to go to the rear of that car, correct?
Well, the passenger compartment is as big as it is. She could only move so far and within that passenger compartment.
Right.
Yes.
She couldn't get out of the car through the
No.
rear doors.
No,
She
my
couldn't-
understanding is that the child-proof locks were engaged.
Andy was up against a wall on the passenger side.
Page 10, you talk about
She sounds bored and
blood
angry
loss
at the same
making
time.
gripping Castleberry difficult. Mr. Mitchell didn't say there was blood all over and he was having a hard time grabbing her, did he?
I don't think he had to.
Homo
His
Shark,
hand
yes, she
bleeding.
was
It
shown a
couldn't have been
valid
flayed
ID.
open.
She
It
was shown
obvious
his
that,
police department ID, and she
there
said
was blood
she didn't believe it.
involved in gripping her, attempting to control her.
Well, this information here is made from an inference, not from his statement, right?
No, when you're cut, you bleed, and when you grab with the bleeding hand, blood's going to make it more difficult to grab. That's a fact.
But Mr. Mitchell didn't say blood dripping made it difficult, right?
I'm not aware of that.
Okay. Page 11. Castleberry continued to remain in an agitated state throughout the encounter until the last shot was fired.
Okay, could you refer me to the
Second paragraph, last sentence. We can hear from the audio tape, you say, that Castleberry continued to remain in an agitated state throughout the encounter until the last shot was fired.
Yes, that's correct. We can hear her screaming throughout the encounter.
Do you consider okay, sorry, an agitated state? Is that what you mean by that?
Well, I think that was at the point shortly before she stops, but up until that point, she's screaming. So yes.
She's not
And
complying. She's screaming.
You
Good point.
mentioned, we can see in the surveillance camera video, Castleberry moved throughout the encounter. I'm on the third paragraph, and I'm going to skip a couple words to move this along a little bit.
Because they're big and I can't pronounce them.
She moves from the center area of the front seat to the passenger window, over the front seat to the rear, and from passenger side to driver's side of the rear seat. So you're saying she moves from the center of the front seat to her passenger window and over the front seat? She's going over her seat?
Yes. Why not? What's the problem with that?
I'm sorry, she moved over to the passenger window. We know that. She moved over the front seat. There is a front seat and two bucket seats, the center part of the front seat. So that's still a front seat. And from the passenger side of the rear seat towards the center or towards the driver's side of the rear seat. Yes.
Okay, are you saying that is your perspective from viewing the video?
I'm saying that's what happened, and we can see movement that coincides with that.
Good answer,
sir. So
you
why
weren't
did
either,
you
bitch.
get this information?
When did the foot
Well,
come
ma'am, she
to his
started in
throat
the
bump
front
if she
seat.
was
We know
constantly
that.
moving?
We can see movement on the videotape.
Come on, prosecutor.
She moves from the front
Provide
seat to the
evidence that
rear
it didn't
seat.
happen that way.
We can
That's
see
your
that,
job.
and
You
we can
have
see
to,
that she moves from
that
the
he is incorrect.
passenger
in his
side
statement.
in the rear seat to the center or to the driver's side of the rear seat. That we can see that. And our final rest position was rear seat center or towards the driver's side.
Well, and you started by saying that she was in the center area, in the console area.
Yeah.
That's
So?
what you're saying you saw in the video.
No.
But she was in the passenger seat. The original knife assault, we don't know specifically where she was, but she had to be within touching distance of the detective in the front passenger seat. She then moves with her back to the dashboard. That would be the center of the front seat area. And then from there, goes over the center area, the front seat into the back seat.
Okay, well, let's talk about the dashboard.
What do you mean? Does it
area.
sound like
You
I'm
said she was in
underwater?
the dashboard
What?
area. I'm asking you where you get that information.
Yeah, your
Well,
sound
that
is
was from
wonky.
Detective Mitchell's information that she put her back against the dash area before she shoved her foot into his neck.
Okay. So you're not saying that's what you saw in the video?
It's very hard to see. We can see movement. That movement coincides with what took place in the vehicle based on the evidence.
Does your report ever mention that all the shots were fired from the front to the rear?
Well, that's where Detective Mitchell was.
Always go
So,
front to back. Always
at
go
that
front
point
to
in
back.
time, the
Help if I'm not
shots,
yelling. That's the
based
question.
on the facts and evidence, were fired.
Yeah, your sound is a bit
I
weird.
don't know if it was towards the rear. One was upward, so a variety of
That
different
doesn't really
angles,
help.
but
I'm going
certainly
to pop
from
out
the
of here for a
front
second. I'll
towards
pop
the
right
rear.
back.
Those are the facts.
Sure. What I'm saying is you don't do any analysis in your report to indicate all the shots came from the front seat to the rear, right?
That was done by the BCI detectives. I didn't do that shooting investigation.
Sure. But
Actually,
isn't
no,
that
I'm
a
not,
factor
because I'll
to
lose all of the
consider
things
the
I've
direction the
started.
shots were being fired during this and determining whether it was reasonable or not?
Well, those are the facts. At the point in time when Detective Mitchell fired, Ms. Castleberry was either moving towards the rear seat or in the rear seat. So those are the facts.
And in 25 pages, though, you don't go into any discussion to even say all of the shots were fired from the front seat into the rear seat, right?
Well, ma'am, there's no facts or there's no ballistic evidence that any shots were fired anywhere else.
Right. I'm just asking whether or not you had any discussion of that in your report. And the answer is no.
Asking,
right?
why don't you say the things I want you to
My
say?
question was not the location or direction. My question was whether they were within the confines of the law, whether they were objectively reasonable based on the facts and circumstances at the time he fired the shots.
Where the parties were positioned is not important to your analysis?
Well, certainly. I have never said anything. However, that's the facts and evidence. He fired multiple shots towards the rear of the vehicle where Donna Castleberry was either moving to or in, and several missed and several struck.
Let's move on to the second to last.
Never mind. I
paragraph
don't
on
like what
page
you're
11.
saying. I'm going to move on.
Kind of in the middle. Starts with because of this. Because of this, a reasonable
can't get
officer
an
in the
Atlas moment
exact
on
same
this. Let's move
circumstances
on.
inside that car, after being slashed with a knife at the onset, continuing to fight a knife-armed assailant at arm's length, having a suspect then shove her clad foot into the side of his neck to the point of unconsciousness. At the moment the officer fired his 6 shots, would have believed that such a suspect presented a continued risk of death or serious bodily harm to him or herself. You say that, right?
Well, actually, you misquoted me. It's to the point of near unconsciousness, not unconsciousness. So you misstated the report.
Wait.
But yes, I do
It
state that.
actually says to the point of unconsciousness.
No, ma'am, it says to the point of near unconsciousness.
Can I compare reports?
We got different reports.
Oh, that's interesting.
It says unconsciousness.
No, we out here again? Down here?
Uh-oh, mistrial.
Near unconsciousness.
Well, that's a different report.
Well, you must.
What is your report dated?
2 June 2020.
So is mine.
Oh,
Sure.
Did you edit?
that's interesting.
Since last year?
No,
Did
ma'am.
you edit this report in any way since last year?
No, ma'am.
Metadata. Bring on the metadata.
Yes, you may.
Bring on the metadata.
No, this is
Don't get
getting-
into other subjects. Get it. Come on.
Oh.
Now this was interesting. On the last witness.
Yeah, we've got drama.
Yay!
Wow. All right. Well, while they're trying to figure all this shite out, I'm going to see if we can get through some of these things I've starred, like Nicholas Starov.
Yeah.
It's Starov, right?
Starov.
Starov. Okay.
Yeah, close enough.
Yeah. Joe Choi a long time ago said I still own Hellraiser on VHS. That's one of the 2 I still own, like 2 commercially produced VHS tapes. One is Hellraiser and one is Mystery Science Theater 3000 movie.
Oh.
Meat Popsicle, he could have just backed out of the car, shut the door, locked her in, but no, he decided to shoot. Okay, devil's advocate again, Meat Popsicle. He had his seatbelt on. Apparently, he doesn't even remember opening the door, but it seems to be that he was just opening the door to allow himself some more room to access his weapon.
So yours says to the point of near unconsciousness. Okay.
All right. That was resolved quickly. No mistrial.
In that statement,
Damn.
you mentioned slash with a knife, foot to the neck. You don't mention
It's like some bad
the
rap
door's been
lyrics.
opened, right? You don't mention
Slice with a
Donna's
knife,
moved to
foot
the back
to the neck.
seat in that statement, right?
Well, I'm rendering an opinion about the assault on Detective Mitchell, not about whether he could have run away.
Well, you're talking about what a reasonable officer would have done in the same circumstances, but you left out some circumstances in that sentence, right?
Well, that's because those circumstances didn't exist. He didn't move away. The question is what he did do, was it reasonable? And that's what my opinion is based on.
Well, first of all, you need to believe Mr. Mitchell to believe those circumstances, right?
You got to believe to believe.
We have the videotape that shows that Mr. Mitchell did not run away. That did not happen. Therefore, we have to examine what did happen as to its reasonableness.
The door's open. That is a circumstance that we objectively know existed, right?
But he didn't run away.
That's not in your analysis here, right?
It didn't happen, ma'am. He did not run away.
No, I'm asking the door opened.
I can concede that the door opened.
But you didn't mention in your report in 25 pages of the analysis that the door was open, right?
He didn't leave the vehicle. It didn't make any difference. It's irrelevant. It didn't happen.
Mr. Davis, the ability to leave the vehicle is important, correct?
Not in this case, counselor, because we're looking at the use of deadly force, not about what he could have, should have, would have done in terms of tactics.
That's not tactics, according to Mr. Patrick. You aware of that? You read his report.
I
think he's full of
disagree.
shit now.
A
Yeah.
tactical retreat or moving outside, or what you previously questioned about cover and movement, etc., is irrelevant. Mr. Patrick also states that the tactics, the actions of the officer are irrelevant, counselor.
Mr. Patrick says that it is not retreat
I hope he just says,
walk
I don't give a
away
fuck what Mr.
and
Patrick
contain
said.
a subject, right?
But he
That's
also,
not retreat.
he writes in his book that that's irrelevant, counselor. That didn't happen. Detective Mitchell did not make the decision to leave the vehicle. That didn't happen. So the question is at the moment that he did fire, was it reasonable based on those circumstances, not on hypothetical of what he might have, could have, should have, would have done?
Well, in fact, the objective evidence indicates the door was open and he stepped out of the vehicle at some point, right?
I believe the door opened, a cell phone fell out. He put a foot down, pivoted back. It appears what we can see in the video, but that could have been to get a better position, certainly.
That could have been an opportunity to step back and create distance or contain the threat, correct?
But he didn't do that. He didn't have to by law. It's not the set of
That's the point
circumstances
right there.
in which we look at in this case. It did not happen.
It's not about what he did. It's about what a reasonable police officer would have done, correct?
No, it's about, the question is, in his shoes, what he did at that moment. Would a reasonably and prudent, well-trained officer have fired on Donna Castleberry based on the circumstances of being cut, being assaulted by her foot, the fearing that she was going to slit his throat from the backseat? That's the question. Not the question
is the
of what he
standard
could have,
right
should
there.
have, would
Not
have
the shit
done
she was
in
talking about. It's not
hypothetical.
what the reasonable police officer would have done. It's what he perceived reasonable.
For it, right?
No, we don't. We have facts and evidence. He didn't leave the car.
We don't have to take his word for everything he says and then
Prove
say,
it wrong, you
okay,
fucking
we accept all
cowbag.
that is true.
I'm sorry, I'm getting
And now we're
agitated.
going to decide if it's reasonable. That's not the analysis, right?
Prove him wrong.
You're talking about a car opening up and a tactical retreat or backing up or whatever. That's not what happened. I can't
Prove
base
him
my
wrong,
decision
government.
or my opinion based on hypotheticals. That's not what happened. He didn't have to legally retreat. He didn't have to legally back up. What he did was reasonable based on the circumstances, on what he actually did based on the facts and evidence.
The facts are he opened the door and he had a foot out, right?
Was it reasonable?
That's a fact.
And you don't discuss that in your report as important at all. Independent facts and evidence.
It didn't make a difference. It's irrelevant whether he put a foot out. The question is whether the shooting was within the law.
Right.
And the totality of the circumstances that existed when he fired.
Irrelevant of his actions. Yes.
Right.
Irrelevant of his tactics. Yes. As your own expert has talked about.
You didn't hear Mr. Patrick testify, did you?
No.
So if Mr. Patrick said that's not tactics and that's relevant to the totality, you just think he's wrong.
No, I think it's in conflict with what he's written and he and Mr. Hall have talked about. And I find that it's not in keeping with Graham v. Connor and it's not in keeping with State v. White. They don't, neither Graham v. Connor nor State v. White talk about police tactics. You know, what they talk about is reasonableness at the moment that force is used.
And State v. White is the very case Mr. Patrick testified in, right?
Yes, in which he said that an officer.
And everybody
need not
remember
be
what an
positive.
absolute fucking horrible witness he was, too. Mr. Patrick was fucking horrible as a
Yes.
witness.
Thank you.
He was one of the best witnesses for the defense because he contradicted his own fucking book, which she's relying on. I'm getting really agitated at her
Page
now.
12, the
And
severity
I
of the crime
started
at
off
issue.
liking her. God damn it. I hate when this happens.
Do you at least recognize that Mr. Patrick says when we look at the severity of the crime at issue, he says you're talking about the soliciting charge.
There
Correct? You're aware he says that, correct?
I was asked a question about the severity of the crime issue. I'm not aware of his testimony.
You read his report, right?
Yes.
She almost had a
mentioned
point
on
on
page
occasion,
12,
but she
and I
ruins
am
it
in
by pushing it too
Assuming these
far
match up, the
and then
large
losing the
paragraph kind of in
argument.
the middle starts with she was shot.
Yes, ma'am.
I'm going towards the middle. The entire time of the encounter within the close confines of the vehicle, Donna Castleberry continually presented a deadly threat to Detective Mitchell. She could have
Yes.
chosen to drop the knife, not physically attack the officer, et cetera, et cetera.
Yes.
Okay. You said, oh, I'm sorry. And then I need to go on the next sentence. She could have put her hands up and literally surrendered.
Yep.
Correct?
Yep.
To the officer's lawful authority, correct?
Correct. So in order to know what a suspect is doing, you need to look at them and see if they're putting their hands up, right?
Well, that's the totality of the circumstances, certainly.
And you said she continually presented a deadly threat to Detective Mitchell. And you base that on the fact that they're in these small confines, that she's still a threat in the back seat. Is that what you're saying?
Well, we know that she had cut the detective.
Yes.
We know that she
Twice.
had a knife. We don't know at what point that she dropped the knife, threw the knife. We simply don't know. It was his reasonable fear that she was a deadly threat when she was behind him. And certainly we can understand that a suspect to our rear with a knife is more of a threat to suspect than a suspect in front of us.
Well, Mr. Davis, if he steps out of the car and pivots and he's looking her way, she's no longer behind him, right?
At that point, then he's facing her. That's correct.
Okay. So this isn't somebody continually behind him throughout the encounter, right?
No, but the decision to shoot was when she was to his rear. And his statement is that he was afraid she was going to slit his throat.
And the circumstances then changed because the door opened, he stepped out, he was able to get out of his seatbelt and turn, right?
He moved to in position, yes.
Page 13. You routinely talk about I'm sorry, I'll try to find the right reference. You've called it here today an attack by Donna. This was an attack by Donna Castleberry.
I'm sorry.
Throughout the encounter?
Yeah, can you tell what page you're on?
Yeah, well, I was referring to prior testimony too, that he was attacking her throughout. So I'll go to the first, we'll start with the.
I'm sorry, Counselor, you said he was attacking her throughout.
I'm sorry, she was attacking him throughout, you've stated. Second paragraph, attacking the law enforcement officer.
She's too emotionally invested in this.
I'm just, in general,
Yeah.
you refer to this in your report, right, as an attack on the officer or a felonious assault on the officer, right?
Yes, she drew a knife, opened it up, and feloniously assaulted the detective. She then shoved her foot in the side of his neck. That's a felonious assault.
And she was committing this attack while saying, help, get off of me, according to the objective evidence. Is that what you're saying?
That was recorded on the audio, yes.
Okay. And open the back door, help me please, during the attack. Those were her words.
Yes.
You
I'm
say
becoming
it was
emotionally
on page
invested in
13
this.
again.
She annoys me.
I'll try to find the exact.
Yeah. And this is not a gender issue. Many prosecutors does the exact same mistake. They get too emotional and are after a conviction
to
instead
propose
of the
that
truth.
Castleberry was unarmed or no longer a
Right.
deadly threat at some point in the armed encounter because no physical evidence indicates so, and there is no way to prove that A, when she dropped or discarded the knife, and B, that Detective Mitchell knew she was unarmed.
Correct.
And would you agree we have a knife found on the front seat, correct?
Yes.
Well, a knife was photographed.
Ooh, good
I
technicality.
don't know where the knife was found. It was
Good
not
technicality.
photographed in place. It was placed point up against the driver's seat and photographed there. But based on body-worn camera, that's not where it was after the shooting.
Good comment. That was fucking
Based on the
awesome.
body-worn camera, what are you saying?
Yes, ma'am. I reviewed Officer McDaniel's body-worn camera, and there are still images. The knife is not in that position.
Oh,
when
shit.
it was at the encounter. It had been placed there for photographic purposes.
When it was on the seat of the car?
Point up on the driver's seat.
You're saying someone moved the knife?
I'm saying that,
Oh.
yes, it was not photographed in place, and it was placed there.
It was found on the front seat, the driver's seat, right?
Somewhere, Counselor. It wasn't photographed in place, is my understanding. You can't see it in that position on Officer McDaniel's body-worn camera or still images created from that.
When an officer is making a decision to use deadly force, preparing to pull the trigger, he needs to assess the threat, right?
Oh,
That's
she left
part
that
of
discussion
what they do
immediately.
is we're primarily site-based creatures, so we're going to look to see, and of course, in this case, the assault happened before he knew there was a knife present. He had been cut before he knew that she had a knife on her. So the assessment was made based on his wound.
Before you pull the trigger, you should look at the suspect, see what they're doing, and see if they're a threat at that moment, right?
To the
Yes.
greatest degree
Wait,
possible.
let's go back to what we were just talking about a minute ago about the knife
Officers
being
are trained
moved.
to
What, you don't
focus
want
on
to?
the threat, right? The knife,
Oh,
the
this
gun, the cell
redirect
phone,
will
whatever the
be
object may
awesome.
Correct?
No, they're trained to focus
Oh, I hope they
on
bring up the
center
photos.
of mass and on their
The stills.
sights, not
Oh,
on
please.
the weapon system.
Well, before you decide to shoot, when you shoot, you should shoot center mass. But before that, you have to determine if the threat exists, right?
Jesus,
That
you're
threat had
losing
already
this
been
argument, lady. Knock it
substantiated
off.
based on the cut.
Mr. Davis, a cut 45 seconds earlier does not categorically allow an officer to use force 45 seconds later, right?
I'm going to try to subdue her.
Testimony from or statements from Detective Mitchell that at the point in time When he diverted his attention, he let go of her arms. She still had the knife. When she moved past him, she still had the knife. So it wasn't 45 seconds.
Right.
What you just said,
Ugh.
the cut on the hand. So what I'm trying to establish is before an officer pulls a trigger, just in general, before an officer pulls the trigger, he looks at the threat, he assesses the threat, he's focused in on the object that's the threat. That's the training, right?
No. And when I say no, what I mean by that is that we're talking about the decision to shoot, which is a time delay. We know that Donna Castleberry had a knife. We know that she feloniously assaulted the detective. The decision to shoot was made when he let go of the hands when she still had the knife. He then had to access the handgun. And at that point, as she's moving next to him, his statements are she still had the knife. At that point, the decision to shoot had been made. And his first shots, from what I understand, his statements are shot across his chest to fend her off. It's very hard to see someone to your rear and to see the whole person under those circumstances. Once he pivots, the handgun is up, and that's going to block his view of her body, her hands. Also, she's kicking, from what I understand, and moving.
First of all, this is assuming you believe what Mr. Mitchell says, right?
Well, once
Of
again,
course,
Cited
of
what he
course.
says, right?
Of course.
to
Prove him
coincide with the
wrong.
video and the facts and evidence, man, we know that she moved from front seat to rear. We know she had a knife.
Prove him
We know she moved
wrong,
from the rear
prosecutor.
passenger
That's
seat
your
towards
fucking
the
job.
Center or the driver's side. All those things are facts and evidence.
We know the door was open.
We know that he opened the
This
door.
should be in their case of chief to relay back to. This happened. This happened. Here's our evidence. Let
And
me
an
show you
officer is
this. Let me
trained
show you
Right.
that.
to watch a suspect's hands, especially if he knew that's where the threat just was, right?
What?
At some point, he has to divert his attention. He can't watch her and get his gun and make it ready to be able to shoot. He has to divert his, especially with the handgun at the side of the seat. That's going to not be what we call a motor program, or what you call a skill that he has practiced. So he's going to have to be more attentive to getting the gun than her. And his statements are that he feared that she would slit his throat from the rear seat.
You are again relying on his statements. I'm asking about basic
Prove his
training.
statements wrong.
Officers are trained to focus on the hands. If there was just a knife in a hand and you're in a training scenario, you focus on that hand, right?
Unless you're trying to get
We
your
train
gun.
officers to focus on hands prior to incidents. We don't want them to wait until a suspect has a knife in hand. It's to watch their hands, because what's in their hands can kill them. But in this case, what was unknown in Donna Castleberry's hands was used against the detective.
So in your analysis, the fact that he didn't know what was in her hands makes her a deadly threat throughout, because he didn't know.
What he did know is that she had a knife. What he
perceived, yes,
where the knife was at the time that
Right.
he fired the shots. That's the statements. Those are the statements.
So what could Donna Castleberry do?
Submit to the lawful arrest.
What could she do when she was in the back seat?
Submit, counselor.
What does that look like?
In my case, anything is I stop. Okay, I'm done.
Okay.
Yes, with hands up, submitting to the lawful arrest. No longer kicking, no longer moving, stopping and submitting.
No longer moving, just freezing,
Yep.
Yes, submitting.
moving away.
Nope.
She
Don't
couldn't
move.
move any further away. She was in the back seat.
Exactly.
It doesn't matter if she believed he was a cop or not.
Page 14,
He said he
can
was
we
a
at
cop. He
least
was
agree
a
you've
cop.
got a
That was her
timeline
mistake. He does not have to.
That it was 45
exert
seconds
effort
after
or
he
to
said he was
prove that
cut,
he is a police
approximately,
officer.
that he fired the weapon. Agree with that?
We'll
From
talk about
when
that
he
in a
says
minute.
he's been cut until the first shot.
Yes. About 45 seconds. Does that sound right?
That's somewhere in that nature. I understand that Agent Loomis's timeline is different. I submit to his expertise, but my report indicates those times.
When Donna went from the front to the back seat of the vehicle, tell me objectively, what did you see or hear to show that there was a deadly attack at that time?
What did I see or hear? Well, the attack was ongoing. She was moving. We don't know when she dropped or threw the knife. We simply do not know. There is no evidence.
He showed his police
she dropped the knife
ID.
at any
He
point
showed
prior
a
to the
valid
last round being
police
fired.
ID to
Mr.
her.
Davis, you say these actions, until her actions, I'm sorry, page 14, second to the last paragraph, her actions were finally de-escalated by way of police gunfire.
I'm sorry, second to last paragraph?
Yes. De-escalated by way of police gunfire.
Nothing wrong with that, as I see. You get shot, you're like, holy,
That's
you get stabbed, you're like, holy fuck, I got sliced, I'm shooting her.
Yeah, yes.
Protect my life. I see nothing wrong with that.
De-escalation means that she was no longer a threat. There is no.
He was not required to have a badge. He
definition
was
of
undercover.
what de-escalation means in law enforcement. It can be everything from talking to somebody and trying
You can
to
argue against
dissuade
the law,
her
but you
or,
can't argue that
dissuade
the
them.
law
In
applies
this
to
case,
him.
at the beginning stages, he used de-escalation tactics to try to keep things calm. But once she feloniously assaulted him, once she created a deadly set of circumstances in the vehicle, the de-escalation was the gunfire. She was stopped.
It was absolutely valid, Luke. It said retired on it. It was a retired police officer's badge. It was absolutely valid.
I'll get to de-escalation here in a minute, but
it identified her as a
words
retired police
and
officer.
Talking, those things are relevant in these determinations, aren't they? What people are saying, it matters. It may not carry the day, but it matters.
Not to override their actions. We have to look at their actions. Many times suspects say things that are not in keeping with their actions to try to lower an officer's readiness. For instance, okay, I'll comply or whatever, waiting for the point to assault the officer. So we have to look at words and compare them to actions.
So in comparing words, yeah, I'll strike that. I'll move on. Page 14, very top, you call Donna an armed, committed, determined, violent attacker.
I'm sorry, Counselor. You're saying page 14?
I'm sorry, am I on 14 or 15? No, I am on 14. I'm sorry, the very last paragraph. Indeed, Donna Castleberry was an armed, committed, determined, violent attacker.
Yes, I believe that's true, yes.
Page 15, you talk about there was no reason to retreat. There was no legal or tactical reason for Detective Mitchell to run away, but rather compelling reasons that this determined, armed, violent female attacker needed to be stopped. That's what you said, right?
I don't believe I used the term run away. I said that earlier, but I used the terms retreat or escape.
Okay, maybe that's another difference. We have Detective Mitchell to run away, yours says retreat.
I'm sorry, I don't know where you're at, Counselor.
This is bad to have all these different copies of the report running around.
There's Mike on a different page, man.
So legal or tactical, that's.
Yours is different.
Oh dear.
Well, you said
this is always ungood.
No, I didn't say run. I said run away, but I didn't write.
Okay, let's take the 10-minute recess so we can get the damn copy
We're
correct.
not talking about somebody running away from a school shooting or running away from a bank robbery, right? We've got a confined attacker who can be trapped and contained, right?
On your analogy, we train officers to move to the sound of gunfire. That's what we pay officers to do. We don't pay officers to run away.
Sure. But where there's an opportunity to escape and a dangerous attacker who's in a vehicle with a knife and you can contain that, you don't run to that danger. that person can't go anywhere, right?
That's what we pay officers to do.
Yes,
They're
exactly.
Law enforcement officers. We pay them to enforce the law. We don't pay them to run away and have Miss Castleberry present a deadly threat to someone else in the parking lot or what have you. We don't pay officers to do that. We pay them to enforce the law.
Miss
Right.
Castleberry couldn't get out of that car, and
Doesn't
he
matter.
knew it, right?
Well, he knew it because he was blocking the exit and she could not get out because he was trying to take her into custody and she presented a deadly threat.
She's not a danger to anyone else in that parking lot, right?
She's a danger to the
That's
officer in
not
the
at
car.
that time, no. But you brought up the thing about running away.
You're calling it officers have a duty to approach and to go towards the threat. But that's not this situation. This is not like a school shooting, go to the threat, right?
But he's in this situation. We didn't pay Detective Mitchell or the citizens of Columbus pay Detective Mitchell to run away. That's not his job.
We train officers to preserve life when possible, right?
Preserve their own life as well.
And
Yes.
citizens, we train them to make distance, to take
What?
time and cover when possible, right?
But
What?
it's not a requirement by law. It may be a tactical suggestion, but based on the circumstances, we didn't have that here. We know that Detective Mitchell did not run away. That's not a factor in this shooting.
We know that the door was open and he had an ability and did in fact step at least a foot out of that car, right?
We know that the door opened and he stepped a foot out, yes.
In your armed defense book, you talk about if an officer feels a risk is too great, back up to a position of cover and hunker down. In this way, you can set up an ambush. Those are concepts.
So what you wanted, you want him to say that he should have
I'm sorry,
ambushed
ma'am,
her?
You're holding a use of force investigations book and you're talking about another book. I'm not sure what context you're asking the question.
Your book, Use of Force Investigation, specifically talks about law enforcement investigations, right?
Yes, but you referred to the Citizens Guide. You referred to the
I'm
different
sorry.
book.
I apologize.
So-
Let me get my quote proper here.
Yeah, get your that helps.
Page. Yeah, maybe I am on the wrong one.
There you go. I got a quote for you.
We are federales, you know, the mountain police.
If you're the police, where are your badges?
Badges? We ain't got no badges. We don't need no badges. I don't have to show you any stinking badges.
Give me just a moment.
Sorry, couldn't resist.
Now, I don't like these paper ID things that they claim are not. You can't copy these. Oh no, sure. But
You can copy anything. Where do you draw the line?
Yeah.
That's a valid ID.
Yeah. But what is the actual law and how is it written?
139. You start with
That's the
active search and
official
response.
identification, is that
Talking
plastic
about
badge.
Conducting what police call a slow and methodical search takes time. Then you go into a case study and continue on and to talk about challenging intruders. You give some examples throughout this book, right, about what police do. Would you agree with that?
I'll take your word for it, Counselor.
Okay, thank you. And you indicate that police officers will make all possible haste towards a burglary in progress armed homeowner call, a robbery or shooting. But when you're the one involved and forced to wait, it can seem like hours. You want to call or have someone else call prior to contact, if at all possible, and when safe to do so. If the threat is imminent, call police. And you go on talking about attack scenarios and time and distance and things of that nature. Do you recall that?
This is about a homeowner burglary where you're the homeowner and a burglar or home invader has entered your home. This is not about police officers, once again.
But the concepts you discuss often overlap between what is a reasonable use of force and what a citizen may look at in considering their use of force, right? There's some analogies to be made here.
In this context, the recommendation would be that the homeowner not engage in going out and searching, that they what's called an ensconce, or that they take a position with their firearm and that they call the police and let the police do their job. And the police are not going to stand back and wait unless it's a barricaded subject type of call where the person has a gun, they don't make entrance. But normally the police are going to search. We don't want the homeowner to do that. So the analogy between that and this case is just not there.
Okay.
Wow. Okay. This is getting more interesting as the time goes by. Wow. Huh.
This is really first the difference in reports, even though they have the same date.
That's interesting. Yeah. Apparently they whatever the problem was, they resolved it rather than make a big issue out of it.
Mm.
Huh.
But
interesting.
As I see it, this guy is panicking. He panicked. A panic cop, which is extremely bad. But as the law is written,
do not discuss
as the law is written, he is probably in the right, even though everything I've seen about him tells me he should never have been in law enforcement. The law is the law.
Have a good lunch.
Okay, they're coming back at 1:15. It's 12:02, so about an hour. All right. Wow, I seriously thought they were going to just rest and start with the closing arguments. That's what it sounded like last time. We might not finish this today. That's pretty darn interesting in and of itself. So let's get some of this stuff out of the way here. Hang on. Where's my camera? There it is. Oop. All right. We can remove this here. All right, talk to us for a minute, Nicholas. Give us your 2 cents here. Give us tell us your opinion here. What are you thinking so far?
Well, we have we passed 2 hours. I can use proper words.
Use proper words.
Yeah, we have a shit cop who tries to make an arrest without unbuckling himself from the car seat, which is how do you not, when you're trying to subdue or arrest a person, why do you keep yourself confided? She panics. She doesn't believe him by this tiny piece of paper that says, "I'm a cop, believe me." So yeah, she would have a case for self-defense, but since she's gone, there's no case there. And everything up until she's dead says this is a cop who panicked, who never should have been in law enforcement. But that's not how the law is written. And you can argue against the law that it shouldn't be like this. But in a court of law, you have to argue the law. And as it seems, even though I think he did everything wrong and should be prosecuted for this, I don't think the law applies to it, as I understand how they are arguing this.
What's your solution to this? I mean, first of all, if you were on this jury, what would you be voting as far as guilty of murder, guilty of voluntary manslaughter, and not guilty of anything?
Well, the prosecution have convinced me that he's probably not innocent, but he's not guilty because they haven't proved that anything he did was to intentionally kill this woman. So I would vote not guilty. I want to, but no, the law doesn't allow me to.
How does that work in Sweden? Are there is Sweden a jury country or a judge deciding country? I don't know that.
We are a judge deciding country.
Okay.
We have no jury. We have layman judges on the lower courts, but not a jury system.
Layman judges. That's interesting.
Hmm? Yeah, they are appointed by the political parties, and then they sit in as after a few hours of training. They sit in with an actual judge. So you have 4 layman judges in the lower court and 1 proper judge.
Okay, well, like in the very lowest of situations in places, we'll have like justices of the peace. They're not really lawyers. They just handle things like running stop sign cases and stuff like that. They don't do anything serious, like dog catcher cases and whatnot.
No, everything starts in the lower courts here. So murder, anything, start in the lower courts, unless it's a specialty court.
Wow. You've got some sun coming through the window there. That forehead is shiny.
Yeah.
Well, I've got a bunch of comments starred here that I want to talk about. It's time to play some devil's advocate. We got about an hour here. I don't know how much longer I'm going to be able to go. I honestly thought we would be wrapped up by now and be in the hands of the jury this afternoon. But hey, they pulled their star witness right out of their ass. This guy is great. Said it's interesting that he was really boring on direct examination. He's just taken her to the woodshed for a good old beating on cross-examination. Hey, Ron, Jeff, you need a watercraft accident video mental health break from this trial. She's just a really bad prosecutor. She asks horrible questions. As Nicholas was saying, she's too emotionally involved in this. And it's coming across, and she's just really blowing her chance here. She's choosing to die on some really weird hills here.
Yeah, and I don't know if those stills are in evidence, but now they will be.
Yeah, that whole weird thing with changing the knife and whatnot, that's not good. And he hammered that home.
Yeah.
And she seemed genuinely surprised by that, as if she hadn't noticed it. That's not a good
how can you not? When you check videos, you go frame by frame, don't you?
Yeah.
Yeah, I do at least, and I'm not even in criminal stuff. I check sometimes when I check surveillance cameras, frame by frame. What does it actually show?
Right. Well, that'll be interesting. I can't wait for the recross. For the redirect. That's going to be interesting.
Yeah.
And Fondian says, this witness has changed my mind to not guilty. Wow, that's not her job. That's not the job of the prosecutor to change your job to not guilty. But like on direct examination, this witness was really boring. And I mean, he was very knowledgeable, very effective, and saying very good things, but in a very undynamic way. But he found his dynamism in the cross examination, and he's bringing it home. Mangs says, "Here's a super chat for you, just because you're awesome, and for the dog cam." Well, now the dogs are scattered about the house. They're like on either side of the camera, so we'll just focus on Sleeping Yoda here for now. Thank you guys for those super chats. That is super, super appreciated because they're super, super chats. See what I did there? All right. Now, again, like I said, I've got these things. We want to go through here and talk about some of these things. And I'm playing devil's advocate for pretty much everything that I've got here. Whether you're pro-prosecution, I'm going to argue against the prosecution. If you're pro-defense, I'm going to argue against the defense because I want people to think. I love the fact that we're all disagreeing here. It's no fun if everybody's all on the same page. And as they say, I'm just preaching to the choir. That's no fun. But I am agitated by this prosecutor. She's got my dander up. A Daily Quick Bite says, I've shot with cops on range. Okay, this is the story I was going to tell. I've shot with cops on ranges. Cops suck at shooting, even in a safe range. And Durna 1804 says most police spend almost no time on the range. Wait, why? There we go. Both of these comments are true. And it's interesting. Well, they've testified in this case that the prosecutors do the police do range training 5 times a year. That's less than once every 2 months they go to the range and practice and are trained. Well, that's less than once every 2 months. And weirdly, he went to the range the morning this happened. And the morning of the shooting, he went to the range, and it's something that Andrew Branco was saying, and that I tend to agree with, that he's coming out of the range. He's hyper aware. He's hyper trained. He's just been trained for the last however many hours to shoot and not to shoot. And, that's what happened. Let's go, Brandon. Here's $5 for proof of life on Strawberry. Also, this prosecutor is malicious. They need to fire that woman. Yeah, she's just like involved. Don't you think, doggy? Come here. Come here, little doggy. Go on over there. You're not going to go over? You just want your butt scratched? Okay. Sorry. She doesn't want to be on camera. She just wants me to scratch your butt, and then she's going to walk away again.
You smell funny. We're going to have to take you for a bath tomorrow.
There we go. All right. Trust me. I was talking to her. She's alive. Well, all right. God, I've got so many of these things. What? That's mean. You're talking about EDB eating mayonnaise straight out of the jar. I don't know what you're talking about there. But anyway, she's not covering this case, is she?
Nope.
What Jeff says.
So.
I have no idea. There we go. Hey, what's up? What's up? What's up, doggo? Bye. All right. Anyway, talking about how bad of shots cops are. Here's a Legal Vices story. Back when I was in law school, I was kind of a dick because there's it's like a shooting range, cop shop, weapons, ammunition, utility equipment store. They sell everything like from firearms to bullets to like actual police uniforms, and they sell them to literally anybody. I walked in there and I bought a sheriff's, like the actual like t-shirt that sheriffs wear, a black t-shirt that says sheriff in yellow letters across the back. I bought a Salt Lake Gang Enforcement Unit shirt, and that's what the gang enforcement unit wears. They back then they wore the gang enforcement t-shirt and like utility camo trousers. So I bought the shirt and I was wearing it because it was a cool shirt, the gang enforcement unit. And I bought the shirt at that shop and they sold it to me, even though it's part of an official police uniform. So one day I came back, I was wearing that shirt and I was on the range, and I had some dick cop from the gang enforcement unit come up and start talking shit to me, going, "Hey, what are you wearing that for? Are you pretending to be a police officer? No, he asked me if I was a member of the gang, and I'm like, no, I just bought the fucking shirt over there like 2 weeks ago. He's like, oh yeah, if you're not pretending to be a police officer, then you're giving us a bad name. I mean, how am I giving you a bad name? He's like, well, because we're highly trained and blah, blah, blah. And I said, look, dude, if you don't want people wearing them, don't have this shop fucking sell the t-shirts right here. Now leave me alone. And he was standing like 3 or 4 booths down in the shooting range. It was an indoor shooting range. And this was like a guy from the gang enforcement. He was all over that fucking target. And he did his rounds. And then I just went boom, 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 emptied the clip, 8 shots. It was an 8-shot clip. Just bang, bang, bang. All of them in the black, in the center of the target. I pushed the button, wheeled my target in. I signed it, and I just dropped it off in front of him and walked out of the store and said, you're the fucking embarrassment, and walked out, and I felt pretty damn proud of myself. And the clerk says, what the hell was that all about, when I walked out of the shooting range? And I told him, and he thought that was pretty damn funny. But yeah, the gang enforcement guy that was giving me shit, saying that I'm giving them a bad name, was a fucking horrific shot compared to me. And I'm certainly no super expert marksman, but I am, we'll say, a marksman. But it's yeah, this guy was horrific. I can't remember exactly if he actually got any in the center of the black center of the target or not. I can't remember, but I know I certainly did. I got all 8 of my shots in there, so screw you, dickweed. The police are horrific shots. This guy was not lying when he said that, unfortunately. Daily Quick Bite says slit his throat from behind, but she was in the front of him with her foot on his neck. Which is it? It was both. That was the testimony. She was choking him out. And he was trying to subdue her. And finally, he realized this isn't going to work. So he had to let go of her to reach for his weapon. And while he was doing that, she climbed into the back seat. That's my understanding. And then he said, he thought she still had the weapon, thought she was going to pose a risk from behind. That's my understanding.
Most of this could have been avoided if he acted as he should have been in the very beginning. Unbuckle yourself, face the person you want to subdue, handcuff them.
Well, it could also have been avoided if she would have just said, oh, okay.
Yeah, that too.
But we'll talk about that in a minute too. Steel axe. I'm getting agitated by this. I'm smelling burnt toast. I can't feel my left arm. Is that a problem? I'm just like stroking out here. Steel axe. I've seen enough fights. Oh, wait, I did bring it up. I've seen enough fights where the losing party yells they're giving up only to take a cheap shot when the other person lets up. So just because she's yelling, I quit, it doesn't mean she really is. Well, exactly. And that's what other witnesses have testified. That's a thing. You say, okay. And then as soon as they release, you get up and run, or you stab them again, or you shoot them, or you reach for something. They're not trained to stop using force when you say you're done. It's when you show and demonstrate that you're done.
And I don't like defending the officer's conduct here, but the prosecution has to prove it. That everything he did was against the law. And to my understanding, they haven't.
I agree with you. Yeah. Absolutely. Defendant KKB says defendant said himself he forgot his badge and walkies before going on a sting. Yes, he said that his badge was on his uniform shirt, and he said his walkie-talkie was in the trunk, but it actually wasn't. But the important thing here is he, as an undercover police officer, was not required to carry his badge at that time. So he did nothing wrong procedurally. There's never been an argument, even from the prosecution, he did anything procedurally wrong. So yeah, even though he didn't have his badge with him, he was not required to have it by policy at that time. He complied with policy. There's no way around that one. Mr. Enzo asking a bystander to call the cops is where he got angry and started assaulting her. Well, use the term assaulting her. We're in an age in the United States, and I'll assume you're in the United States, where people hate the cops.
Sometimes with good reason, but yeah.
She starts saying the cops are doing this, the cops are doing that. It's quite possible this guy could have been the white knight, could have tried to white knight and jump in and rescue her and pull the cop off her and do whatever. So I don't think that's a wrong thing to say. Okay, she's bringing civilians into it. She's increasing the risk to me personally. She's asking bystanders to get involved. So therefore, now I was waiting for for the backup to get here, but now she escalated it by trying to get third-party citizens involved. So now I have to get her under arrest. I don't see a problem with that. Comments, Nicholas?
Nope.
Oh. Legendary Racing, would you say a police officer have better or worse accuracy than stormtroopers? Probably about the same. But speaking of accuracy, 614 of you are here, but only 501 of you, 2 of you have managed to find the like button. So hit that like button. And I know there's a lot more than that because we go about 30 to 45 minute viewing cycle here. So the 609 of you here, there's probably statistically very few of you that have been here since the beginning. So everybody here, go hit that like button, go hit the subscribe button. And as long as you're feeling generous and liking this video so that we can get it out on YouTube, and as long as you're feeling generous and subscribing or making sure you are still subscribed, make sure you go to Nicholas Starov. Oh, sorry, Starov. That still sounded very Russian, didn't it?
Yeah.
I've got to learn to say Starov. That's like a total Russian name to me. So I've got to start learning to say Starov in a non-Soviet way. I will crush you. If he dies, he dies.
If he dies, he dies.
Starov. Whatever.
Yeah, so just walk over to this, make a search for it in a different window, subscribe, and when this stream is over, check my content. If you like it, continue to subscribe and like. If you have criticism, just write it in the comment section because I like being criticized constructively, so I can improve.
He likes it when you berate him.
Yeah. Tell me I'm a bad boy.
Tell him what a dirty, dirty Swede he is. Slap him with a pickled herring. We have an extreme doggo close up here, don't we? Don't we have extreme doggo?
Oh, I want scratchy. I wish I could have a dog, but I'm away so much, so it would be unfair to the dog.
Yeah. All right. Would you say, okay, so yeah, we've decided that police officers have really bad aim. Would you attack a police officer with a knife if you were being arrested for prostitution? She had an outstanding warrant that would have put her in jail for a while, and he is mandatorily required to take her in. So it is possible that she doesn't want to go to jail. Plus, she had what I can't remember all what she had in her bloodstream. She had cocaine, fentanyl, and a horse drug in her system at the time of this arrest. So you can act irrationally. That's something that they haven't mentioned today, but it was mentioned previously. She had 3 powerful drugs in her system. A horse, something that like a veterinarian would prescribe for your horse, a cocaine, and fentanyl.
I don't want to hear horse and prostitute in the same sentence.
Nope. And Adriana says cocaine is expensive. No, yes, she was 23 years old, and that's why she had apparently become a hooker, was to support her drug habit. It wasn't ketamine. It was something that was like really long and unpronounceable by people other than horse vets. Well, we got to play lots more devil's advocate here. Hang on, I'm kind of starring a few things as we going on. It wasn't ketamine. It was something else. Like it was literally like a name that only horse vets could pronounce. So yeah, it is quite possible she's got fentanyl, cocaine, and this horse drug in her system. So it is very possible she would attack an officer with a knife while being arrested for prostitution. Brad, in the back seat, she was on her back using her legs to keep him back. He was in the front seat. He wasn't trying to get in the back seat. So that's a false statement as far as I understand it. He wasn't trying to get in the back seat and she was using her legs to keep him back. He was in the front seat reaching for his weapon, trying to turn around, and she was kicking him from behind. And he also thought she still had a knife behind him at that point, according to his statement, which the prosecution has not disproven. So again, I'm playing devil's advocate here. You can think I'm full of shit, or you can say, hey, wow, that's something to think about. But I'm doing it for both sides here. There's just a lot more negative people. Never mind the pattern. The knot is what's wrong. Oh, the tie. Okay.
Yeah.
The previous dude's tie. Yeah. Never mind the pattern. The knot is what's wrong with it. Still end. The small end is halfway up. Yeah. He just kind of needs a little more length on the tie. The girth is definitely there in the tie. He just needs a little more length.
Yeah, but the angle is wrong and the wrinkle is in the wrong place. So yeah.
Yeah, it wasn't ivermectin either. Can we say that on YouTube? It wasn't ivermectin. It was something else. And I probably wouldn't know it if I heard it. It was something I've never heard of. Some people are saying xylazine. It may have been. I don't know. It seemed like it was longer than that, but I don't know. What is xylazine? Is a drug used for sedation, anesthesia, muscle relaxation. Well, if you're taking cocaine and a depressant, that's counterproductive. Wow. I don't know what it was. If someone knows for sure what it is, let me know. Xylazine doesn't sound right. It may be, I just don't know. But I know it wasn't ivermectin or ketamine. It's Trenton says, if he had backed out of her car, would she have been a threat of any force, much less deadly? It's his escalation. No, he is authorized. He is a law enforcement officer. It is his job and his duty to enforce the law. She was breaking the law. He has a legal right to escalate the situation and no duty whatsoever to retreat. If she had submitted, it wouldn't have happened. So he doesn't have to back out of it. He has no legal duty to back out of the car, and you can't say he's guilty because he didn't back out of the car, regardless of what the prosecutor wants you to think.
Yeah.
So
the
yeah,
counter argument is the 6 shots, but then the prosecution also needs to prove which shots was the last one, which one was the kill shot, which one. They have to prove that, and yeah.
Meat Popsicle says, even just pointing the gun would have been enough, but he kept shooting. Well, again, seeing as how I'm supposed to be playing devil's advocate to both sides. Okay, so he points the gun. Maybe that would have stopped, but... Oh, wait, never mind. That's your argument. I have to make the opposite argument. But he kept shooting. How do I make the opposite argument to this? Even just pointing the gun would have been enough. Okay, but perhaps it wouldn't have been enough.
There are many situations where cops are involved where they point the gun and people keep running. They run against you. They draw weapons. So the base of that argument is,
removed the threat because she was still talking. She was still moving. She wasn't complying. So there is that argument. I've confused myself. I'm playing both sides of the coin here. I've confused myself. Daily Quick Bites again. Someone explain why he gets upset when she asks for someone to call other cops. As I said before, it could be because now it was between him and her. He just had to subdue her. Now he has to, and he could have waited. He was waiting up to that point. He was waiting for her, for the backup to get there before arresting her. Then suddenly she invites a third-party civilian into the equation where now he's got more on his hands than just her to take care of. So now he's like, okay, I can't deal with this. I have to put her under arrest. And then he says, fuck this. And I think that's literally what he said. It was fuck this. And then went to arrest her. Yeah, that's a possibility. And the state has not proved that was wrong. John Gary, women of negotiable affection is the official LV term for crack hoe. Well, that is from brilliant, may he rest in peace, author Terry Pratchett, referred to prostitutes as women of negotiable affection. And it stuck with me ever since I read, I think it was in The Lost Continent. I'm not sure which book that was in, where I first came across the term women of negotiable affection. David, how does he know that the door was opened to grab his weapon? How do we know it wasn't? That's the point. And he's saying he does not remember. And this tunnel vision thing he was talking about is a real thing. If you remember, some of you watched this, you watched the testimony of Officer Potter, who was convicted, and everybody was on the officer's side when she mistook her taser for, she mistook her handgun for her taser. She said, taser, 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 drew her handgun and shot the guy dead. And she was convicted and sent to prison for that. And you all thought that was horrific because she clearly misunderstood and clearly did not recall or know what she was doing. This is the same situation. He's more focused on saving his life. He is trying to neutralize the threat, and other actions may not even be noticed. You accepted it for Potter, but you're not accepting it for him? Not sure why that is. The state has not proved that didn't happen that way. Food for thought. Mariko True, what is the protocol for an undercover arrest? Seems like he put himself in the situation by acting without backup or searching the suspect. Well, he tried to arrest her. The procedure for that is you put them in handcuffs, then you search them. He didn't get to the handcuff part because she grabbed the handcuffs and threw them out the window. So that caused a problem. But the protocol is he identified himself as a police officer. She didn't comply. He did her a favor by showing his official police ID. She didn't believe him, and at that point, he has no duty to convince her. And as I've said from the beginning, what this is a failure to communicate. She didn't believe he was a police officer, and he has no legal duty to stop what he's doing and invest a great deal of time and effort to convince her he is who she says he is. But you see, it seems like he put himself in the situation, acted without backup. He texted for backup to come, and backup was on the way. And while he was waiting for backup, she decided to start screaming for third-party civilians walking by to get involved. And he said, now it's time to arrest you. Why wasn't he armed with a taser instead? Non-lethal force is an option. The answer to that is because he's a police officer, and a firearm is. Have you ever seen tasers? Are big. Tasers are actually pretty darn big. And you're in a car. A taser shoots out two basically like little fish hooky things attached to copper wires. They shoot those out and they stick in your skin, and they deploy. They do the zzz thing, and that gives you the shock. And in a closed situation where you have this deal, it is very easy for one or none of those of the prongs to stick in you and deploy. Plus, and also tasers are bright yellow. You don't want to have like this bright yellow. They're like bright yellow and black. You don't want to have a bright yellow and black thing sticking in your door where people can see it. Yeah, and Quick says, if you're authorized to use a taser, you are authorized to use a gun, right? And the gun is the safest choice in that situation. Was she shown a valid ID? Asked Momo Shark. Yes, she was. Her mistake was not believing it. She said, now this is where that gets interesting. This is where we have to differentiate between what is shown in evidence in this case and what is happening in the greater world that we're not talking about in this case because it's not entered in as evidence. Wow, dogs are snoring up hard here. She was shown a valid ID. She didn't believe it. She didn't accept it. And she said, oh, there's rumors of a guy going around kidnapping prostitutes. There's another officer that testified, hey, we went and we investigated that, and none of the prostitutes we talked to us about anybody that was supposedly kidnapping prostitutes. So the officer said, hey, we talked to hookers, and none of the hookers wanted to talk to the cops about it. And the defense has never come back and shown that there was, in fact, this rumor going around. But if we step outside of the court, this officer here is actually under federal indictment for kidnapping hookers and forcing them to have intercourse with him in exchange for being released and not charged. He's under federal indictment for this, but that has been excluded as evidence in this case. So
Yeah,
that's where I'm thinking. Yeah, go ahead.
And if it were admitted, then the prosecution could have argued that he only made the arrest because there was a civilian bystander. Now there was a witness. Now he has to arrest her. Otherwise, he probably would have. But since it's not in evidence, maybe because they're not in Wisconsin, where everything is let in.
See, and this is the thing. This is like this is where the difficulty comes with the jury instructions and the jury's duty to focus only on the evidence that's presented in the court case and not considering outside evidence. He is literally under federal indictment for doing this to multiple women, for kidnapping multiple prostitutes and forcing them to have sex with him in exchange for not being charged. But that has not been introduced into evidence. So therefore, in our analysis of this case, we can't consider that as evidence against him. We can only look at this one case in isolation. And so, I mean, what everybody's saying is probably true, that even if he's acquitted in this case, he's probably going down on the federal charges. Notes on a phone says, so basically, if he gets not guilty, they will give him max time on the federal case. Either way, he's done. Cop in jail. That's a possible outcome and a probable outcome, I think.
And then you can have the family bringing forward a civil suit.
Chris Mullen asks, why is that not admissible? It's basically my understanding in this situation, I didn't see the exclusionary decision, but in a situation like this, it would be excluded and not admissible because he hasn't been convicted yet. It's only an accusation that hasn't been backed up by a finding of law. So you can't say he's done this because it hasn't been proven in the federal courts yet. Starred comments back. We have 16 more starred comments and we can talk about other stuff. But we've got a couple of super chats that are backed up. Then we'll go back up and do these things. This is kind of fun. Thank you guys for making us all think. Mangs, because you're awesome for the dog cam. We already did that one. I hope you can hear the dog snoring up a storm. Here's $5 for proof of life. We did that one. We proved Strawberry's alive. Strawberry. Jessica Reloaded. Hey, welcome, Jessica. You asked a bit ago, which one is Dargy and which one is Strawberry and which one is Yoda, because you can't remember. Yoda is the white one that looks like Yoda. Strawberry is the one that doesn't look like a strawberry. So Strawberry is the one on the right, the brown and white, and Yoda is the white and brown. That's the dog mystery. Yoda, white and brown. Strawberry, brown and white. Hope that makes sense. Jessica Reloaded. Smash the like button, peasants. Right. We've got 590 here now. Hopefully we'll be back in court here in about 15 minutes. I don't know how much longer I can stay because it's 1:30 a.m. here and I had a shit day and I'm tired, but I'm kind of having fun. So we'll go as long as we can. 589 concurrent viewers, 535 likes. Thank you so much for all of you doing likes. Let's check our likeometer here. So far, we've got 11% say he's guilty of murder. 16% says guilty of voluntary manslaughter. Not guilty has gone up 1% to 46%. And 27% say you just enjoy sitting on the fence. Well, just be careful you don't get a pull up your ass, you non-decision-making peasants. Just kidding. Thank you so much for that, Jessica Reloaded. Always a pleasure to see you here. Good morning to you over on the west coast of God's country. Marv White, studies vary, but police accuracy under pressure is sub 35%. Not surprising. I'm actually surprised it's that high. Let's go, Brandon. Yep.
When I did my army duty, the first time I handled a gun, I had I believe a 60% accuracy.
Nice.
That was the first time I handled a gun. So if
that's actually good because you didn't have any bad habits to break. That's apparently the biggest difficulty is people that have been hunting and shooting all of their life, they develop really bad habits, then they go into the military and you have to untrain them before you can train them.
Yeah. Break down, build up.
And speaking of training people, let's go, Brandon. Hey, Jeff, would you be open to go on MLS show? Of course. You just got to invite me. If not, I suggest everyone unlikes the stream. Well, don't unlike the stream. He hasn't asked me to. When he does, I will, as soon as time permits. And he is all... No, he hasn't been on my stream yet. But he is always welcome. Just has to rear his head. So, of course.
Yeah.
Of course,
Yeah.
great show.
You are both covering trials, so it's hard to be on each other's stream. But yeah.
Yeah, no,
I'm having
enjoy his
lots of
channel
fun
quite a
on
bit.
his. Yeah, I'm having lots of fun on his streams.
Yeah, he just needs to throw out the invitation. So that answered that question. Flux throwing in the $5. I need to have Nicholas on my channel. Okay, Nicholas. Okay, I'll reach out. LMAO.
Yeah, sure.
Yeah.
If my schedule permits, I'm all game.
We need to see if Nicholas knows if Nicholas the Swede knows anything about the Switzerland weird ass tunnel satanic ceremony that we talked about on our Unexplained stream.
Yeah, I'm sorry I missed that, but I heard of it, so I went into my old moving boxes to find the books when I dabbed into all the religion studies just to check things out, and I didn't find that book on symbolism, but yeah.
So I mean, so was that a thing in Greater Scandinavia, or was that just like, okay, they're the Swiss, they're just doing whatever they want?
Well, in Scandinavia, we had the Norwegian black metal scene in the late 80s. So, yeah.
Of course.
Yeah. So, there was
Viking metal is still my favorite kind of metal.
Amon Amarth. Ah, what a band.
Oh, let me tell you an Amon Amarth song. Story. I have an Amon Amarth story.
Yeah.
Proof that I love my son to death. My son's a great kid. He's 22 now, so he's not a kid anymore. But he's a great kid. And I had trained him just to appreciate all kinds of music. So, I mean, he's in middle school. He's, 11, 12, 13 years old. I can't remember how old he was, but he's like, and he's borderline ADHD like me. And he's like, I'm having trouble concentrating, Dad. Do you mind if I listen to Miles Davis while I study? I'm like, Of course you can. And then we'll be watching Stevie Ray Vaughan videos and other things. And then it was one. Then from high school he went to live with my sister in America, so we could go to high school and have a good high school education, and then get in-state tuition fees for the university. But I was on vacation. We were driving down the road, and I just had my phone on random, and then a song, just a random song comes on that starts out. I was like, oh, this is Amon Amarth. And I'm like, how the fuck did you know that? He said, because every Amon Amarth song starts. And I go, fair play. You're absolutely correct. That was Amon Amarth. Yeah. Which, incidentally, for all of you Lord of the Rings nerds, knows that's a very important part of Lord of the Rings. All right. Now, I guess that just means I'm a big-ass nerd. David, how do you know that the door was open to grab his weapon? Well, like I said, that's we got way off the track there on that statement, but essentially that's what the testimony was, that the door was opened, and apparently that's when he grabbed his weapon. So they're just adding two and two together, because it was in the door panel in like the little holdy space on the door, and it would make sense, I guess, to open the door to get more room. There's no proof that he did, but again, the state has not proved any other reason for opening that door. It's a weird case. Was she shown a valid ID? Yes, as we said, she was shown the official plastic ID. Yeah. She didn't trust it, and bad shit happened.
Now, in her defense, I've looked it up, and I wouldn't believe it either, because it looks like real crap. But it's legal.
Well, but then again, I will argue that she also says on the video that she's familiar with the Vice Squad arrest procedures. I mean, this isn't her first rodeo with the arrest procedures.
Okay.
But anyway, and see, and that's the problem. And Bifrons here says cops carry badges. I didn't know that was in dispute. At the time, the policy of this was that they were not required to carry their badges while undercover. He said he normally did, but he forgot it this day. But he wasn't required to have it. So not having that badge was not a violation of policy. He had the official ID card. And police officers don't have a duty, as much as we think they should, to stop what they're doing and engage in a very long discussion to prove to people that they are actually police officers. They can do all of that with the handcuffs on and under arrest. We may not like that, but that's and well, I guess we have a lot of we'll come up here. I don't think I starred one of them, but there was a lot of the argument saying, well, so if any random civilian comes up to us and says they're a police officer, do we have to believe them? Well, that's a tricky situation, isn't it? It's a gamble. If you don't believe the wrong person, it can end up badly for you.
I saw in the chat band name Bathory, the OGs of Scandinavian black metal.
Yeah.
Oh, one-man band, played every instrument. Passed
I did
way
not know
too
that.
soon. One-man band. It is amazing.
But then how did they make all of those? Does Jeff have to go to work today? Yes, Jeff has to go to work today in 8 hours. But if there's only one man in the entire metal band, then how do they do the Scandinavian death metal posters of the black and white posters of 3 goth dudes sitting in a forest together? How do they make those pictures if there's only one guy? That's like every Scandinavian goth metal album cover ever, standing in the trees, optionally holding a sword, but all of them have to have hoods and long hair.
And
it's
corpse
a thing.
paint and everything.
Yeah.
Oh, you have to, if you want to have fun, Google black metal dance. Then you have these small gifs with black metal people walking around in the woods making weird gesture, and it's hysterical.
Bye, Franz again. Okay, we just read that one. Brad, step out, shut the door. She's locked in. Or she's attacking you with a knife. Defend yourself by shooting the bitch. How's that for some?
Do you really want to
advocacy?
Turn your back against a person wielding a knife?
Well, that's basically what he testified. He said, I was being attacked with a knife. I thought she was still attacking me with a knife. I decided that I had to end this threat. So I took the risk of being stabbed again by reaching for my weapon. He was fully expecting, according to his testimony, to being stabbed again. And it's a lot easier to reach over, grab your weapon, and go pew, pew, pew than it is to undo your seatbelt, which probably should have been undone anyway, but it wasn't. We have to take it as we see it. To undo your seatbelt, open the car, get out of the car. This isn't like they're in a football stadium. They're like 1 yard, they're like 1 meter away from each other tops. She's already stabbed him with a knife and cut him twice. How long is it going to take her if she's still got the knife to go again? A lot shorter. She's going to be able to do that a lot faster than he's going to be able to get undo his seatbelt, open the door, climb out of the car, and shut the door.
Yeah. Or the prosecution could argue he got stabbed in the hand while trying to whip it away, and then by grabbing it. She might only have held it, but they have to argue it and they have to prove it.
Yep. Momo Shark, but she didn't believe he was an officer and asked bystanders to call for a real cop. That was her mistake. He was a real cop.
Yeah.
I hate to sound so cold, but she fucked around and found out.
Yeah.
He does not have that duty to prove to her satisfaction that he's a real police officer. He's a real police officer. He knows he's a police officer and he has to do his duty. If she doesn't believe him, that's her fault.
And had she lived, she would have had a great case for self-defense. Had she lived.
And again, it can both be self-defense. She could have acted in self-defense to stab him, reasonably believing she was being raped and kidnapped. And he also could have acted in self-defense because she was attacking him with a knife. They can both be able to avail themselves of self-defense. They don't mutually exclude each other.
Yeah, I saw in the chat someone. Oh, Niklas likes metal. Yeah, I thought this gave it away, but I remembered I had it in a ponytail.
At Mr. Enzo, he decided to shoot when he realized he got sliced. Well, yeah, because that's when a deadly attack on his person happened. He wasn't shooting, he wasn't struggling with her until she stabbed him. And then he spent the next 45 seconds trying to subdue her without shooting her, but she continued to resist and be aggressive towards him, so he decided to do that. So yeah, it's not unreasonable to be a police officer in a closed vehicle going, oh, she's stabbing me with a knife. I think I need to neutralize this threat. KKB, badge can be faked, but not plastic IDs. Y'all funny. Well, how many IDs does he have to show to prove to her that he's a police officer? What does he have? You can fake a badge. You can fake the plastic ID. You can fake a uniform. You can fucking fake a police car. So if he would have rolled up in a police car wearing a full uniform with a badge and a plastic ID, where do you draw the line? Where do you go, okay, well, still, prove you're really a cop. He was in the process of proving he was a real cop by calling for backup. If she wouldn't have gone all ratty and started calling for third parties and innocent bystanders to walk by and waited for the other police officer to show up, maybe she would have been satisfied.
And then this argument is, now you have to argue against the actual law.
Right.
That permits this with a plastic ID. But the law is in place, and you have to argue the law in court.
And X Moon says, if someone says they're a cop, they are more than likely carrying a gun. And if they weren't a cop and they were a kidnapper, they likely still have a gun. Tricky Rich says, Legal Vice's Gunsmoke? No, the stinking badges. That's from Blazing Saddles, one of the greatest movies ever.
Which we can't show various portions of because it consists of words we are not allowed to say, even though it is black men saying them.
Words that people don't like to say anymore, even in jest. And let's see, notes on a phone. Oh, this was, can't remember what brought this up. Was it I can't remember, but notes on the phone says this is more of a Wilhelm scream case. Now, if those of you that don't know what the Wilhelm scream is, in every movie, they deliberately put this in almost every movie, just as an homage to Wilhelm, who was the first person to do the Wilhelm scream like 100 years ago. I can't remember when the Wilhelm scream first happened, but I think it was like in the 1930s, like when sound first started coming to movies. They recorded one scream and they started using it over and over and over again in movies. And now it's just a thing. They just put the Wilhelm scream in almost every movie. And once you hear the Wilhelm scream, you can never unhear the Wilhelm scream. So I'm going to ruin everybody's everybody's movie-going experiences. You have heard this, and next time you hear anybody scream in a movie, chances are at least one of them, perhaps several of them, will be, and I hope this works because I can't hear my own sound effects, so I hope it works. This is the Wilhelm scream. Did it work?
Yeah.
Good, yeah. Yep, it worked. So yeah, that is the Wilhelm scream. When guys fall off roofs, fall off cliffs, get shot with arrows, fall down rocks, get run over by horses or cars, or fall out of vehicles. In action movies, you will hear the Wilhelm scream repeatedly. It was 1951 Distant Drums. Thank you, Shlomo. Yeah, I thought it was like the 30s or a little bit earlier than that, but yeah, the Wilhelm scream. Thank you for that suggestion, notes on the phone. We're replacing the fake goat scream with the Wilhelm scream from now on. I've kicked my goat identifying sheep to the curb. We're going to be using the Wilhelm scream from now on. Law Talk with Mike can have his fake goat scream. I'm going full Wilhelm scream from here on out. JSD's says she wanted to be stuffed. Just simple miscommunication with being stuffed with lead and protein. Yikes! No. Shame on you. All right, Wilhelm scream. Joe Paolo, however you want to pronounce that, shot in the leg on her back in turtle position. She was not a lethal threat when shot. Well, where's the evidence she was shot in the leg on her back in a turtle position, as opposed to wildly kicking at him from the back seat while he is trying to effect an arrest against her? That's the thing. This is and this is going to sound really crass and cold, but this is a he said, she said, and she dead case. So it's essentially a he said case. And, we just don't know exactly what happened. Valhalla awaits. A stupid sheep scream. Rest assured, Valhalla, we have now retired the goat scream, and we're just going to go full Wilhelm scream at this point. Lady Autumn Sky says, Jeff, check out my latest video. It's 10 hours of waves, and I invite everyone else who likes waves to check it out at Lady Autumn Sky at Lady Autumn Sky. Well, okay, I shall do so. That sounds like something that I could use to put me to sleep every night when I need to be put to sleep, just like a mad dog.
Be careful with the Wilhelm scream, because I'm checking here that it might be still copyrighted.
Whatever. Come and get me, Wilhelm screamers. That would be hilarious if I woke up tomorrow and said I've had a copyright claim lodged against me for a Wilhelm scream. That would be awesome. I'd actually laugh. Flock says, I'm so curious about Jeff's kid. Like, what is Jeff's boy like? Does he look like Jeff? We've seen Steve's boy. Jeff, we need to meet your kid. Well, he's on the other side of the planet. Perhaps when I go back to the States in August, we'll hang. But see, I haven't told anybody, even my family, that I'm doing this YouTube thing. I'm just kind of waiting until organically somebody picks up on it somehow. I'm just testing to see how this works out. To see if literally how long it takes for someone to notice that I'm doing this, and then word gets out to friends. So like we're going on a year. It'll be a year next month, and there's only been 2 people that I know that have said, "Hey, that's you." One was a girl I knew when she lived down here in Busan, and then I moved up to Seoul, and the other one was a law school friend who works in the district attorney's office in Las Vegas. So when I went to Vegas, we sat down and had a good laugh. No, my sister knows nothing about this. Digger 420. Nobody knows anything, but like literally nobody knows. I'm just kind of waiting for the penny to drop. Someone in my sphere of knowledge to go, wait a minute, is that you? It's just, there's no reason I'm not doing it. I just think it's funny, and I just want to see how long it takes for this to organically grow. Well, all right, we are now here. Apparently there's going to be about 15 minutes left of lunch. I want to play something, and I want to get people's opinions, because I know this has been one thing that people have said. One of the big questions is, or statements is, well, I listened to the video, and that's one that I started out listening to the video going, holy crap. And, that sounds really, really bad. Nicholas is Jeff's son?
That would be physically impossible.
How old are you?
I'm turning 57.
Yeah, that's physically impossible because I'm 53. I'll be 54 in July. So I knew you were very close one way or the other, but your hair is way cooler than mine. My hair gets like really wavy when it gets about collar length. It starts to go like all wavy, and then I get this big weird ass curl in front. So I just said, screw it. I'm shaving. If I had straight hair, this is what I would look like. Just less of it.
This is the curls or the waves are combed out, so because it looks stupid.
The longest I ever had my hair was down to about here. I've got like 2 pictures of it somewhere, but I had to I had to get like a straight permanent. I'd like perm my hair straight because it's like really long, but it's curly, so it doesn't grow. It doesn't look long, so I had to like perm it out, and that just you women that perm your hair all the time, that just destroyed my hair back in college. But yeah, so I shaved my head for 15 years, and then I just thought, we'll let it grow back, and to see what it looks like, and I said, wow, it's all gray now, and there's a lot less of it than there was last time I let it grow out. So I shaved it off again.
Now they claim I'm your older brother. Well, we might be related, but not by choice, if you know what I mean.
Yeah.
Irish heritage,
Yeah.
you know. Yeah.
Well, I this is weird because you can do this. I've traced my lineage way back to old Norway, so yeah.
Now I'm your uncle and Danny's dad. No, I'm there. Me and Danny says I'm older brother.
Yeah.
So yeah, we are
All right,
all
now that
filming
we're-
next season of House of the Dragon. We should do bad takes of that series because it's already horrifically bad.
Well, I disagree. I thought it was pretty decent. Followed the books pretty well. I want to see long hair Jeff. I got pictures somewhere around here. I'll have to dig up some old pictures and see.
Yeah.
All right. Well,
I already shown me without long hair and clean shaven. I won't do that
scary.
again.
Yeah, don't do that again. That was not pleasant. You look just fine the way you are.
Thank you. Thank you. Thank you.
All right, I want to play something here because we all heard the audio. Let's kind of do this. I want to hear if someone has not heard the audio tape. If you haven't heard the audio tape, type like a 1. If you haven't heard or seen the video of this recording, just put a 1 in the chat. And then you're gonna make me go find it. Ugh. Okay, so there's some people that have not heard this.
69.
Yeah, there's always 69, 420, 666, the usuals. Crap. Let's see. I got to find out where this is in the grand scheme of things. Huh. I think they played it on day 1 of the prosecution's case. I think it was day 1. Let's see. So go to Law and Cuck. Uncut.
I can show you clean shaven head and long beard.
You're gonna do that to us. You showed this one too. Yeah, you showed both of them.
That's me about 40 pounds and a decade ago.
1, 2, 3, 4, 5, 6, 7, 8, 9, 0 is not the answer to that. Well, they played the audio during the opening statements, but later they showed the audio synced up with the video. So I can see them showing the video when I just scroll through, but I can't see them playing the audio when I just scroll through the opening statements. I was looking for the video here. All right, we're on Law and Crime because there's a reason I want to do this. Excuse me. Stepmom, sex worker, day 5. We need day 2. Day 2. I think we need day 2. What day is this? Day 1. So this would be day 2 right here. Let me. Stop screen. Share screen. Where we go? Detective Shepard, is that you? All right. So let me pause this and then kind of scroll back through. Is this it? No, this is officer. Yeah, I think it's right at the beginning. Is this it? Yeah, this is it. All right. Now this is really bad audio because law and crime.
And
there's no
so
sound
we
in the
had
right ear.
Custody of the video at that point.
I'm sorry.
And we took the DVR system and we downloaded it. So we had the video.
All right. And what happens is there's some really bad audio you can't really hear while they talk about negotiating a price. Is the blowjob $25 or is it only $20? That kind of thing. And this red box here is. Wait, let me get up here. Excuse me. All right, where are we at here? Enhance. This red box here is an expansion of the red box up here in the upper left corner. So in just a little bit, the car is going to pull in here and stop right here. You can't see anything on this video. You can see her. You can see her throw the handcuffs out the window. You can see him open the door at some point, but what you can't hear very well or clearly at all is the shots being fired, because it so overmodulates the microphone that it cuts the microphone out. There's some clicks that might be the gunshots, but we just don't know.
I'm going to pause it for 10 seconds. Can you describe, and if you need your laser pointer there, can you describe for the jury what it is?
So as you guys saw yesterday, this is the corner of the building where the car was parked. And up here at the top,
oops,
where it says inside laundry, that's about where the camera is located at the top of the building. So what they did is they blocked this off in red, and then they tried to enhance it here to bring it up a little bit, so in hopes that we could see a little bit better.
So when we see this vehicle come into the top part of our screen, into that smaller red box, you're simultaneously going to see it come into the bigger red boxes.
Yes, sir.
Okay, this is them like negotiating the price, and he's flirting with her, and they talk about drugs.
Correct, but the time was off a little bit, if I remember right. No.
Playing at the same time as we're watching, but in a different location.
So yeah, okay, fast forwarding here until they get into the thing. All right, here we go. This is where things.
So here's just the blown up version of this, where the car turns the corner.
Yeah.
So here's where he identifies himself as police. She says, "You're police," and then this is where they start arguing about whether or not he's police. I'm not kidnapping you or anything.
Hold on, let me see it.
Let me see your ID. Any warrant?
No, I'm opening it. Where's your bag?
He explains he doesn't have his badge.
No video. Who I? Oh, I said. I'm cuff just for my safety. I'm not gonna do nothing to you. I'm cuff.
This is where he says, "I'm going to cuff you for my safety. I'm not going to do anything to you. I'm just going to cuff you." And again, she might be thinking, "Who the fuck?" And he might be thinking, "Why isn't she letting me cuff her? I'm a cop." They can both be right.
No, I'm not getting anything. You're getting under arrest. If you don't have any.
That's where he says you are under arrest. He's a actual real police officer, actually really putting her under arrest. She just doesn't accept it.
No, I'm not getting anything. You're being under arrest. If you don't have any warrants, I'll let you go. Okay, well, I'm gonna have to see some other type of ID badge. I just showed you my ID. I don't have my badge on. I'm calling my buddy. Okay? I know how the whole body situation works.
No radio.
As a negative opinion of the time.
And that's where she said, I know how this vice thing works.
I know how the whole body situation works.
I know how this whole vice situation works.
As a negative opinion of the time. So,
Why? Because I don't have my badge. I left on my police shirt.
you don't have the badge, you don't have your walkie-talkie.
Yeah, I do.
You don't have any of that.
Okay.
What is that? There's no major
Complaint.
municipal court.
Vice.
Right, you get that.
Right. So I'm a policeman.
You can give that.
Handcuffs, ID, or what you want.
Stopped at 5 minutes and 38 seconds. Throughout this, at times you can hear some clicking. Were you able to determine what that?
I believe that was when Mr. Mitchell was texting Laura Evans.
And Laura Evans is the other police officer that was in the vicinity. He was texting her, and I can't remember exactly what the text said, but it was something like, she doesn't believe I'm a police officer, come on over here.
And we were able to get phone records from his phone.
Correct. Yes, sir.
Can you help me, please?
Now, this is where there's a guy that's walking behind the car here. This is where he decides to this is where she decides to get the third person involved, the guy that's walking by. And this is where the police officer decides it's time to arrest her. So she's just telling random guy walking by, can you help me, please?
Can you help me, please?
Stopped at 5:47. Can you tell what's going on here?
Right here, you can't see it on here, but here a guy walks past and he's going to throw something in the dumpster. His name is Randall Jackson. So he lived at the time in the building.
You know where he is now?
I have no idea where he's at.
Do you, but again, I guess we'll watch. Had he left the scene before the shooting?
Yes.
No, they don't know where he is.
On the police for me.
I'm the police.
She never back to this whole thing. Call the police for me. He says, I am the police.
I know you're not. And that's supposed to be an indication, I guess. I can get you a lot of trouble doing stuff.
Well, see, now Brad says he later claims she escalated by asking for 911. She kind of did, as far as I'm concerned, because it's her and him. He's texting to have another police officer come to verify he's actually a police officer. And then she gets another person that he has to be careful about, he has to consider, he has to be aware of and monitor. At the same time, he has to take care of her. So it can be seen as an escalation that she involves other parties into their interchange, we'll say. Playing devil's advocate. And John Gary, there's two things. Again, devil's advocate, the bystander believed he was police and just left, or he could be doing the I'm not getting involved in this shit and just walked off.
When he's tracking me and saying he's a police officer and he's not a police officer.
Yes, I am.
He's acting like he's a police officer. And he's not. He has this and a thing act bad. He's having to win. We want to turn about him. We want his money. This is possible to show you a picture of that. They just show you a picture.
See, that's where he says, fuck you. And then he pulls out the cuffs to arrest her. after she's involved a third party. But let's see what happens here. This is the important part. Listen to what goes on here, and then we're going to talk about this in a second.
Don't put your hands on me. Don't put your hands on me. Do not put your hands on me. Do not put your hands on me. Don't put your...
It appears there's some action actually leaving the window of the passenger side there. Was that window down?
It was down maybe about 4 inches or so. 3 or 4 inches.
Your hands on me. Help! Help!
She's got a knife.
Help!
That's where she stabs him.
Help! Help me, please, open the back door, help me! Open the back door! He's coming! Please help me! Please help me!
That's when the door opens. That may have been a shot. Now that's you get off me. He's grabbing for her. Yes, he is grabbing for her. He's trying to put her under arrest. He's trying to subdue her. Now, the reason we're playing that is I want you to listen to some other audio and compare and contrast this. Because I mean, just isolated without kind of thinking, maybe she's trying to get out of this. Maybe she's screaming to embarrass him into releasing her or getting other people involved, that she wants to make other people think he's doing this so they'll get involved. There are other explanations for that, but I want you to listen to this here. I'm not sure how I can bring this up without spoiling it here. Dang, I wish I could just play the audio without actually first adding it to the stream. Shit. I'm gonna have to try to do this as quick as I can. Everybody look away. Everybody don't look over here. Don't look over here. All right, this is a let's see. We need to find out if you can hear this. Just the audio. We don't get distracted by the video. Again, hang on tight here. Where did I just stick that video? There we go. Now I'm going to back to tell me. Can you hear this, Nicholas?
No.
Can you hear that?
No.
Of course not. That would be too easy if you could hear that. Shit.
Yeah. Meanwhile, the prosecution's case rests solely on the officer's credibility. And I don't know how hard they have been arguing against his credibility.
Okay, I know what we can do here. Hang on. We're going to do this, and then we're going to do that. Now you should be able to hear it.
Okay, you know what?
148. You can hear that?
Yeah,
Wait.
I heard that.
Okay, listen to this audio of this arrest.
I'll get out of the vehicle for you. I will get out of the vehicle. I'm kidding, Mama.
All right. Well, you're not free to leave.
You're
going to take the bag
no,
off.
No, I'm
You're
not.
going to take the bag off.
No, I'm not.
Then that's your...
Hey, you're raping me. This is rape. This is rape. This is rape.
Relax.
Okay.
Relax your arms.
It's relaxed.
Stop fighting with
It's
me.
relaxed.
Stop fighting with me. Stop fighting.
All right. I'm not fighting.
Center 2, 5, 6. I got a combative X-ray.
Here, I'm lifting my arm up. I'm lifting my
Leave
arm up.
your arm right
It
there.
hurt. Okay, I told you what I was doing.
This is pain compliance, okay? It's not meant to be comfortable.
This is illegal.
I have your attention.
This is completely illegal. No! Take my bag off!
I can't.
You're not putting me in the car. You can wait till you get superior. You are not taking my bag off. You can hand.
Now, we had that little audio bite there, and I didn't show the video for a reason. This is a little bit of a video. It's much longer than this. This is a sovereign citizen who is just making up bullshit because she doesn't want to get pulled out of a car. This isn't with audio. I mean, with video.
You're raping me. Out of the vehicle for you. I will get out of the vehicle.
And he removes her from the vehicle.
All right. Well, you're not free to leave.
You're
going to take the bag off.
No, I'm
You're
not.
going to take the bag off.
No, I'm not.
You're not sure.
Hey, you're raping me. This is rape. This is rape. This is rape.
Relax.
Okay.
Relax your arms.
Let's relax.
Stop fighting.
See, people are saying it's not the same. What's the difference? You've got both people screaming. She's actually using the R word. They're both screaming. One was made up. Maybe the other one is too. Yeah, we're not going to play that again, so you don't have to worry about deafening your ears. But people are like shocked by her screams. People are always that. If you just hear that, that sounds pretty horrible. But that's just someone who is trying to make a scene so the officer doesn't arrest her. Now this is where I thought so, but now that I listened to it, said the woman in our case is actually afraid for her life. I don't really think so. Because you heard her talking like, can you call the police for me? It's just a cop. He's showing me this dumbass badge. It's not even real. And he's like, yeah, it is. Yeah, it's not real. And then he says, all right, fuck it. I'm arresting you. And then she starts screaming, get off me, when he's actually getting on her to handcuff her inside the vehicle. And again, it's being recorded. It's being recorded. So see, I actually answered this question before. People, when I thought he was guilty, when I thought he would be found guilty, people were saying, well, why would he record himself doing this? And I gave the answer, well, obviously, because if the recording cuts off, it looks bad, or I made some, I can't remember exactly what I said, but it was something sticking for the reason why he would record it. But now you go, well, okay, why wouldn't he if he was just arresting her? And he was already, this is one thing that I thought about. He already texted the other police officer. At the time this shit went down, there was another police officer en route. So if he was going to grape her, why would he text another female officer to come to the scene and know that she is en route, and then he decides to start doing this? That was something I hadn't thought about until just very recently. He had texted another officer to come to the scene, and she was on her way by this point. So that is a big problem for me. People like, got too much booze. Explain that away, though.
Was this
to grape her together? Well, thanks, Flux. You're helping things, Flux. You're not helping. How does she know that? He said he was texting in front of her.
But that was before the other civilian.
Yes.
Okay.
She said, I don't believe you. And so then he texts to bring another police officer to the scene. The other police officer is on the way. And, so there is another police officer that is on her way to the scene to verify he's a cop. And so there we go. That's kind of what I'm thinking now. I'm thinking it doesn't make any sense. Flux says, pissing on. I'll assume you're pissing off Valhalla and not pussing off Valhalla. Wait in 3, 2, 1. Goats and shit are the same animals. It's a government psyop. Brian P says, don't blame her at all for not believing this clown. And she did not believe him at her peril. He, again, this is what I don't understand. Why aren't people understanding this? He has no legal duty to sit there and debate with her about whether or not he is a police officer. That's, from a legal standpoint, there is nothing wrong with what he did as far as trying to effect the arrest. To say you're under arrest and not sitting down and explaining to her and proving to her satisfaction that he's a police officer. He's a police officer. He knows he's a police officer. He's a real police officer, and he put her under arrest. She doesn't comply. He has a legal duty and right to subdue her and put her into handcuffs. Oh, wait. We're arguing jury instructions now. That was sudden.
Oh,
hang on.
Was there no redirect?
Well, maybe they'll get to it before the.
Oh, yeah.
I don't know.
Oh, this is before the jury walks in, so they are. Yeah.
Says the test reason was an objective one, and I think we just need to clarify. I don't think it's necessarily wrong, but the focus is specifically on the moment you use his weapon. Then it says, and in the moment's directed proceedings. So I don't know if we really intended to say. I think the focus is specifically on the moment he used his weapon.
What part of the, you on page 8?
Page 8 at the top.
Okay.
Assuming we all have the same exact one.
I have mine.
Yeah, the focus specifically on the moment he used his weapon, and it says, and in the moment's directed proceeding. I don't want to make it confusing and make the jury think that they're considering the reasonableness of the firing, the decision point at any moment prior. So I thought maybe if we put the words focuses specifically on the moment he used his weapon and considering the circumstances in the moment's directed proceeding.
I think it's fine just the way it is. I mean, both experts have testified that there's a decision to make to use it as force. There's a process, and then weapons fired. I mean, I think that says that there, right?
The moment he used his weapon is what we're looking at, not in the moment's directed proceeding, which is unclear and implies that we.
Well, didn't both experts say?
There was a group chat of the officers that were in the area, and one responded.
He had to have made the decision, and then he goes through the mental process to go get the weapon. Then he, but
right, but the focus isn't on the decision point. That could be 20 seconds earlier in the case. It could be 2 minutes earlier. The point is when you actually put it in force. It's super clear with Mr. Patrick to make sure that that's where we were. That's the problem.
let's wait till we can find it out here. Okay. I think Mr. Patrick said, you know, before he could use it, he should have shot her after she cut him.
Right, but don't when you talk about.
Isn't that preceding the firing of the weapon?
I'm sorry?
Isn't that preceding the firing of the weapon?
Yeah, I'm just asking to clarify that what it says the focus is specifically on the moment. As long as we're talking about, we're not talking about the moment of decision. As long as we clarify the moment of decision as a separate point, that's what I'm concerned about. That's why I think it's a little bit confusing.
She's not talking anywhere near the microphone.
We used last time, other than that minor change on mine. So you can go print them up. We didn't put anything else on the record prior to anything on behalf of the state? We'll get you out here sometime.
All right. Well, they're bringing the jury down. This is the thing. You're right, but she wasn't wrong either for defending herself. We don't know that because she's dead. She can't testify as to what she was feeling or thinking. But I'm willing to give you the benefit of the doubt. And as I've been saying since the dawn of this case, it is possible for both sides to be right. She could have thought maybe she could read. Let's say she did, whether it's reasonable or not. She honestly herself believed he was not a real cop and was defending herself. No problem. But from his point of view, he is also as a legitimate law enforcement officer trying to effect an arrest, he is also able to defend himself against a knife wielding attacker in his vehicle. So this is a shitty outcome. This is a horrible outcome, but that doesn't mean it's illegal. It doesn't mean there was anything wrong.
All rise.
And Brandon Lesko said it good here. The chat is going full tard. Just because it was a bad outcome doesn't mean this is a legal homicide, a legal murder, say it. Don't like the laws, change them. That is a good thing. You can have a shitty outcome with good law or with bad law, but law is the law, policy is the policy. Was he doing what was reasonable? Would a reason was his mindset reasonable? That's all we're looking at here. Boomer Wow says we can hear the strength leaving her body. I don't believe him when he says she was still combative.
You guys are switching seats now.
You don't have to still be combative. That's the problem. It's have you neutralized the threat? We have the saying playing possum, where you lay there and you go, okay. The cop comes to put handcuffs on you and you stab him in the throat again, or you pull a gun and shoot him, or you get up and run away. Just because she is not moving or not fighting back, that does not mean she's complying with the arrest.
Mr. Davis, you're still under oath.
Thank you, Your Honor.
Any further cross?
Yes, thank you, Your Honor.
That is the job of the police. They don't need to negotiate. They're there to enforce the law.
About the last sentence at the top of the page.
Oh, and one last thing before she talks about this last sentence at the top of the page is Trenton. He flashed his ID for 2 seconds and claimed that's proof enough. I don't believe it is. In a criminal arrest, he has no duty to show her his ID for any length of time. For citizen complaints and things like that, they have a duty to identify themselves. But generally speaking, and in most places, in the middle of effecting an arrest for a criminal violation of law, he has no duty whatsoever to show her anything or convince her he is actually a police officer. His job is solely focused on getting her into custody.
Had Detective Mitchell not fired on Donna Castleberry and stopped her, innocent civilians in close proximity might be at risk.
Correct.
You wrote that.
I did.
We've established Donna Castleberry was not getting out of that car, right?
Well, had she inflicted a mortal wound or Detective Mitchell moved off and allowed her to escape, the potential was there. We don't know what she would have done.
Do you take into account inconsistencies in the evidence in coming to your opinions?
I don't know what the deal is with the audio, but let me listen
If
here.
you find inconsistencies, if you find varying statements by witnesses, by the officer, do you take that into account when you write these? If you find your
All right, I'm coming in a little hot.
I do, depending on the who the witness is, proximity to the.
Okay, I've boosted the audio. Let's see how that sounds.
If the officer involved has made conflicting statements, does that comport with the evidence? Yes.
Okay, and then so when there's conflict like that, do you put that in your report, or do you become the decision maker as to what position to take?
Well, it's my opinion based on my review of the evidence. So it's my opinion. I'm the arbiter of what goes into my opinion.
So when there's conflict, you'll choose what you believe and form your opinion from there, correct?
I form an opinion based on my review of the facts and evidence.
You mentioned at the, I think it's the bottom of yours. It might be a little bit different. The paragraph that starts, a threat is a capability to do harm. Do you see that?
That is the last
A
paragraph.
threat is a capability to do harm joined by hostile intent. We use a lot of things to determine someone's intent, don't we?
That is a quote from Thomas Petrowski in that published article in the FBI bulletin. I quote him, but yes.
We use actions, right?
Yes.
To determine intent. We use words, right?
Depending, but yes. As I said before, balanced with the actions.
Sure. Let's move to page 18. And underneath the photograph of the knife, unable to control Castleberry using verbal de-escalation, Detective Mitchell attempted to grab and control, which only led to a serious injury by way of cutting. You see that sentence?
Which only led? That's kind of weird.
Do you consider, fuck you, I'm going to have to handcuff you, de-escalation?
I consider it frustration on the part of the detective. Unfortunately, we would like all police officers all the time to not use profanity and not curse, but you know, I'm not going to tell you that that doesn't happen. As a former chief of police of mine said, it's the language of the street, and sometimes it comes out.
The language shows frustration, anger, things like that, right?
The anger is a subjective emotion. Isn't relevant to the use of force. So examining or saying it was said in anger is irrelevant.
You recognize officers should try to de-escalate, right?
I'm sorry, ma'am?
You recognize officers should try de-escalation, right?
Depending on the circumstances, not all. I mean, the suspect dictates their circumstances, and the officers can't de-escalate a actively attacking or resisting subject.
You talk about it being a sound strategy to slow things down, right?
If at all possible, but once again, the suspect acts, the officer responds. So not all the time can we slow things down. If someone's shooting at you or stabbing you, you can't talk to them out of that or talk them out of that.
But when you're trying to handcuff somebody, you can attempt to slow things down and de-escalate, right?
I think Detective Mitchell did that up to a certain point, and then she was calling out to an occupant of the apartment, and he was attempting to establish control. So at that point, attempting to handcuff was a reasonable thing for him to do.
Calling out to a bystander to call police, you're saying is what caused the escalation.
I'm saying that her behavior began to escalate at that point. He had already identified himself as a police officer. He had already texted back up, and said, I'm calling my buddy or whatever. He had attempted to slow things down at that point, but it was Miss Castleberry that escalated her behavior at that point.
So you're calling, they paused and sat there calmly for a while, right? Until the guy walked by and she yelled out. Would you agree with that?
Until she moved over and began yelling at him, correct?
Till she moved over where?
I think to the window area and called to him. I mean, there was movement.
Leaned in her seat, you're saying? You're not saying she moved within the car.
No. Well, she moved towards the window, I would say.
Inferring that, right? That's
Inferring what? Inferring what, ma'am? I'm sorry.
That's an inference that she had to move over to do that, right?
Well, she called to him, so I guess that's an inference.
I mean, I guess you're inferring when the window went down, she leaned out or something.
Or she was seen moving in the seat.
So she calls out to him and he hasn't handcuffed her yet, right?
No, not at that point.
There was a period of time. It was only when she said, they're showing your picture, you're out here kidnapping, something to that effect, that he says, fuck you, I'm going to have to handcuff you, right?
At some point he says, after her comments, says, fuck you, I'm going to have to handcuff you.
And page 18, you talk about the movement in the seat. What is your understanding?
I'm sorry, can you direct me to which paragraph?
Just in general, the second full paragraph underneath the knife photo, screaming, kicking.
Okay.
Just in general, you're talking about the position. She was in the front seat, right? And then the second paragraph, you talk about his position. So I'm just talking in general about the positions of the parties.
Yes, both started out in the front seat, he behind the wheel in the driver's seat, and she in the passenger seat, yes.
Okay. So what is your understanding of where he was behind the wheel in the driver's seat? During the struggle, what's your understanding of his position?
During the entire encounter, or at
Let's
what
start
point?
from the point after the cut when he indicates there was a struggle.
Well,
What is your understanding that you relied upon in your report of where he was positioned?
he had to be positioned after he was cut to grab her arm, so within touching distance of, either leaning in or where, depending on her position, but within touching distance or holding distance of her arms.
Okay, so he was sitting in his seat, you're saying,
Yes.
right?
Yes,
And you
apparently.
had mentioned that she was in some sort of position on the console, on the dash, I think you called it.
I think the movement described as put her back against the dash or the center of the dash and then pressed her foot on the side of his neck.
Okay, and your understanding of his positioning during that, what do you believe his physical position to have been when she had her foot on his neck?
Holding on to her arms, seat belted in his seat with her foot against his neck.
Okay, very good. And that is based upon his statement, correct?
And the facts and evidence, there was DNA recovered from the bottom of one of her shoes.
Let's talk about that for a minute. DNA, as you know, can come from an arm, a hand, a leg, face, a neck, right? Various parts. And there's transfer DNA, right?
I'm not a DNA expert, but all I can state is that DNA evidence was found on the bottom of her shoe consistent with pressing her foot against his neck.
Also consistent with her kicking at him, right?
I would assume that if she kicked him, made physical contact, that could be possible, yes.
Also consistent with being in a vehicle that was exclusively his and moving around in that vehicle, right?
That part I defer to experts. I'll stay in my lane on that, Counselor.
Okay, then with regard to saying there's evidence on her foot, you can't attribute that to it being from his neck.
I can say it's consistent with his statement and testimony.
It is consistent with a lot of other possibilities as well. Agree?
Once again, I'll stay in my lane. I'm not a DNA expert.
Depends on what other stuff he has in the car.
In your report, you said he was trapped against his headrest. I'm sorry, not in your report. You said it just here a few moments ago that he was in his seat belted in, and you kind of made a motion like the head against the headrest, right?
Well, pressure was being exerted by Miss Castleberry with her foot against his neck while he's holding her arms. That's just once again described by the defendant.
And do you explicitly describe that position in your report somewhere, or just that he was seat belted in his seat with a foot on his neck? Do you ever classify him as trapped in his seat? Let's put it that way.
I can't recall, Counselor, whether it was, I use the term trapped.
And if the evidence would suggest he wasn't, in fact, in his seat, would that change your opinion?
I haven't seen any evidence to the contrary, so a hypothetical, I'm not sure how to answer that question.
Well,
good answer.
If you're wrong on an underlying basis or fact
Your volume is very
that
much
made
up.
up your analysis, it was part
Is
of your
it?
opinion.
Okay.
That has to change the analysis, right? It has to factor into the analysis if you relied on something and then it turns out to be something different. Agree?
I've not heard any evidence contrary, but I haven't listened to Detective Mitchell's testimony.
Exactly. If there were evidence contrary, it could affect what you've relied on as the basis for your opinion, right?
Certainly if things change based on the facts and evidence.
What is the trail of evidence? Is he
Sorry, gotta get to the right
obligated
page
to
here.
prove his
Our pages are a
innocence,
little bit
or does
different.
the prosecution have to prove that thing?
Am I still super loud?
Page 19, I think it's going to
You're
be.
muted.
There's a mention
Yeah, you're a bit
of
better now.
shots. How many shots were fired? How long it took? Are we on the same page here? There's not a title to it. So I
The
don't-
defendant in Ohio at this
Yes,
time
I
had
see
to
that on page
prove
19.
he had the duty of proving he
And
acted
I think you have an
in a
elapsed time
manner
of
that
about 14
that was
seconds
reasonable according to his perception.
for the 6 shots, right?
That's my conclusion. I understand that Agent
Beyond
Loomis,
reasonable doubt, I guess.
said it was less time,
Um,
but that was my conclusion.
More likely than not, more reasonable than
Okay,
not, 51%
Agent
standard.
Loomis?
Oh,
I believe that's the video expert that examined the video.
Okay. You're
Is-
saying he made a determination of the timeline involved here?
That he, what I did was work on the video and the audio, but I acknowledged Detective or Agent Loomis's expertise, and that timeline was reported by your previous expert, Jamie Borden, as 12 seconds, and I believe Mr. Patrick is 11 seconds. So I will submit
13.
13.
So we're going to say a range of 12 to 14 seconds. Fair?
Fair. Mhm.
Great. So 6 shots over the course of approximately 12 to 14 seconds, right?
Correct.
You personally have fired 6 shots in 1.17 seconds, right?
I actually,
Have you?
I've shot faster than that, counselor.
Okay. So an officer can fire off 6 shots in a well-trained officer in a second or fractions or maybe less, according to you,
Maybe,
I guess,
but
right?
Well, experts
Yeah, but
can
under
fire,
uncontrolled.
6 shots in less than a second. But once again, that's
How
different
about we
standards.
slice your hand
My
open from the
tests
top of your
that
thumb
I've
to the
done
ball
was
of your hand and
once
see how
again,
quickly
friendly
you can
aligned to
shoot?
the target, drawing from the holster, or with the pistol out, just timing the time it takes me to cycle the trigger. That's a little bit different than this circumstances where you're firing across your chest, you're moving, you're firing one-handed, and then you change hands and fire with the opposite hand. So all that's going to factor in with time. So that's apples and oranges. You can't compare an average, or when we look at the amount of time it takes for an officer to fire 6 seconds or the potential, we have to examine the totality of the circumstances. In other words, what was the officer doing? Was he wounded? Was he exhausted? Was how close was the target? Was the target moving? All these things factor into the cadence of fire. And here we have a completely different set of circumstances, one that I've never dealt with before.
You're aware that officers firing to save their lives fire rapidly, right?
There is no stopwatch or tape measure at any officer involved shooting. Every single one is different. To say that they fire quickly belies the fact that we have to examine the circumstances. And in these circumstances, it involved, awkward shooting, movement, change of hands, all those things factor in to the cadence of fire.
Mr. Davis, you're aware that Mr. Patrick found this cadence very unusual of more than 150 cases that he's testified in, right?
I don't know what Mr. Patrick has found. I don't know whether he's ever dealt with a shooting
You
of
read
this
his
type in a
report.
vehicle.
Don't talk over each
Sorry, Your Honor, I'm just looking for more direct answers.
Carla will yell at me.
Thank you. That I don't know if Mr. Patrick has ever examined this type of shooting by a plainclothes detective in an unmarked vehicle under these circumstances. I would be highly skeptical, that he had another shooting of this type.
Well, you haven't had one of these either, right?
That's true. As I stated, it's an anomaly.
Mr. Patrick has many, many years of experience being
Blah, blah,
involved in
blah.
reviewing police-involved shootings, right?
So, irrelevant.
I don't doubt Mr. Patrick's expertise or experience. I understand it was about 30 some years with the FBI. Myself, I was involved in law enforcement for 39 years.
Was this like a cop dick measuring contest? Oh, she's Elaine Bretterhoff
And
sighing.
officers must account for each bullet they fire, right? You'd agree with that?
As I stated before,
no,
officers are inherently inaccurate in their shooting, and oftentimes tragedy happens where an errant round causes an inadvertent, unintended injury. So officers are accountable for them, but understanding that they are inherently inaccurate in these types of situations explains that they sometimes miss and sometimes hit innocent bystanders, hostages, a variety of things.
Okay, but they have to account for each bullet they fire. They have to have a reasonable belief they're in danger for each bullet they fire, recognizing it can take time to stop firing. Fair?
Well, they make the decision to shoot. There's an on switch where they make the conscious decision to shoot. They perceive the deadly threat. And then there's an off switch, which is they perceive that the threat is no longer in existence. During that period of time, they can shoot a number of rounds. In this case, it was not that many, comparatively speaking. It was only 6. But officers in these types of situations or in shootings with this type of timeline can frequently empty their entire pistol.
Netflutter, yes, the defendant testified
seconds, right?
on Friday,
Well,
or Thursday or
that,
Friday.
certainly within the amount of time we're talking about here.
And officers are not trained to shoot until their gun goes dry or till it's empty, right?
No, we see back in the revolver days when there were 6 shots, 5 or 6 shots, that officers frequently shot their revolvers empty. And we see that a lot now with modern semi-auto pistols, that officers perceiving a deadly threat continue to shoot and oftentimes shoot to what's called slide lockback or when the pistol is empty. The question is when they made the decision to shoot, based on the totality of the circumstances and their perceptions, was there a deadly threat?
So the training is not shoot to empty your gun unless the circumstances would warrant that, right?
That's correct.
Okay. And you've reviewed the statements in this case, right?
Statements
You have a file. You had the investigative packet, right?
I do, yes.
And are you aware of a statement by Mr. Mitchell that he fired until the gun went dry?
Well, I know that Detective Mitchell's pistol suffered a failure to extract, that an empty casing was not completely ejected from the ejection port. The gun at that point in time was what we call a malfunction, and he could pull the trigger a lot more times. It would never go off until he cleared the malfunction.
But that wasn't my question. Are you
Kinda was.
aware of a statement that he was taught to keep firing until the weapon goes dry?
He was taught that? I'm not aware of that.
And where's the evidence for that?
Page 20.
Well, there's your answer, I guess.
22. I think it's.
Let's skip to the next.
Page
Yeah,
20
okay.
should be
No evidence of that.
some quotes, sympathetic nervous system, and quotes by various authors, right?
Correct.
And then 21, you have additional quotes by an author about ATP and some other energy systems, right?
ATP-PC, which is in these types of incidents, the word is.
I didn't ask, I wasn't asking a question. Is that what you're
Okay.
talking about in these pages? I'm just trying to get to the proper page. You're not an expert on those areas.
Oh, I am, ma'am, yes.
Okay, just not DNA.
Well, actually, I'm an expert.
Amongst other things, I'm not an expert, but if you're asking if I'm an expert about energy systems in these types of situations, I am.
Okay.
Gotcha, bitch.
Page 22, again, a bunch of quotes, various case law, right? And then and page 23.
That was funny.
Several quotes by Mr. Patrick. Is that what your document looks like? I'm trying to get us to the right.
Well, I believe one quote by Mr. Hall and Mr. Patrick, yes.
Okay, I need to figure out where your 22 and 23 begin then.
That's the one approach.
This is starting to get accumulative, returning to the same things over and over again, trying to get that Matlock moment. You're muted.
Oops.
Muted. Yep.
Oops. I was
Two old
trying to
geezers
block dog
on the
snoring.
same stream.
Yeah, he's so boring that the camera dude is just swinging the camera around.
That's a decent neck.
Della Sanders says, I'm sick of this trial. He had no right to do this by himself. Jeff, you have no proof he was just trying to subdue. The only thing the defense has to prove is that he acted reasonably based upon his situation. If he tried to mess with her, couldn't risk having another complaint with his current trial. We know nothing about his other accusations because it hasn't been introduced into evidence in this trial. Again, we have to separate emotions from actual facts being presented for the jury's consideration in this trial. He said he acted in self-defense. He's having this witness testify why what he did was reasonable in self-defense. The state has to prove it wasn't reasonable self-defense. Once he reaches the threshold of 51% more likely than not that a person would find what he did reasonable based on his assumptions, is what was in his here. You have to decide what was in his head and whether what was in his head was reasonable.
Yeah.
See, he believed that she was attacking him and was still a threat to his life, and he did what he did. Was that a reasonable thought in his head? Not whether it was reasonable to some random third-party person. What was on in here in his own head?
You discussed, and we've discussed here, tactical retreat. Just generally, we've talked about tactical retreat.
Yes.
And you've described backing up, making distance, creating space as a tactic, right?
That's correct.
Okay.
And that's a valid answer.
And said that doesn't have any relevance here, in your opinion, right?
Well, in my opinion, but also in your experts' previous writings on that it's irrelevant.
Well, we've established we disagree, Mr. Patrick, and you disagree on that point currently, correct?
Well, reasonable minds can disagree.
And while
that's a reference to Hogue Law.
How Mr. Mitchell did his job that day, whether he had backup, things like that are not relevant to the reasonableness of the shooting, right? We on the same page so far?
Yes, to the application of use of deadly force, whether he was alone or backup was there is irrelevant.
It's irrelevant to the reasonableness of the use of force, but it's not irrelevant to his credibility, right?
Yeah, that's my what?
I'm not sure I follow the line of question.
Sorry, I'm on your team, dude.
Discussing how he performed his job go to his credibility and whether he's a well-trained officer, right?
I don't think credibility can be inferred by tactics. There are so many wide variety of tactics, and tactics are so subjective in nature. One officer may move forward, officer may move to the side. You can't say that credibility lacks because of the tactic they used.
It's a general factor that one could consider in a criminal case, credibility, right?
Trying too hard.
Well, the question is, would a reasonably prudent and well-trained officer in those exact same circumstances have used deadly force at the moment that Detective Mitchell did, not whether.
Now, okay, I'm sorry to pause this in the middle of live testimony, but that right there is literally the only question the jury concerns themselves with. Was, would a reasonable police officer in that exact same situation, under those exact same circumstances, would they have been reasonably, well, I've confused myself here. Would a reasonable officer have done exactly the same thing in exactly the same situation?
Assuming his testimony is correct. So you have the credibility, and would another officer do the same?
And it's only it's greater than 50% threshold. If it's more likely than not that a reasonable police officer in exactly that same situation, in exactly those same circumstances, would have done what he did, then you have to acquit. That is it. That is the standard right here. He just said it. So let's continue. Sorry.
In a criminal case, credibility, right?
Well, the question is, would a reasonably prudent and well-trained officer in those exact same circumstances have used deadly force at the moment that Detective Mitchell did, not whether in light of hindsight based on Monday morning, we can find that they could have, would have, should have done something else. That's not the question. That's the law under Graham v. Connor, the law under State v. White.
And we don't just take the officer's word for it. So it's, if Officer Mitchell had said, Donna Castleberry pulled a gun out of her dress and fired at me 2 times, so I shot her. In light of this evidence, you wouldn't just take his word for that, right?
Well, no, we'd have to have the gun and the gunshots. I mean, the fact is that Donna Castleberry had a knife. She opened it up. She cut the detective. She put her foot against his neck and pressed. She moved erratically. She moved to behind him. It made him fear that his knife was.
He keeps opening up for him, saying
all
these
that
things.
is what we factor.
She had his ID.
If we have facts that the objective evidence does not support, we don't just take the officer's word for it, right?
Come on.
That's different.
No.
I think that was a general
That's a yes
question.
or a no.
I'm sorry, ma'am. Can you ask the question again? I was distracted.
If the objective facts are different than what the officer said, we don't just have to take his word for it, correct? Yes or no?
No, we examine the facts, certainly.
It's an objective independent review. Just because he said it doesn't mean we have to take that as gospel in our analysis, correct?
Ask and answer, sustain.
Come on, prosecutor. Oh, so you're back talking the judge now?
Ooh, bad call.
Dang, she's getting feisty. She's back talking the judge.
Page
But
20.
for the jury, they can only listen to the tape, hear her voice, and
You
say
should
he's
have
guilty.
conclusions.
We don't know how the jury,
There's
the
a few
jury
more
will
quotes, a
think
couple more
about it.
cases, Mr. Patrick's quote. And then section 12, conclusions and opinions. You with me?
I'm in the general area, Counselor. Go ahead and ask your question.
Heading conclusions and opinions. Second paragraph on 8 August 2018. It was August 23rd, right? Not the 8th.
That is a typo.
Okay. I think that appears twice. Your cover page as well.
I'll take your word for it. Yes, it's wrong.
You discuss on, I guess, 2, 3, 4th paragraph under conclusions and opinion that Donna Castleberry committed the elements of soliciting and one that she knew would normally lead to a summons and release unless she had a warrant. You're talking about what Donna knew right there, aren't you?
Based on our previous experience, which we have evidence of, yes.
You're making an inference of what was in Donna's mind and what Donna knew based upon the fact that there was a prior arrest, right?
Well, yes, we have evidence that there was a prior arrest and she had that experience.
So you're talking about what Donna knew. Does that factor in this analysis?
Insofar as we can state that her experience, we can document her experience, but other than that, it has no relevance as to what she did when she feloniously assaulted the detective in this case.
So if we can use it to document her experience, if her experience was officers generally take me to the library where there's a bunch of officers around when they arrest me, we can consider that too?
That was her previous experience. I'll concede that.
So do we consider it or not?
Well, my understanding is that the vice detectives took them to different places, not just one location. They took them to different places based on which side of town they were working. So in that previous incident, it was to the library. I'm not familiar with Columbus, but let's say it was from Yale Street. The library would have been that location. That's fine.
So you don't know what Donna knew that day, right?
I can only read her manifested intent based on her actions.
Well, might her manifested intent and actions been she was scared she was about to get kidnapped?
Objection, Your Honor.
It's a thing.
Is a logical interpretation of her statement, help me, I know who you are, they're showing a picture.
What?
You've been out here kidnapping women.
Objection,
Show,
Your Honor.
Overruled.
Mm.
Question.
I think under these circumstances, especially when we just talked about her experience, that her experience was that she was placed under arrest for the crime of soliciting prior in very similar circumstances. We talked about that earlier. If she had submitted to that lawful arrest, she would have been placed in custody based on her warrants, but that would have been it. She's the one that chose to escalate that simple arrest of soliciting into a felonious assault and created the deadly set of circumstances which led to her demise. Ms. Castleberry did that, not the detective.
Mr. Davis, you put in your report what she knew. There's another interpretation for that, correct?
What she knew when she was arrested prior?
You said she knew this would normally lead to a summons and a release if she didn't have a warrant. So you're talking about what she knew. There's more than one interpretation for what was going on in her mind. Agreed?
I can't read her mind. I was talking about her previous arrest. We know that she was arrested previously.
Go ask a question.
Thank you. You also used the word necessary on page 24, but we agreed.
Where at, Counselor? I'm sorry.
Second, right before
Good
the
doggy
quote
snoring.
by Yuri Patrick and John Hall.
Snore dog.
I
Attempt
want
to
to
stop that
reach
deadly
down
threat
and
would be
just
necessary.
scratch.
You see that?
I'm sorry.
Starts the paragraph of Castleberry chose instead to draw, open, and slash. Do you see that?
Mm-hmm.
The last word, necessary.
Yeah, based on Detective Mitchell's perception of what is necessary. That's
Necessary is
Granby
not the
Connor.
legal.
Don't talk over each other. If you ask a
She's
question-
got problems with shutting the hell up and letting him answer the
Granby
questions she
Connor
asks.
talks about the amount of force the officer finds necessary, not a third party.
Yeah. Who does she think he is?
You
A
said the
streamer?
word necessary. We all agree that's not part of the analysis.
No, it is with the amount of force the officer finds necessary. That's in Graham. But the amount of force in hindsight based on a 2020 review is not how that's factored in Granby Connor.
Right. So using the word necessary here doesn't mean you're changing the standard of review here.
No, it's the amount of force that a reasonably prudent and well-trained officer would have found necessary in the exact same circumstance.
And
She sounds bored.
Yeah, she's going nowhere with this. I don't know what she's searching for.
you would agree the fact that deadly force might be justified at one moment doesn't justify it categorically throughout an encounter, right?
I would agree with that.
Okay. You agree officers can act outside of their training, right?
But violation of their training is not a violation of law.
I didn't ask that. Officers can act outside of training, right?
Oh, they frequently do things that they've not been trained to do, unfortunately.
Officers can violate the law, right?
Yes,
There are bad apples in every profession, right?
in every profession.
Yeah, he can rise his rates after
In
this.
your use of force book, and I'll be clear about what we're talking about, you mention the need for officers to read the reaction of a suspect and determine if they need to dial back the use of force. That concept familiar? Can we start with yes? You recall that?
I'm sorry, I was answering the question, Counselor.
Well, I want to know if you recall it first.
Yes, it's consistent with training I've given and what I wrote in the book, yes.
So officers must reassess, and there's an ebb and a flow regarding the application of force, right?
There's a application of force, and then there is an assessment period or the reading, if possible. Some situations are over in fractions of seconds, and the assessment is only that the suspect is down and no longer a threat in a deadly encounter, for instance. Others are more prolonged, but there's an application. For instance, when the subject is resisting handcuffing and an officer does a knee strike, is the knee strike effective? Does the suspect stop, or do they continue to resist, or do they escalate in their resistance?
When did you look at the weapon involved in this case?
Well, I looked at photographs of the pistol. I've never examined the pistol, in person.
Okay.
Muted.
I keep like having like the anti-snore microphone dampener on. I don't think she cares about the answers to her questions anymore.
No, this is
She's
just
just
a
asking.
word salad. Is she trying to get it to the next day to avoid closing today? Or you have that she doesn't want the day to end with the stills of the knife.
Now, is this something we can all agree on without argument? I love ginger snap cookies. Hell yeah.
I don't know what that is.
You didn't look at the weapon.
Gingerbread cookies, ginger cookies.
In photographs,
yes.
In person, no.
And so fair to say you didn't look at the holster or the knife or the clothing, right?
In photographs, yes. In person, no.
You talked about officers routinely saying, this is what I'm going to do and why. This was on your direct testimony. Officers routinely tell suspects what they're going to, I'm going to cuff you, I'm going to this, I'm going to do these things, right?
When talking about handcuffing, yes, you're under arrest, put your hands behind your back. I'm going to handcuff you for my protection of yours. That's a common saying in law enforcement.
And officers also say things like, show me your hands, hands up, drop the gun, things like that, right?
In different circumstances, yes.
You said on direct that Donna's back was against the dashboard. Defendant was being choked almost to the point of unconsciousness. She continued to resist and not comply with the instructions to submit. What instructions were given during that struggle?
Well, he said that you're under arrest. At that point in time, once he's been cut, it's a different set of circumstances. It's now survival. But I'm going to handcuff you for your protection and for my protection of yours were instructions.
Well, at the time you were you were talking about that very subject in that statement. You were talking about the struggle with him in her seat and her against the dash, and said didn't comply with instructions to submit. Were there instructions to submit during that struggle?
Well, as the struggle began, yes. But once she feloniously assaulted him, then it was, she cut me, she's got a knife, etc.
What was the evidence you rely upon in saying that Mr. Mitchell reassessed? Reassessed before shooting and between his shots. What evidences did you rely upon in making that decision?
Well, his assessment was based, from the time he was cut, and then in that interim period is when she feloniously assaulted him by way of the foot against the neck, and then he made the decision to go for a let go, to go for the pistol. But his assessment was that she was armed with the knife at the point that she went from the front seat to the rear seat, and his statement is that he felt that she might slit his throat from behind.
What from the point he turned and began to fire did you rely on in deciding that he reassessed throughout? You said he reassessed throughout. What's the evidence you relied on?
Well, he's seeing movement by Miss Castleberry. She's attempting to kick him. She's moving from one side to another. Once again, he says he doesn't see the knife, but that doesn't mean the knife's not in her hands. He just said he didn't see it.
You indicated that you don't believe this is a change in circumstances because you said there was no substantial change because Donna was still in touching distance. Right?
Yes. I mean, the vehicle that we're talking about was a smaller four-door sedan, very cramped space in terms of the distance from back seat to front seat. And the entire time she was in the vehicle with the detective, she was within arm's reach.
She had no option to get any further from him than the back seat, right? I'm sorry, I couldn't hear over the call.
Yeah, she's just stalling for time to avoid the pictures being entered. She wants that out of jury.
That an officer just saying I was in fear for my life is not enough to justify a decision to use deadly force, just his statement alone. You have to articulate why, correct?
Well, the facts and evidence are examined as well. For instance, the slash on the detective's hand, that happened, and that was a felonious assault.
The reason we look at this objectively reasonable analysis is we're looking to extract the unreasonable officer, right? The outliers.
Well, it's our responsibility, both the law enforcement investigators, expert witnesses such as myself and Mr. Patrick, to examine these cases and determine if, based on our expertise, our experience, that they're within the law.
And I think we've established you and Mr. Patrick do not agree in this matter, correct?
I don't know what Mr. Patrick testified to. However, I have read his report. I disagree with some fundamental statements in his report.
May I redirect?
Briefly, Your Honor.
Not
May I
briefly.
Thank you, Your Honor.
Show the pictures.
Ms. Pritchard talked to you about your book, Armed Citizen's Guide to Self-Defense, correct?
Correct.
Is this case, Mr. Davis, about a private citizen or is it about a police officer?
It is about a law enforcement officer in the performance of his duty.
Is a citizen ever allowed to use armed defense against a police officer?
No.
Is this case about a citizen's house being burglarized?
No.
I want to talk to you about the standard that Ms. Pritchard has talked to you about and how it relates to the door being open. Do you remember that discussion?
I do, yes.
How do we analyze a deadly use of force incident?
At the moment that it's used based on the totality of the circumstances.
Through the eyes of who, sir?
The officer on scene in their shoes, based on their perceptions and their experiences.
So not standing in Miss Pritchard's shoes?
No, not in my shoes, but we have to project ourselves into Detective Mitchell's shoes at the moment that he used deadly force.
Standing in Andy Mitchell's shoes at the moment he used deadly force, right?
That is correct.
So whose beliefs about the situation are we supposed to take into account when analyzing whether or not a use of deadly force was justified?
Slow it down.
Just trying to be brief. So, whose beliefs about the situation are we supposed to be analyzing when analyzing whether or not a use of deadly force was justified?
The legal standard is the perception of the involved officer.
So if the perception of the involved officer did not believe the door was open, is it reasonable to believe that Donna Castleberry is still an imminent threat to his safety with regards to serious physical harm or death?
Door opened or closed, it's irrelevant. It's based on his perception of the threat of death or serious bodily injury.
So it's still reasonable.
It's still reasonable.
Ms. Pritchard talked to you about shot cadence, about how quickly you can fire a weapon. Have you ever fired a weapon quickly with a sliced hand, Mr. Davis?
No.
Would having your hand sliced affect your ability to rapidly fire quickly?
Potentially, certainly, and especially with the blood flow, et cetera, that would affect the operation of the pistol or revolver or the handgun.
Would having been choked affect your ability to fire quickly?
Yes.
Do you believe that Andy Mitchell's shot cadence is in fact reasonable given the totality of the circumstances in this situation?
In this situation, yes.
Along those same lines, sir, Ms. Pritchard talked to you about giving instructions, right? About giving instructions during an attack, correct?
Verbal orders, et cetera?
Yes,
Yeah.
sir.
Yes.
Can you give verbal orders while you're being choked?
What was that? Re-ask the question.
Thank you.
He needs a safe
Are
word.
you able, is a reasonable officer able to give instructions, to give verbal warnings as he or she is being choked?
The
Couch.
focus of a reasonable officer would be on survival. You're fighting with a
Gross.
subject armed with a knife that's already seriously wounded you and is pressing their foot up against your neck. The focus is on survival, and legal. There is no legal standard for giving verbal directions or orders at that point. The only in the law in Tennessee versus Garner is that verbal orders have to be given before shooting a fleeing felon, if feasible. Those are the only legal standards that I know of in terms of giving verbal orders prior to the use of deadly force.
Do you remember when Ms. Pritchard talked to you about Donna Castleberry potentially surrendering earlier this morning before lunch?
I'm sorry. It seems like a long time ago. I may not, Counselor. I'm not sure of the question.
Did she talk to you about a suspect potentially surrendering?
Yes.
Is it reasonable to believe that after the first shot that Andy Mitchell did not hear any other words Donna Castleberry uttered? Your Honor, I'm asking a yes or no question.
Re-ask the question.
What is it reasonable, Mr. Davis, for Andy Mitchell to believe that he heard or did not hear the shots? I apologize, that he heard or did not hear the words after the first shot was uttered.
Detective Mitchell would have to testify as to what he heard or didn't hear, but under those circumstances, with the effects of stress, as I talked about earlier, and the gunshots, it would be very hard to hear verbalization or comments made by Ms. Castleberry.
You mentioned on cross-examination that Donna Castleberry could have submitted to the arrest before Mitchell made the decision to use deadly force in order to get out of the car, correct?
At any point in that time, she made the decision to cut him, but she could have submitted at any point.
What other way, if any, exists? Does Donna Castleberry have a way out of that vehicle?
What other way? Feloniously assaulting the detective or killing the detective.
Thank you, Mr. Davis. I have nothing further.
Questions as a result of those questions?
No pictures.
Oh, I want to see the pictures of the knife being moved.
Leave everything there. You can take the water, I guess.
Thank you.
Councilman Prost? Off the record.
Oh, no, I want to hear this. Off the record. The judge saying, get up here. We are going off the record.
Well,
yeah.
I hope they rest because I'm done for the day as soon as this witness is off the stand. It's 3:30 a.m. here. I got to be awake in 5 hours at the latest.
Mm. Yeah, in an hour and a half, I'm picking up a girlfriend. So,
Any further witnesses on behalf of the state of Ohio?
Us.
On behalf of the defense.
Your Honor, with the exception of the submission of our exhibits, the defense would rest at this point in time.
Wow. All right.
Ladies and gentlemen, what we're going to do is take a 15-minute break. I have to do some work, so so it'll be about 15 minutes. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you in your presence. It is your duty not to form and express an opinion on the case until it is finally submitted to you. All right.
Go have some tea, Chandler. All right. Well, that's where we're going to wrap this testimony part of it up with them resting. I'm assuming the afternoon they'll probably just go through all of the entering the other bits and pieces of evidence into evidence. But I'll have to see. We'll have to see how we're doing this. How we're going to go through this, and then we'll pick up where we left off. If it's just nothing, well, we'll pick up where we left off tomorrow. Same bat time, same bat channel, but we got a bunch of stuff to get through here before we call it a night. Scrolling up here, it's Trenton. Oh, okay, he flashed his ID. Now this is the thing. You're asking for like citations. It's just a thing. I mean, the closest I could find to satisfy your directive, because this happened years ago, is this little piece. This is as close as I could find for uniformed police officers in Columbus, Ohio in 2014. This was the closest thing I could come up with, was this screen right over here. And this is called "Think You Have a Right to Demand Police Identify Themselves, Look Closer." If we scroll down here on the side, this is Columbus, Ohio. Columbus Police Division Directive 1.45B from 2014. Uniformed sworn police officers shall display their identification card to any person upon request or as soon as safe and practical. That is for uniformed officers. No mention of badges, no mention of anything else. Just display their identification card. Undercover police I would believe would be even more restrictive because they're undercover. But even a uniformed sworn police officer does not have to display his identification card, the one that she didn't believe, to any person upon request or as soon as safe and practical. Once you say the magic words, "I'm placing you under arrest," that is no longer practical for you to be going, "Oh, excuse me while I pull out my ID here." He did her a courtesy of showing her his ID. He didn't have to, but it said that was as soon as safe and it was safe and practical at that point. So I guess you could say he would have had to have done it at that time, assuming that undercover police officers are held to the same liberal standards as a police officer wearing a uniform. So he did what he was supposed to do, according to this. What was in, I think this was 2018, early 2018. I don't know what was in effect by then, but according to this, you have to show your identification card, not your badge, to any person as soon as safe and practical. They asked if he was a police officer. He said yes, as soon as she asked and showed him that ID card. So, and it's just a thing. If you're in the middle of effecting an arrest on someone, you don't really have to identify yourself. That's just kind of a widely common thing. Because you're tackling someone, you're chasing someone down, going, "Here's my ID." After you're arrested, when everything is okay and everything is safe again, then you can show it to them.
Yeah, I believe that the prosecution's more or less only chance is to play only the audio and then claim this cop is lying and then go for credibility, because the witnesses haven't been very good and their cross-examination of the defense witnesses leaves.
Well, Trenton again here says, "Thank you for looking, Vices, but uniformed rules are completely different per the U.S. Supreme Court." As I'm saying, one thing, even this just banshee of a prosecutor has never mentioned that he violated any policy by not doing more. She's harping on every tiny little minor thing that he might have done wrong. Even the prosecution is not accusing him of improperly identifying himself. It was safe to do so before he tried to cuff her, and he did. He showed her the ID before he tried to cuff her. She just didn't believe it. Then she started saying, she starts to get the other third parties involved. And says, "Hey, this guy, he's not a real cop." He's, "Yes, I am. He's just got some fake, stupid little plastic card." And then he said, "All right, that's it. You're under arrest." He showed the identification before he tried to cuff her. She just didn't like it, didn't want to accept it. Trenton, you're grasping at straws here, my friend. She flashed it. I don't think it means, if you listen to the audio, she is looking at it and saying, "This is you? I've seen this picture. You've been accused of picking up other prostitute." She's looking at his ID and looking at his picture. She's looking at it enough to say that, this isn't real. It's not just like, "Here it is." She had a chance to look at it, look at his picture, ask if this is him, and to make comments about it. So anyway, let's move on here. Nicholas Campbell, Nick Campbell. Is there an imminent threat if he steps out of the car waiting for backup while she's locked in the car? Well, not if he steps out of the car, but I would say there's also no imminent threat if he sits in the car waiting for backup while she's locked in the car. There's no imminent threat. That's why he was sitting there doing nothing. And then third guy gets involved. He decides to arrest her. It gets escalated. Let's go, Brandon. I have a new angle to look at this for. Okay, let's hear what this is. Let's go, Brandon. She asks for what, $20? Why would he grape her over that? And yes, you are extremely loud. Well, people have done more for less money, I guess. It's not, I guess graping isn't about the money. See, look, I play devil's advocate for both sides. Let's go, Brandon. Completely agree. He wasn't trying to grape her. Those theories are out there. Well, let me get rid of this. But I only barely support him up to the first. Okay, this is why I flagged this one. I couldn't remember why I flagged this. But I only barely support him up to the first 3 shots. Then it was a slaughter. Question for you, Brad. Of those 6 shots, which ones hit him and in what order were they fired? There were 6 shots fired. She was only hit by 3 of them. Which of those 6 shots hit her, and in which order did they strike her body? The answer is we don't know. I don't know. That's maybe the last 3 were the only ones that hit her. Maybe the first 3 went wild and the last 3 were the ones that hit her. And maybe the 4th shot, which was the first one that hit her, was the one that went through her leg and through her calf and into her thigh, which likely would not stop the threat of bodily harm. And maybe they took the other 2 to end the threat. We just don't know. And that's the problem. That's what I'm saying. The police, the prosecution hasn't proven that it was unreasonable from a reasonably trained officer position in this exact, a well-trained officer, whether or not it was reasonable for them in the same situation, the same conditions, to do the same thing that he did. The state did not prove that was not the case. I think this is a bad prosecution. SJJ, I thought he hadn't got his ID. He had his ID. He didn't have his badge. He was undercover. He said he left it on his other shirt. And again, at that time, it was not the policy of the police to require them to carry their badge when they were undercover. Now they are, I believe. That's what I was led to believe. Timothy Schultz, someone sounds pissed, right? And also Timothy Schultz, thank you again. The thing that's effed up the most is the fact she was kind of trapped in her car. Well, she was. He parked up against the side of this building specifically for that reason. So when he goes to arrest her, she can't just open the door, jump out, and run away. And that's what apparently what the cops did to prevent them from leaving the car. Okay, people, I'll give Jeff $5 more for no reason. Says, let's go, Brandon. That's the best reason of all. The fight is on until the cuffs go on. Ask any police officer until she is in custody. Game on. I agree. And as Kiernoth says here, thank you very much. Branka calls this awful but lawful. 100%. Boomer Wow says Branka is usually right, but nobody's right 100% of the time. This is a self-defense case, not a case on police power. Exactly. There has to be imminence. If she's done fighting, no self-defense. Done fighting and threat neutralized are different. You can be done fighting and playing possum and laying in wait for them to come and get you. Unless it's once you are no longer able to do something by virtue of being dead or in custody or some other neutralization, you're still considered in the fight, as far as I understand things. I'm catching up. Thank you, Vice. Oh, we just did that one. And Kingslayer Damocles, his answer to is a citizen ever allowed to use force against a police officer was no. WTF, if an officer is actively graping someone, he thinks someone isn't allowed to harm an officer. Incredible. No, I think you're reaching for that answer. I don't think that's what he meant at all.
Under normal circumstances,
yeah.
Blah blah blah. Yeah,
I think you're stretching.
If you are in your house and the officers are moving in, it's hard for you to argue that you are allowed to use force against them. And that doesn't really matter if they have a warrant or not. If they identify as police officers, they more or less can do whatever they can, and you can object after the fact.
Hey, if a police officer is actively graping you, yeah, you get to stab them or shoot them. And that's why we're saying she may have, from a reasonable point of view of a reasonable person in her same situation, may have acted reasonably in thinking that that's what he was trying to do. Maybe that was the case, and maybe she was fully justified in attacking him, but that doesn't mean he can't say that he was justified and that any other reasonable police officer in the same situation would have done the same thing. They can both be right and they can both be wrong. That's what the juries are here to decide. And I think that's the cool thing about this case. And it's Trenton says, nothing but love. Thank you for the responses. Now, I just want to say we're having a good spirited debate, and I like this. This is much more fun and much more interesting than the cases where we all sit around and agree and, and just preach to the choir. It needs to calm down even more, though. Are we talking about me? Who are you talking about there, Nick Campbell? Oh, her yelling. Okay. Yeah.
I had a trial the other week, the case against Alan Brown, where he clearly is one of the most despicable people on this planet. But I still try to argue for in his defense that yes, he might be guilty of 99 out of 100, but you have to get him not guilty on the 100 because that he might not have done. That wasn't easy because clearly he was a douchebag. But then that was the 32. That was the 32-second defense opening. So I kind of forced myself to be his defense.
Yeah, I mean, in cases like that where there's just literally no hope, and it's we all go, oh yeah, he's guilty, or oh yeah, there's no way that person's guilty. This is a legitimate disagreement where we're asking the jury to put themselves in the mind of a police officer under these circumstances and decide. We're asking these 12 people to decide if a equally well-trained police officer in the same situation would have acted reasonably in doing the same thing.
Well, I really hope there are not equally trained police officers, because in my opinion, that police officer was
a well-trained officer. Would it be reasonable for a well-trained officer in the same situation, in the same circumstances, to do the same thing? And this was tried a year ago, and the answer was the jury couldn't decide. So I can think that he should be found completely not guilty just based on the facts as presented under my interpretation of the reasonableness standard. And Nicholas can have a completely different view and think, no, this bastard should be hung because it wasn't reasonable what he did. And that's the good thing about this. We can still walk away and
meet on another stream and opposites. Yeah.
There's literally only one person that can answer this question, and that's himself. Everyone else has to put themselves into his seat and interpret his actions through their own filters while trying to see it on the law. And I think, this is a tough case for a juror, and it's even tougher to get a unanimous decision, I think, in a case like this.
Yeah, because he has every incentive to have, for self-preservation, to lie his teeth off. Oh, she was having her foot against my neck. Well, we know he got caught. We don't know how he got caught. So all we have is his story. So the entire case rests on, do you believe this guy? And the prosecution, the only thing they have so far, as I've seen, is the audio. And the audio is disturbing.
Yeah. That's one thing I can't argue with. And again, it's him. It's what's rattling around in his head, what he was thinking, what he was feeling about her actions. Has nothing to do with policy, has nothing to do with identifying himself. It has nothing to do with anything. That is all extraneous information. What matters is what's going on here in his head and his decision to pull that trigger. That 6 times, hit her 3 times under those circumstances. Is that what a well-trained would that be a reasonable behavior for a well-trained officer in the same situation, in the same circumstances as him? So, this is a case that's going to go to the jury, and it could go either way. I'm aggressively defending my point, and you're aggressively defending your points, counter people.
I really wish there was a clearer case, because now we are going into the gut feeling part, but that's not evidence. I think he is a bad cop, but had the prosecution proved it, that's a whole other story.
I think he's a bad cop too. But I'm just, as you said, I'm just going solely on what evidence has been presented to me during this trial. Right. I mean, once you know that he's under federal indictment for kidnapping and forcing hookers into having sexual relations with him in exchange for not charging them. That's accusations. Those are going to have to be proven as well by the federal prosecutors. Now, granted, federal prosecutors win even more than other prosecutors. So it's not looking good for him, but that we're not allowed to talk about that because there's still allegations at this point. He hasn't been convicted of any of that. Whew. Mavia? Where we got here? Where did we go here? Aha, here we are. Imagine being so high that you think you're going to get SA'd in an area with people still walking around over just thinking it's probably a cop.
Yeah, she would have a great case. Yeah.
Now that would be an interesting discussion. Let's say it was the other way around and she took the cop out.
Oh.
And I mean, this is something I don't know the answer to. We have to decide whether in her situation at that point in time, was she reasonably justified in doing what she did? Does that mean we have to factor in what she was thinking as a result of the drugs? I'd say no, because drunk driving and killing somebody while drunk.
Hold on, let's try it.
Yeah. No. Don't do that. He's just kidding, YouTube. Yeah, so I would assume like with alcohol and other things, you can't use your diminished. Well, again, there's all kinds of deception. I don't even want to get down there because I don't know the answer. I think I know what the answer is, but there's always exceptions, so I'm not going to go down there. I'm not going to wander too far afield from things that I know what the hell I'm talking about. We're already kind of right on the borderline. It's an interesting question, though, for someone who does this more than me. They doing jury instructions, no rebuttal. I have to change my description of this because they made it sound like they were going to start this day and everybody's just going to rest and they were going to get into it. So I'm assuming there's going to be some rebuttal, maybe. So I don't know.
Oh. Huh.
But we'll find out tomorrow because I plan on being back here at the same time tomorrow. I don't know if I'm going to start at like 8 a.m. Eastern or the usual 9 a.m. Eastern. I'll have to look and see what they do for this last little bit of trial today. But we'll do something. It'll either be the usual time, 9 a.m. Eastern, which is 2 p.m. UK time, or it'll be an hour earlier than that. I'll let you all know by the time you wake up tomorrow, or hopefully by the time you go to sleep this evening, if you're in the West Coast, or if you're in the United States. But I do need to check out. It is 4 a.m. I got 4 hours to sleep, and then I got a whole day of work ahead. My day sucked ass, Nicholas. It sucked ass hard. It was a bad day, and I want to forget about it. But everybody here, and you were a godsend tonight, my friend, because I was in a pissy mood, and nobody knew about it, and Andrew Brank is off doing his thing and can't join, and nobody else was available, and then just out of the blue, want me to join you, and then I was pleased and happy. So thank you for keeping me company. I talked way too much and didn't let you talk nearly enough, but I was agitated. I apologize. Are you going to be free tomorrow?
I'm on MLS law show tomorrow with Letitia Stouch trial.
Oh, okay.
The woman who ended her son.
Yes.
Trial.
So they didn't have trial today?
Yeah, they did, but I had I had all the plans. Then girlfriend was called into work, and then you needed help, so ta-da.
Well, there you go.
MLS tomorrow, and Branka will probably be free tomorrow for you, so you don't need me.
Now he's done for a few days. He's out and about doing things. But anywho, we'll just have to see what happens tomorrow, guys.
Yeah.
Mods, thank you so much for being super moddy. You guys are great. Chat, thank you for the spirited discussion. We all have our ideas here, and from what I saw today, it was a little bit weird the other day, but from what I saw today, everybody was mostly respectful of each other's opinions and argued points without resorting to calling people names and being offensive or offended. I'm glad we can have a spirited debate and still respect each other's point of view. That's a good thing about this chat.
Oh,
I'm glad we can do that. What?
MG Law says he's happy to keep you company tomorrow. So yeah, you have offers.
Groovin'. That sounds awesome to me. All right. So yes, it's okay to just and I like that. The other day there was a few personal attacks and calling people retards and whatnot. But I didn't see that today. So if there was, I missed it. I thank you guys for being able to do that. You're adults. I love that we know where the lines are and we don't cross it. The judge is back. Yeah, the judge may be back, but I'm not. I'm going to sleep. Thank you all. Thank you, Nicholas.
Yeah, and all of you
to invite me tomorrow.
Yeah. All of you in chat, go over to my channel, subscribe, watch my content. Yeah.
Absolutely. Subscribe to him and like everything he's ever done. Yeah. And watch it. Actually watch it. It's very entertaining.
Thank you.
He's,
yeah.
he's a funny guy.
I'm trying.
Actual Boomer says, I don't. I think you're all dummy heads. Well, thank you very much. And Flux just says, fuck all of you. All right, well, great. This is the classic example of saying don't stick beans up your nose, children. Just jam those beans up there. All right, everybody, I'm going to shut this down before you all act stupid. Thanks, guys. We'll see you tomorrow for day 6. Take care and have a wonderful evening. See you, Nicholas.
See ya.
Bye, dogs. See ya. Oh, wait, I have one thing marked. Is it a super chat? Oh, it's the one we already did. All right, never mind. I'm leaving. Bye.